It's just after 10 o'clock. I hope that's the end of the fire alarm. The inquiry is now open. Before I go any further, I assume everyone can hear me. I can hear my voice reverberating around the room, so I assume everyone can hear me. For the council's perspective, I think that's the time to start the live streaming. Okay, my name is Stephen Normington. I'm a chartered town planner and a chartered surveyor, and I've been appointed by the Secretary of State to hold this inquiry into an appeal made by Cemix UK Operations Limited. The appeal relates to the refusal of planning permission by Hampshire County Council for the proposed extraction of sand and gravel with restoration to grazing land and recreational uses using imported inert restoration materials. Also includes the erection of associated plant and infrastructure and the creation of a new footpath and access onto Hamble Lane. The appeal is located at the former Hamble Harefield, Hamble Lane, Hamble Larice, Hampshire. My role over this inquiry is to carefully consider the evidence provided and to make a decision whether the appeal should be allowed or dismissed. Before we go any further, there are just a couple of housekeeping matters I think we need to deal with. First of all, we've had a fire alarm test. Can the council please advise if there are any other tests, and if there isn't any other tests, what are the evacuation procedures?
Thank you. Good morning. Thank you, sir. There are no other fire drills planned for this week. If the fire drill does go off and there's a continuous alarm, if you can make your way out through the entrance that we've just come through towards main reception, out through the main doors at reception, and then follow the road to the left to the Great Hall. If you follow officers, and there will be a assembly point and marshals to actually take you across there as well. So it's the other side of the high street, so towards the front end of the old bit of the building.
Thank you for that. And can you just advise where the toilet facilities are?
Thank you, sir. Yes, the toilet facilities are out towards the main concourse. So if you go out this door here and then round to your right, you will see them on your left-hand side. So it's the opposite way from the cafe and restaurant, which is up on your left.
Just to avoid any unnecessary interruptions, can I please remind everyone to ensure that mobile phones, email notifications, alerts, and anything else that might be associated with that are silenced while the inquiry is in session. The inquiry will proceed as a face-to-face event and is being live streamed. In a moment, I will explain the arrangements for those interested persons who wish to speak at the inquiry and how they may do that. Firstly, though, I do need to run through some housekeeping and organisational matters. In addition to the live stream, I'm also aware that there are television cameras that's just going to film this opening. Does anybody else intend to undertake any filming or recording of the event other than the live stream? Thank you. That doesn't cause problems, provided it doesn't cause disruptions, but it's helpful to know that there's nobody else intends to do that, and I think that's understandable because we have the live stream. I have produced an inquiry programme that's available on the Council's inquiry web pages. I'm aware that the Council's appeal notification letters and notices also outline how the inquiry documents can be accessed because they are available online. We also have a limited hard set in this room that can be viewed by discussion with the council, which I'll come on to in a moment. But before I go any further, could I just ask the council just to explain how copies of all the core documents, proofs of evidence and inquiry documents can be accessed?
Thank you, sir. So all of the documents associated with the appeal are available on the Appeals tab of the Planning Application website. So when the application was running through, that was the main website that was used. So all of the replication of all the documents, the proofs, the statement of cases, etc. are on that tab alongside the core documents list, which documents all of the documents for the inquiry.
Thank you for that. If anybody is still unsure, then I'll explain in a minute how there is a person who can help you gain access electronically to the documents. And that leads me on to that particular point. The council has kindly provided some administrative assistance to me during the course of the inquiry. The relevant officers, Amy Heath, who sat at the bottom of the council's table. Amy will try to ensure that all documents that are handed up to the inquiry are quickly placed on the inquiry web pages. She'll also be able to answer queries regarding housekeeping, including explaining how the electronic version of the core documents can be accessed. You may see me speaking to Amy during the course of this inquiry, but if there are any housekeeping matters, and it's not procedural matters, it's housekeeping about these premises and accessibility documents, then Amy will be able to assist, and that goes for the Rule 6 party and the appellant as well. So just be aware that Amy's there, she's helping me, but she can also deal with minor queries regarding housekeeping matters in this room. In addition, I do have a colleague from the Planning Inspector present today. You may see me speaking to my colleague during the break or at lunch. However, my colleague has no role in this inquiry, nor any role in my determination of this appeal. But we do have an observer from the Planning Inspectorate here today who will be observing proceedings just for today's session. The inquiry will proceed largely on the basis of the programme, and I'll go through that programme briefly in a moment. If there are any minor changes that are necessary as we proceed through the forthcoming days, I will try to explain these during housekeeping matters at the start of the morning or the start of the afternoon, so we just understand where we're at and if there are any relevant changes that we need to be aware of that may affect any of our programming. I don't think there will be, but nonetheless we'll have that housekeeping check at the start of each session. I'll also do a little check as well to just ensure that the web pages remain up to date. So any inquiry documents that are handed up, I'll do a housekeeping check to ensure that they are up there so that everyone can access them should they so wish to do so. The programme does provide for interested persons to speak this afternoon or on mid-morning on Friday. I'll come on to that in a moment. Throughout the inquiry, I will guide proceedings, inviting particular people to speak at particular time. In general, you should not speak unless you are invited to do so. You're all expected to observe the usual courtesies and respect for the formalities associated with the planning inquiry. I'm sure this won't be the case, but if I consider that the behaviour of a party is not appropriate for some reason, they will be warned, with the ultimate sanction, if deemed necessary, of being able to exclude them from the event. Any such action would only be considered if previous warnings were not heeded. I'm sure that won't be the case, and very rarely does that have to be invoked, but it's just a reminder that we've got a lot of things to go through, so please just be mindful of the inquiry process. Just to advocates, I'm sure you're aware of this, but I'll reiterate it for the benefit of the room anyway. You're reminded in this regard that once cross-examination of a witness has started, they are not permitted to communicate with or discuss evidence with their own advocate, for example, in private or during breaks, until their re-examination has been completed. You're aware of that. Just for the audience, that's a procedural matter. It's just reminding advocates that once the witness started giving evidence, they can't discuss any aspects of their evidence with anyone else during the course of the inquiry until they've completed their re-examination. Just moving on to appearances, although I have a prior notification of the witnesses for each part of the main parties in the Rule 6 party, I will, however, ask the advocates to introduce themselves to the inquiry and their respective witnesses. So first of all, if you could start with the appellant, please. Could you please introduce yourself and your respective witnesses you will be calling during the course of the inquiry?
Good morning, sir. My name is James Strawn, spelt Strachan, S-T-R-A-C-H-A-N. I'm of King's Counsel, and I'm instructed by Mr. Brian Greenwood of Clyde & Co., who sits to my left, and you'll have their details on file, I'm sure. And sir, I'm intending to call 4 witnesses. Dr. Rachel Dewhurst, dealing with hydrology/hydrogeology matters. Mr. Danny de la Haye, dealing with ecology matters. Mr. Ben Howard, dealing with transportation. And Miss Emma Pym, dealing with planning. And you should have proofs and indeed rebuttal proofs from each of those witnesses for the inquiry.
Thank you, Mr. Strawn, and I do apologise for pronouncing your name incorrectly during the case management conference. But yes, I do have those proofs, and I've checked this morning, they are on the inquiry website as well. For the council.
Very good morning, sir. Good morning, everyone. My name is Gwion Lewis. That's Gwion for November, and then Lewis spelt as normal, Lewis. I'm a barrister. I'm King's Counsel. I appear for Hampshire County Council in this matter. I'm instructed by Mr. James Hammond, 3 persons down from me to my right. He is a solicitor at the County Council. And so I intend to call in due course one witness, if that would assist the inquiry, and that is Miss Lisa Kirby Hawkes. That's Hawkes, Hawkes, the person to my right. She is Head of Development Management and Flood and Water Management at the County Council. Great.
Thank you very much indeed. For the Rule 6 party, please.
Good morning, sir. Good morning, everybody. My name is Ben Fullbrook, Fullbrook. I'm a barrister. I'm instructed by Lead A solicitors on behalf of the Rule 6 party in this inquiry, the Hamble Peninsula Defence Group, or the HPDG, and I'll be calling 4 witnesses to give evidence, and those are as follows. Dr. Tony Clothier, who will be giving evidence on hydrology and hydrogeology. Richard Andrews, who will be giving evidence on ecology. Andrew Whittingham, who will be giving evidence on highways matters. And Catherine Else, who will be giving evidence on planning matters. So you should have received proofs of evidence from all of those witnesses, and I'm conscious that Miss Else's proof, for reasons which you'll already be aware of, has arrived and was filed yesterday. But hopefully you've received that, sir.
I do need to remember about that red button. I thought it remained on all the time, but it doesn't seem to be the case. But I've got the hang of it now. Thank you. Yes, I have received those proofs of evidence. I will come on to those right towards the end of my closing submissions, just to make sure that everyone's seen them and they've arrived. So I'll do that check as well, Mr. Fullbrook. Just while we're on with the Rule 6 party, I do recognise that some of your colleagues may be unfamiliar with some of the proceedings of an inquiry. Where I think it's necessary, I will try to explain the reasons for the order of events over the next few days. I wouldn't normally do that, but when we have a Rule 6 party, clearly there are people who are probably unfamiliar, and it might be the first time they've encountered the public inquiry. So I'll try my best to explain why we're doing things at certain times. If there's anything that any of your colleagues are unsure about, Mr. Fullbrook, then please don't hesitate to ask me about procedural matters, of course, and I will try to deal with those and explain why we're doing certain things at certain times. So it's me really saying that if anybody's not so sure why we're doing something, don't hesitate to ask me at the appropriate time.
I'm very grateful for that, sir. Thank you.
Okay, turning now to interested parties who may wish to speak at the inquiry. As mentioned earlier, the inquiry programme provides for the whole of this afternoon and a slot around mid-morning on Friday the 4th of April to be dedicated to those persons who wish to speak to the inquiry, both in objection and, if there are any, in support of the proposed development as well. Whilst it's hoped that most people will speak this afternoon, the Friday session is really a contingency for those who may have difficulty in speaking today. I have a number of interested parties who have already registered to speak. I will go through these now, and the order that I read the names out will be the order that I ask persons to come to the witness table to speak today. So the people that are already pre-registered are Paul Holmes, MP, Donna Jones, who is the Police and Crime Commissioner for Hampshire and the Isle of Wight, Councillor Keith House, Professor Sir Stephen Holgate, Christian Walton, Alex Riding, and I do apologise if I pronounce that wrong. I'm sure I'll be corrected later this afternoon if that is the case. Nick Griffith, and on Friday I have an indication that Sarah Sutcliffe would like to speak, who was unable to speak today. I also have a request from Councillor Brad Baines, I do apologise for that, Brad Baines, to speak when the inquiry resumes in June. The programme does not provide for speaking in June, so the Planning Inspectorate will liaise with Councillor Baines to see if alternative arrangements can be made. But Councillor Baines is the only one who suggested that he'd like to speak later in the inquiry programme, We'll just see how we can accommodate that over the next few days. My assumption is that those persons whose names I've just read out will speak in opposition to the proposed development. I recognise that some of those persons might not be here this morning, so I'll check at the start of this afternoon's session, and before those persons speak, whether or not they are speaking in objection or support of the application. In a moment, I will ask if there's anyone who may not have registered to speak initially, but who knows at this stage that would like to do so. You should note that if you do wish to speak, your name will be listed in my decision letter. Before I take the names of persons who have not pre-registered but do wish to speak, I do need to point out that I have access to copies of all of the representations submitted in this appeal. Therefore, it's not wholly necessary for you to speak or comment on matters that I've already seen or read. We do have a lot of technical evidence to go through over the coming days, and it's not helpful to any parties if we have to repeat matters and hear the same thing over and over again, because invariably we've all read that. Having said that, I don't wish to deny any parties the right to speak, particularly if there's something that they wish to say that I may not have read. For persons who do wish to speak, I need to know whether you are representing anyone or any group. As I mentioned, I will check whether you support or object to the proposed development. When you do speak, you'll be invited to the witness table on my right to present your views. I also need to advise you that I will ask you if you are content for the appellant's advocate, Mr. Strawn, to ask you any questions on what you have said. You don't have to answer questions, but it may reduce the weight that I attach to your comments if you are unable to respond to any questions raised. I will ask for hands up in a moment of those persons who wish to speak. But before I do that, I understand that there are a number of children today present who wish to speak to the inquiry and who do need to get back to the school premises as quickly as possible. So firstly, before I ask the general audience, can I please ask the names of the children who I understand wish to speak to the inquiry this afternoon? Is there somebody from the school who can do that, or is there a spokesperson, or do you want to put your hands up individually? Sorry, can you... Max Breeny. Wait a second, Mr. Breeny. Anyone else? Anna, Lisa, sorry, I didn't quite catch the second name. I'll check your name when you come back to the witness table. Anyone else? Martha Hart. Oliver Fradgley. Is there anyone else? Okay, can you just give me that name again? Thank you. All right, before I take the names of other interested parties, I understand that someone in the audience has got a list already of people who wishes to speak. Could I please have that list, if you wouldn't mind? And I'll read through that list. If your name's not on the list and you do wish to speak, then I'll ask you at the end, when I've read the list out, to please raise your hand.
There will be some duplications for people that have registered.
Okay. Okay, so on this list I have Malcolm Wallace, a local councillor. I've mentioned about Brad Baines, Alex Crawford. Just bear me a second, I just want to recheck my list there. Sorry, you are? It's not on this list as a councillor. I do apologise, Councillor Ward, it wasn't on the list as a councillor, but I've recorded that now. Dr. Thompson, I've already mentioned Professor Steve Nolgate. Vicky Hillman, Christian Walton, Anna Craggs, the business Leslie British Marine, Rob Griffiths I've already mentioned, Lisa Roachford, Rob Hillman, Susie Thompson, Tony Peter, Fred Wales, Glenn Jewell, Stephen Fletcher, Angela Fowler, Stephen Hinton Lever, Kay Linders, and I've got Kilby there as well, so I don't know if that's one person or two people. One person. Lou Clayton, Rebecca Stainforth, Kerry Marchbank, Vix Mansfield, Nick O'Donnell, Bill Blaine, Jenny Austin, and I think I've already got Isabel down, Kelly McGrath, and is it McGrath, Georgie Baker, Katrina Southworth Marty, Ted Ill, Valerie Archibald, Phil Riley, Andy Daniels, and I've just got Brian and Caroline on this list. And Caroline Trimble as well. I do apologise because I just had the first names on my list. And Hayley Richards. Those are the people who have been collated by the community to speak today. Are there anybody else? Is there anybody else who wants to speak whose name I've not read out? If so, can you please raise your hand? There's a lady in the bottom right hand corner. Thank you very much. Anybody else? Okay, so the order that I read those names out is the order that I will deal with the speaking this afternoon. We'll start with those persons who first ready to speak, whose names I read out earlier. We'll then move on to the school children, and then I'll come back to this list in the order that I read the names out on this list. There is a lot to get through this afternoon. I'll come on to when we adjourn for the evening, but just to be aware that we might not be able to get everyone in this afternoon, depending on how long it takes, and therefore we might need to use that continued session on Friday. So perhaps might be helpful if you can just have a think over lunchtime whether there's any persons who would be available on Friday to give their comments rather than today. And the only reason I say that is to just think about keeping numbers manageable today so we can get through as many people as we can today without obviously going on well into the evening, but equally being able to deal with those people who want to speak, who can speak on Friday when there's a session also on Friday to speak as well. So I'm not going to ask you for that now, but if you could just have a think over lunchtime, and I'll go through that list again before we start this afternoon, and I'll just ask if there's anybody else who could perhaps be moved to Friday to speak, just to help numbers manageable. All right. Just bear me one moment. Just one matter that might be helpful to me in the inquiry for those people who do wish to speak. If you are prepared a speaking note, it would be helpful if you could let me have a copy of that, if possible today, if not over the next coming days. You can send that through to the planning case officer, or if that's not something that you're familiar with, then please send it through to the council's admin officer, Amy, or Amy will collect it. It just helps me have a record of what you've said. I will be taking notes, and therefore I hopefully will capture all of the salient points. But sometimes a record of what you said is a helpful aid memoir to myself. So you don't have to do, but if you have a speaking note, you're going to speak that speaking note, it will be helpful if you could let me have a copy of that when you've completed speaking. but again, I'll go through that when you're speaking this afternoon. Those speaking notes I will record as inquiry documents, and I will ensure that they're put on the inquiry website. But just to be aware that I will be making notes in any event. Just moving on to formal notifications of the inquiry, I've seen a copy of the Council's notification letter, site notice and press notice announcing the arrangements of the inquiry and a list of persons to whom it was sent. As mentioned earlier, I have a summary of all the representations submitted to the Council in response to the plan application and those submitted to the Planning Inspector as part of this appeal. I can confirm that I will be taking all of those representations into account in making my decision. Just moving on to the plans that's relevant to this proposal. Can I thank the main parties for confirmation of the agreed plans list? Those relevant plans are referred to in the draft conditions. Can I just ask the Council to confirm that, not now, but just ensure, don't confirm, just ensure there's a copy of that plans list on the inquiry web pages. I'm not going to go through these plans at this stage. I will obviously go through them on Friday. But it's kind of a last chance to just double check between the Council and the appellant that the plans that are now on that plans list are indeed up to date, correct, with the correct drawing numbers on, and any revisions, and they reflect any amended plans or revised plans that might need to be considered from discussions over the next few days. So we have an up-to-date list as I see it now. There might be other things that crop up in the next few days that could have an influence on those plans. Just have a check Thursday night before Friday morning that that plans list is bang up to date with the right revision numbers, so that when we commence our discussions on Friday, we've all got the right plans. Thank you. Just moving on to planning conditions and the planning obligation, we will discuss what conditions should be imposed on this proposal were it to succeed, and those discussions will be held on Friday morning. For those persons not familiar with that process, I need to advise that this is normal practice and should not be taken that I've made my mind up regarding my decision. It does not weaken any objection to the proposal, neither does it strengthen the appellant's case that the appeal should be allowed. Rather, in the event that the appeal were to succeed, any conditions imposed need to have the benefit of discussion. A list of suggested conditions has been produced, and that is available on the inquiry web pages, and that list will form the basis of discussions on Friday morning. I also have a draft planning obligation which seeks to secure contributions and other measures aimed at mitigating the impact of the development proposed. The detail of those provisions will also be discussed on Friday morning, having regard to the civil compliance schedule provided by the Council and related guidance. Just one matter on that planning obligation, that the version that I have doesn't include the plans and drawings referred to in annexes 1 to 5. And I also understand there are continuing discussions between the parties. It's not crucial now, but by the time we adjourn on Thursday evening, I would like the final version of that planning obligation that reflects all the discussions that's currently ongoing this week, because I understand there are discussions ongoing this week, but equally as the copies of those annexes that are referred to in 1 to 5. All I have is a title. I think some of them are plans. In fact, they are plans. So just to be sure that I'm probably looking at yourselves from the appellant's perspective, that by the time we adjourn on Thursday, I need to take away with me that final copy that needs also to go onto the inquiry web pages as well.
So could I just check? Do you want a hard copy on the Thursday or as well? Yes.
A hard copy, please, yep. And obviously an electronic version to go into the core document list. Well, I think it'll be an inquiry document. All right, just moving on to timetable and arrangements. The inquiry is programmed to sit for 6 days. That's Tuesday to Friday this week. We will then adjourn and reconvene on Tuesday the 24th and Wednesday the 25th. Friday afternoon of this week is dedicated to an accompanied site visit. I'll come on to that a little bit later. I've checked this morning and it does appear that the inquiry programme is published on the Council's website, so it is accessible. I think there are 1 or 2 copies floating around the room as well if people are not aware of the programme, but the inquiry programme is published on the website. Other than today, the inquiry will resume each day at 9:30. We'll try to adjourn around 5 o'clock each day if we possibly can. On some days that might be a little earlier or a little later, and it's dependent where we are in the consideration of evidence. Each day we are sitting, we will have a mid-morning break and a mid-afternoon break at an appropriate time in proceedings, which I will announce. We'll also try to take a lunch break of around 45 minutes to 1 hour each day. When I say around, it will be a minimum of 45 minutes, but it might be 45 minutes, but it could be an hour depending on where we are. But we'll always have a lunch break at appropriate time in the proceedings. Hearing all the evidence that we need to do, to go through, within the time that we have available, we'll need the cooperation of all parties. To that end, it would assist greatly if questions put by advocates are clear and focused, and also if the witnesses could respond directly to each question as it's put to them in a focused manner as is possible. And that might be starting with a yes or no, where it's that type of question, and then if necessary going on to qualify the answer. Attempts to evade or reinterpret difficult questions will not help the inquiry, especially if that question has to be repeated. I'm sure you won't do that, but it's a reminder that when you are being cross-examined or asked questions by any other parties, that you do that efficiently, focused, you're clear, and please don't try to reinterpret the question to think you mean it's something else and give an answer on something else, because it doesn't help us. But I'm sure everyone in this room who are involved in the inquiry will be mindful of that. During adjournments, I will try to leave the room as quickly as I possibly can. Sometimes that's not possible in terms of if I need to do something. But I'll try to ensure that I'm not left with one party or another. But just a reminder, I will be speaking to Amy and my colleague who have no role in this decision at all. So it's me saying I'm aware of my need to be impartial. Other than pleasantries, which are fine, I'll try to ensure that I'm not left with one party alone in this room. And I'll try and leave as quickly as possible during breaks and at lunchtime. Something I just need to say about procedure as well. Just explain some procedural matters and then some matters about the conduct of the inquiry. I will be following the procedure set out in what's called, or abbreviated to the 2000 Inquiry Procedure Rules. And that is the Town and Country Planning Appeals, brackets determination by inspectors, close brackets, open brackets, inquiry procedure, close bracket, open bracket, England, close bracket, Rules 2000. You can make your own minds up about that. When I've concluded my opening remarks, I will invite the appellant, then the counsel, followed by the Rule 6 party, to each make a brief opening statement, which should be no longer than around 30 minutes. This will help everyone understand the main arguments that we are going to consider over the next few days, and it will also help us to understand the council's position now in this inquiry. I've asked for copies of each party's opening statement. I'm aware that the Rule 6 party and the appellant has submitted those to the case officer because my machine's pinged up as I've been speaking. I'll come on to that before you start actually, but if you do have hard copies for me, that would be helpful. I don't know if the council's sent theirs yet. It may well be that the case officer has not alerted me, but it sounds like all of those opening statements have been provided to the PINS case officer, so thank you for that. But if you do have a hard copy, that would be helpful to me. Don't worry if you haven't, I'll open it up from our system. Hearing those statements should take us to the lunch break. At around 1:30 today, we will then start to hear from the interested parties. As I mentioned, I'll read that speaking order out again, so you have a rough idea when you will be called. The inquiry will predominantly proceed by the examination of formal evidence from the various witnesses in the order set out in the programme that I issued. The roundtable session dealing with planning conditions and the planning obligation will be a discussion led by myself. I will invite interested persons who have spoken to the inquiry to participate in that roundtable session, should they so wish to do so. Friday, the room will take a slightly different format. So after I've opened the session on Friday morning, we'll go into a kind of a different, more relaxed environment with tables pushed a little bit closer for a discussion on the conditions and the plan obligation. Whether or not the advocates participate in that is entirely a matter for yourselves. I'm not generally expecting you to do so. That's entirely a matter for yourselves, but obviously we will need the relevant witness from the parties to have a discussion about the obligation and the planning conditions. So we'll take a little bit of a more relaxed feel on Friday morning, so it'll be a little bit different, but I will invite people to come participate in this discussion should you so wish to do so. So after today, the programme sets out that tomorrow morning we'll hear evidence on hydrology from Tony Clothier on behalf of the Rule 6 party and from Rachel Dewhurst on behalf of the appellant. Tomorrow afternoon, we will hear evidence on ecology from Richard Andrews on behalf of the Rule 6 party. Thursday morning, we'll commence with ecology evidence from Danny Delahaye on behalf of the appellant, and Thursday afternoon will be dedicated to the consideration of highway matters, and that will start with evidence from Andrew Whittingham on behalf of the Rule 6 party, followed by Ben Howard on behalf of the appellant. Friday morning we'll commence with the roundtable session on the planning obligation and conditions, and that will be followed by the site visit. I'll come back onto the site visit in a few moments. We'll then adjourn on Friday afternoon and reconvene on Tuesday the 24th of June, with that day being dedicated to the consideration of planning evidence and the need for sand and gravel. The morning of that day will commence with evidence from Lisa Kirby-Hawkes on behalf of the council, followed by Catherine Else on behalf of the Rule 6 party, and then in the afternoon we'll hear from Emma Pearman on behalf of the appellant. The inquiry will hopefully conclude on Wednesday the 25th of June with closing statements from the council, followed by the Rule 6 party, and then from the appellant. Copies of your respective closings will need to be sent to John Legg by no later than 9:30 that day, so there's sufficient time for us to have those as inquiry documents before you read them out. In addition, a hard copy of your respective closings will help me, and that would be much appreciated. It's important to bear in mind that closing submissions will form the summary of each of your cases as they stand at the end of proceedings, and therefore must be fully referenced, ideally with footnotes highlighting where the references or evidence relied on can be found. Those persons who have registered to speak and have spoken will have the opportunity to ask questions of the appellant's witness or witnesses at the appropriate time. I will indicate that during the course of discussions. So usually, once the cross-examination of the witnesses occurred, I will invite a couple of questions from people who have registered to speak and have spoken to the relevant witness, should they wish to do so. That's not an opportunity to restate your case. It's not an opportunity to ask questions that's already been asked, nor is it an opportunity to ask further evidence. It's simply an opportunity to ask questions about the evidence that you've heard from that witness. So just bear in mind that when I do offer that opportunity, it's questions only about what you've heard. It's not a rerun of your case, your concerns, or anything introduced that's new. And I will have to close that down procedurally. I can't allow that to happen anyway, so I will close that down. But I will offer you that opportunity at the appropriate time. Just a reminder for the advocates that in the formal presentation of evidence in chief and in cross-examination, it would be helpful if you could give me prior notification of some of the core documents that you might be taking the witness to. That's so that I can have them at hand if possible, because we will be dealing mostly with those electronically. I will need to open the relevant tabs up and make sure I can see all of those tabs as we go through the cross-examination and examination evidence in chief. Just on costs, I will need to hear any application for award of costs before the close of the inquiry. A discussion regarding any application for costs will be the last part of the inquiry programme. Any such application should be made in writing, giving sufficient time for the other parties to prepare any necessary rebuttal, which should also be available in writing. Whether or not a cost application is made, I need to remind the parties that I have the power to initiate an award of costs whether or not any application has been made by one of the participating parties. If I were to do this, it would follow a written process with the relevant party after the appeal decision is issued. Once we've had that discussions on costs, I will then close the inquiry to any further oral submissions. It may well be at that point that further information or submissions may be required that are requested by myself. If that is the case, I will close the inquiry in writing after receipt of such information. In this particular case, I'm only thinking here about whether or not the planning obligation has been completed. Hopefully, given the fact that we're having a discussion on Friday and we've got until June before we close, hopefully that can be completed. But usually that's the only matter that I look for further information after we've closed. But if it's not completed, I'll give it a little bit of time to complete that in case something crops up, that particularly on the last day, that we're not so sure about. After I've got that final copy, I will close the inquiry in writing. Just moving on to the site visit, I've already visited the site. I'm aware of its surroundings and the general traffic conditions on Hamble Lane, including at school closing times. However, for the formal site visit on Friday, the parties have provided me with a detailed itinerary. I'm not so sure that I've seen that on the website, but if it's not on the website, can I please ensure that that itinerary is uploaded, please? In order to keep numbers manageable and ensure that we see what we need to see, in consultation with the parties, I have agreed a limited number of people to formally accompany me on the site visit. I have a list of names of representatives of the council, the Rule 6 party, and the appellant who will accompany me. Given the distances that we may need to cover in the site visit, I've also asked for consideration whether any suitable transport may be necessary for the main parties, the Rule 6 party and myself. I understand that that's been arranged. Can I just ask to confirm that we indeed do have, the itinerary says we do have transport. I just want to be sure that we do have transport.
Yes, you do, sir.
Thank you very much indeed. So there'll be a limited number of people, and I'll go through those names of those people on Thursday evening before we close on Thursday evening, who will accompany me on a minibus to go to the site visit. Other people can attend the site visit, but you'll need to make your own transportation arrangements. I am mindful of numbers and managing that site visit, so it's important just to think about the fact that we're there for a purpose. We need to see things. The Rule 6 party needs to point things out. The appellant needs to point things out. The council needs to point things out to me. So it's just to really say, yes, people can attend, but just be mindful of the fact that it has a purpose to it. And I need to ensure that we can manage a site visit as much as we possibly can. When we do that site visit, it's just a reminder that that's not an opportunity for you to open discussions on your respective cases, nor is it an opportunity to lobby or restate community concerns. The site visit was not a forum for discussion on any aspects of the case, but I do want parties to participate in that and point out features that might be relevant and also respond to any questions that I might have. So it's really me saying, I'm sure you're aware of this anyway, respective advocates, it's really me saying that it is a site visit. It is not part of the inquiry in terms of discussion, and it's not an opportunity to restate your case. And from interested parties, it's not an opportunity to lobby. But it's very important we see things as much as we possibly can. Just on that, I do recognise that this proposal has the potential to raise many emotive issues. However, it's important the site visit is conducted efficiently. Whilst I recognise that there might be a local desire to protest that day, it would not be helpful if it unduly interrupts the site visit and affects our ability to see what we need to see. So I'm aware of the strength of local views regarding this proposal, but I would respectfully ask that during the site visit there is an opportunity for me to see what I need to see, conduct the site visit without obstruction, and that its purpose is fully respected. So it's me really pleading to the community. Yes, you might wish to protest, but just be mindful that we don't cause obstruction to the site visit, because it's very important that we attend that day and deal with it that day, because we don't have another opportunity to do so. So please be mindful of that on Friday afternoon. Just dealing with the main issues, having reviewed all of the evidence and in discussion with the parties in the case management conference, the main issues to consider in this appeal are as follows. The need for the proposed development, with particular regard to the land bank position for sand and gravel, and the need for inert waste disposal in the county. The effect of the proposed development on highway safety and the free flow of traffic, with regard also to whether sufficient information has been provided to ensure compliance with the tests in Regulation 122(2) of the Community Infrastructure Levy Regulations 2010. The effect of the proposed development on the integrity of European sites, with particular regard to hydrology and the displacement of informal recreational use. In addition, consideration will be given to any benefits to be weighed in the overall planning balance, including the implications of not proceeding with the scheme. In dealing with the relevant planning evidence, consideration will need to be given to the relevance of the emerging Hampshire Minerals and Waste Plan, partial update, that's a submission plan July 2024, which was submitted to the Secretary of State on the 29th of July 2024 for independent examination. It's understood that those examination hearings, which I think occurred in this room, have now been completed. But I'm sure at some point we'll get to know from the Council's witness exactly where we are in the process regarding the examination of that particular plan. But we will need to take that into account to some extent during the course of discussions on planning matters in particular. There are numerous matters also raised by interested parties, and that's the representations that people in the audience and others have provided both to the Council during the plan application stage and to the Planning Inspectorate during the course of this appeal. So I'm aware of all of those. Whether any of those are matters dealt with as main issues in the eventual decision will depend whether, in the light of the evidence submitted or at the inquiry, they are determinative in relation to the outcome of the appeal. What that's really saying is that I've identified there some main issues that are the key issues that have been raised by the Council initially and the Rule 6 party, and for which expert witnesses will provide evidence. There are lots of other matters that the community has raised. I will take those into account. Some of those matters might be racked up in the kind of weight that I attach to them as we go through discussions when I refer to those in my decision. So it's really saying that there are main issues, there are key things, but I'm also aware of all the other things that's been raised, which I will take into account. Some of those will be raised and discussed in my decision letter, and whether or not they are determinative as main issues will depend on what I eventually hear and when I complete my final reading of everything that's relevant to this inquiry. I will then decide whether or not they are determinative in relation to the appeal. Just on environmental impact assessment, the plan application was accompanied by an environmental impact assessment, which was periodically updated as the application was considered by the Council. As part of the appeal procedures, the adequacy of the environmental impact assessment has been considered by the Planning Inspectorate. That's not me, that's a separate dedicated team in the Planning Inspectorate of professionals who will deal with those matters. But they found that the environmental statement is adequate for the purpose of compliance with the Town and Country Planning Environmental Impact Assessment Regulations 2015. I think I confirmed that in the case management conference anyway. but it's just to explain in the room that the environmental assessment has been reassessed again following the council's assessment by the planning inspectorate, and it's found to be adequate to meet the requirements of the regulations. Nearly finished. I just want to say something about conduct and expectations of the public inquiry. The public inquiry it has a certain degree of formality attached to it, and the procedure differs markedly from a public meeting. In that regard, it's not a public meeting. It has a formal structured approach to the consideration of evidence. It is thus a quasi-judicial procedure in its structure. You will no doubt hear evidence over the coming days which you will disagree with, but you'll need to be patient listeners. Refrain from interruptions or other expressions of support or disagreement in any form, allowing those who are speaking the opportunity to do so without fear or favour. So it's really me saying you're going to hear things that you will disagree with. I really don't want to hear cheers or support or wherever it might be. It's extremely important, even to the Rule 6 parties case also, the witness has got freedom to speak without interruption, because it's important that we hear what they have to say. You might disagree with it in your own minds, but you need to keep it in your own minds, I'm afraid. So just please be aware of that and respect the formalities of the inquiry. I'm not so sure if I need to say that. I will say that. When we start to hear from the witnesses, I will not permit any interruptions or questions from interested parties during the formal presentation of evidence in chief by the witness or during cross-examination by the advocates. But I mentioned earlier, I will permit some questioning by the witnesses, by those who have taken part in the inquiry, sometime after cross-examination of a witness. But again, I must stress that this must be relevant to the evidence that the witness is concerned with and should not be used to ask questions that have already been asked or make statements. You'll be pleased to know that just about concludes my opening remarks. There just are a couple of housekeeping matters that we need to deal with. First, I did say, I think in the CMC, that all inquiry documents should be submitted before we start today. However, I'm aware that the Rule 6 party has submitted a note related to Table 2 of Mr Whittingham's proof of evidence, providing traffic flow data at 5-year intervals and correspondence relating to the highway mitigation costings. Given the brevity of those documents, they are a couple of pages, I'm minded to accept them as inquiry documents, and there will be inquiry documents 1 and 2, which I've already alerted the council to. But can I just check the appellant's seen those documents? They came in last night.
I have seen them, yes, sir.
Thank you, Mr. Strawn. I'd say I'm not going to speak to them now or do anything else with them. I have them. I will accept them. They are loaded up as inquiry documents, and I accept them on the basis that they are brief and are probably more of an explanation than anything else. But I'm sure we'll address those at the relevant time.
I will, and it's not entirely clear to me what their purpose is, so perhaps I'll wait and find out.
No problem. Thank you. I appreciate that. I don't need to mention to you about the right-hand button on the microphone because you've all done it. But just a reminder for people who do come to speak today, there is a microphone. The console has 2 buttons. You press the right-hand button and the microphone illuminates, the microphone's on. When you finish speaking, please try and turn the microphone off as much as you can. We do have microphone police who will mute your microphone if you don't follow those procedures, so just be aware of it. I'm sure you will. And probably the person who will be contravening that more is myself. That's it regarding my opening announcements. Is there anything else that anybody looking around the interested parties, the advocate and the council, anything that you're not so sure about, or anything that you want to raise about procedural matters or housekeeping that I've not said or I needed to say, or something that's causing you any concern? Mr. Strawn.
Thank you, sir. You did mention a little earlier you would come back to the question of the Rule 6 parties planning proof of evidence. And just to lay down a marker, I have seen it's been submitted, but it came in last night. I haven't been through it yet, and I know we've got some opportunity to respond, but I'm just making it clear now, due to the lateness of this, which is extremely unusual, I will wait to see what's in it.
All right, I'm aware, you are aware obviously the background regarding the relevant planning witness and the reason why we have a new planning witness, and you will be aware of my correspondence regarding my acceptance of that revised planning evidence on the basis that we're not going to consider that as proofs of evidence until June, notwithstanding the fact I recognise there'll be some content in there that's relevant to other matters that we are just going to discuss through the next few days. I accept what you're saying, Mr. Strawn, and I think I did say, and I think everyone said, that these are extraordinary circumstances regarding that planning evidence, but we are where we are, and I think I had to make the judgment call of, do I postpone the inquiry, or do I take into account the fact that we're not going to consider that planning evidence in detail until June, and therefore my view was that it's better in the public interest to keep going with the inquiry. We've got, well, June to consider the evidence in detail, and hopefully you might have a couple of late nights this week, like I will. You can take into account, where necessary, that evidence prior to it being considered in detail in June. I do take your point. It's extraordinary circumstances. There are some unusual reasons why, legal reasons why we have to change the planning witness, but I hope you understand my explanation that I had to make a judgment call in the public interest, really, and proceed with the inquiry.
Yes, sir, I understand that. It's just, for example, I'm going to be delivering an opening statement shortly, with your permission.
Yep.
And of course, I won't. That's not delivered in light of reading that proof if it contains anything of materiality. I'm just really flagging that up.
No, I'm sure you will address those matters in your closing submissions as well, or alert me to the fact where there might be differences during cross-examination between what you said in your opening and indeed what there might be in the Rule 6 parties planning witness proof. So I take on board what you're saying. We are where we are. It's a new situation. It's not ideal, far from ideal, but there are legal reasons why we are where we are, and unfortunately I had to make that judgment call that it was too late, really, and it's only because we've got a little bit of time to go through that again before June that I accepted to carry on. But I understand where you are, and I fully sympathise. And if there are things that have got a contradictory element from what you've said, please flag them up, and I'll obviously record that. Right. Any other questions? Thank you ever so much. It's just about 11 o'clock. I could go into opening submissions, but I think I'm minded to take a break at that point, a comfort break, because you've just probably had enough of me and you don't want to sit down there for the next hour and a half and hear things again. So my computer's just about to tick on to 11 o'clock. So I'm going to take a break there and reconvene at 11:15. It's just a reminder, when I say 11:15, it's 11:15. It's not 11:16, it's 11:15. So at that particular point, I'm going to take a break for a comfort break or anything else that you need to do. Back in this room, and we'll reconvene with the opening statements at 11:15. Thank you very much for your patience, and thank you for your participation this morning. This part of the inquiry will now hear the opening submissions on behalf of the appellant, the council and the Rule 6 party. So we'll start those by inviting Mr. Strawn to give his opening submissions, please. Thank you, Mr. Strawn. We have an electronic copy of that, but I will record the appellant's opening submissions as inquiry document 3. Whenever you're ready, Mr. Strawn.
Thank you very much, sir. This is an appeal which should never have been necessary. The need to resort to such an appeal is emblematic of some of the deep-rooted problems in the planning system that can frustrate and delay crucial development to meet established needs on what is a site long allocated for the development identified in the adopted development plan, and an allocation that's proposed to be carried forward into the emerging development plan. This is a vital proposal to extract critical sand and gravel for the area's mineral needs, and these are essential minerals which are needed to deliver the many forms of development required in the area, be it housing, affordable housing, or the basic infrastructure for sustainable growth. It is literally the essence of the building blocks of a sustainable future. And of course, mineral extraction is by its very nature not footloose. These minerals can only be extracted where they are found. National planning policy could hardly be more emphatic. And I've quoted from paragraph 222 of the National Planning Policy Framework. It is essential that there is a sufficient supply of minerals to provide the infrastructure, buildings, energy and goods that the country needs. Since minerals are a finite natural resource and can only be worked where they are found, best use needs to be made of them to secure their long-term conservation. It's therefore highly surprising that national policy specifically prescribes that when determining planning applications, great weight should be given to the benefits of the mineral extraction to the economy. And where, as here, the appellant is proposing such extraction in a way which, first of all, avoids requiring minerals from, for example, any national park or other designated area, secondly, ensures no unacceptable adverse impacts on the natural and historic environment and human health, thirdly, ensures any unavoidable noise, dust and particle emissions are controlled, mitigated or removed at source and deals appropriately with all noise, and fourthly, provides for restoration and aftercare at the earliest opportunity to be carried out to high environmental standards. Such proposal fully complies both with the development plan and the National Planning Policy Framework. It's therefore difficult to conceive of more sustainable development than this. Extraction of sand and gravel from a site specifically allocated for such development, and extraction at a location closest to where the minerals are needed for use in the immediate surrounding area, so avoiding the inherently unsustainable prospect of importation of such materials from further afield, all this to deliver what the National Planning Policy Framework identifies as essential development for a sustainable future. The refusal of planning permission by Hampshire County Council, the Minerals and Waste Planning Authority, albeit on only limited grounds, we say was not justified. Any outstanding issues of detail could readily have been addressed by obtaining further information, whether it be from Natural England or indeed Hampshire County Council in its capacity as a local highway authority, or through the use of conditions. It's deeply unfortunate that its progress has been delayed. Fortunately, but unsurprisingly, given their nature, the authorities, the mineral waste, I'll call them the NWPAs, 3 reasons for refusal have all been resolved. There is now complete and comprehensive common ground with the MWPA that there are no valid objections that remain and planning permission should be granted. This position is further supported by First of all, Hampshire County Council in its capacity as local highway authority, being satisfied that the development is acceptable in terms of highway safety and impact on the road network. Secondly, Natural England, the government's statutory consultee responsible for the integrity of the national site networks, formerly known as European sites, being satisfied that there will be no adverse effect on the integrity of any of those sites with the secured embedded mitigation measures proposed. And thirdly, Hampshire County Council in its capacity as, I think it should be, lead local flood authority, probably it's got the wrong way around, and the Environment Agency being satisfied there will be no unacceptable flooding effects. Unfortunately, but somewhat inevitably, mineral extraction of this kind is typically opposed by local residents in the area out of concerns over matters like noise, air quality, or traffic impacts. And it is part of human nature that the important intrinsic policy need for extraction to occur in this location and the long-standing allocation for such extraction and the measures in place to avoid unacceptable effects on the local community when considered objectively are overlooked. And that is the case here, as embodied in the participation of the Hamble Peninsula Defence Group, the Rule 6 party, pursuing objections which are not pursued by the MWPA or any other statutory consultee. The appellant has done its utmost to be sympathetic to those concerns, and that has been even where those concerns are not objectively well-founded on empirical assessment of the proposal and the mitigation measures which were included at the outset. So, for example, it has proposed additional limits on movements from HGVs during years 3 to 7 of the operation, taking them down from 144 movements per day to 126 movements per day, and of course restricting HGVs from leaving the site between 0800 and 0845 and 1430 and 1515 during the drop-off and collection times for the Hamble Primary School and Hamble School in light of perceptions from the local community. That is, even though both the number of movements it was originally proposing and the use of an existing road already used by HGVs without such operational hour restrictions would have been acceptable. But it is somewhat inevitable that local opposition still remains. It is ironic that had the NWPA reached the conclusions it has now reached earlier, planning permission would already have been granted in accordance with the planning system. Whilst the HPDG continued to pursue those objections, the determination of this appeal is governed by the plan-led approach, and in accordance with section 38(6) of the 2004 Act, if I abbreviate it, sir, and section 70, subsection 2 of the 1990 Act, the underlying planning application for this development should be determined in accordance with the development plan unless material considerations indicate otherwise. As already noted, the principle of this development is already established by the allocation in the adopted development plan. The site is allocated for such extraction in Policy 20 of the Hampshire Minerals and Waste Plan. And of course, one of the other critical material considerations is the National Planning Policy Framework itself, dealt with above. Far from indicating any determination contrary to that development plan allocation, it provides further emphatic support, and great weight is required to be given for what's proposed by way of sustainable development, where the proposed development impacts are all controlled. Another material consideration is, of course, the emerging plan, but once again, far from indicating any determination contrary to the adopted plan, it also strongly reinforces it. This site is proposed for allocation once again, and it forms part of the MWPA's reserves up to 2035, after which the MWPA will be dependent on having to try and find windfalls to address the need for the planned period up to 2040. So, in circumstances where the NWPA and all statutory consultees have satisfied themselves, apologies for the repetition there in the written text, with the acceptability of what's proposed, there's not just a presumption in favour of granting development as soon as possible, for development that's in accordance with the development plan, but prescribed great weight must be given to that proposal under the National Planning Policy Framework. What then of the initial and now remaining issues or objections that are to be considered at this inquiry in that context? Well, I'll briefly address them at this stage. First of all, need. Bizarrely, in the context of a proposal to release needed sharp sand and gravels from an allocated site in the adopted plan, but also a proposed allocation in the emerging plan, and where development needs are due to increase, not decrease, and the NPPF is clear about the weight to be attached to a proposal of this kind, it appears that HPDG are seeking to question the need for the mineral in question. And just a couple of points about that. First of all, and as a matter of principle, it's worth noting that there is in fact no requirement to demonstrate any such need in this context. This is a proposal to extract a mineral pursuant to the long-standing allocation, where the NPPF emphasises the great weight to be given to such a proposal. So HPDG's apparent attempt to support its objection by reference to an analysis of need is misguided in any event. The proposal would enjoy the policy support of the development plan and the framework, regardless of any question of need. Secondly, but also in any event, it's clearly wrong to suggest that there is no need for this mineral anyway, as addressed in the supporting material for the planning application and now in the evidence of Ms. Pearman, which you'll hear in due course, and the position of the NWPA itself. HCC, the County Council, has in fact a sand and gravel land bank lower than the minimum 7 years identified in paragraph 226F of the National Planning Policy Framework based on its local requirements set in the adopted plan. And whilst the latest local aggregate assessment, or LAA, to use the abbreviations, indicates a land bank of 12 years, that's based on an aggregate provision rate that includes reliance on sites which are inactive. And it's simply not reflective of what the land bank position will be when the proposed site would commence operations, with exports unlikely to be until 2027. By that time, many existing sites will be exhausted of sand and gravel. And this is in a world where development pressures requiring such important minerals, if they are to be realised, will have increased. And given that we are involved in the concept of planning, which means looking to provide for those predicted needs, it's unsurprising that the NWPA itself has rolled forward the allocation of the site in its emerging plan, albeit even then relying upon it and another 3 sites, it's only providing for its needs to 2035, when after that point it will have to rely upon windfalls. So we say that there is no doubt as to the need for extraction from this site, even if there were a requirement to demonstrate such need, which there is not. Third, in addition to the point about need for the NWPA's requirements in that context, we say there's a specific need for this mineral in this locality. There are no other land-won sites close by to serve the urban areas of South Hampshire, where the development pressures will be concentrated, and the ability to provide a sustainable source of sand and gravel to this locality, therefore, is not only addressing a specific need, but doing it in a highly sustainable way. And that's not just in terms of reducing HGV mileage, but also not affecting or relying upon other locations affected by other designations, such as the National Park. There is therefore a powerful case on the need for the use of the appeal site, even though it's unnecessary to demonstrate that under the applicable policy framework that applies to the use of this site. HPDG have also sought to question the potential of availability of inert material for the site's restoration. As a matter of principle, the use of inert material to provide for the restoration of the site is a beneficial aspect of the proposal, ensuring reuse of material so higher up the waste hierarchy in a sustainable way. But as both the appellant and the NWPA address, there is no evidence to suggest that there will be any shortage of such inert material to secure that restoration, and this is clearly incapable of being a valid objection to what's proposed. Turning to traffic and transportation, it is evident that HPG's, I'm going to call them the Rule 6 party, principal remaining source of objection relates to matters concerning traffic and transportation, and in particular, unfounded allegations about traffic safety and concerns expressed about the impact of HGV traffic from use of the site on the road network. This, of course, is commonly expressed concern about any development, but of course also one that's typically raised in respect of mineral extraction, where HGVs export the needed minerals and import the reused inert material. And of course, mineral extraction can only occur where the minerals exist in the ground. However, throughout the evolution of the planning application itself and its determination, the appellant, the NWPA, and Hampshire County Council, in its capacity as the Highway Authority, have conducted extensive and comprehensive analysis of the transportation requirements for the proposal during its temporary existence, and so as to be entirely satisfied as to the safety of what's proposed and the ability to accommodate the proposal on the road network in this location. And it's in light of that extensive work that there is common ground between the appellant, the NWPA, and the Highway Authority on these matters. You will have already seen the transport assessment work that's being carried out, and you'll hear more by way of evidence from Mr. Howard for the appellant as necessary, which explains the result of that work. And although transportation issues are no doubt an emotive issue for the local community, given the experience of congestion on Hamble Lane at peak times, it's unfortunate that much opposition has been prompted against the development based upon misconceptions or misinformation about what is proposed and its effects. In summary, but you'll hear much more detailed evidence in due course, there is simply no basis for suggesting that the proposed access into the site from Hamble Lane to allow the extraction to occur will be unsafe in any way. Indeed, the access has been subject to a road safety audit procedure, and the Highway Authority has satisfied itself of the safety of the access. The fact that there are pedestrians and cyclists that will be able to cross that access, for which specific provision is made, does not create an inherent issue of safety at all. It is, of course, commonplace for such accesses to exist without there being a safety issue. It's been designed for safety. Secondly, there is simply no basis for suggesting that the use of HGVs along Hamble Lane itself and the addition of HGV traffic to serve the site to enable that mineral extraction and restoration to occur would be unsafe either. To the contrary, Hamble Lane is already used by many vehicles and HGV traffic on a daily basis, where the footway and cycleway already exist and serve children and other pedestrian users alike. The annual average daily traffic flows along Hamble Lane are somewhere between 16,000 to 34,000 vehicles per day, with 375 to 800 HGVs using it as well on a daily basis. The addition of the additional HGVs into that existing mix, even at their peak levels of 126 HGVs per day, will not have any material adverse effect on the existing safe operation of the road. To the contrary, the development proposal can only deliver benefits in that regard, both in terms of the identified pedestrian and cycleway improvements that will be funded and secured as agreed with the Highway Authority, but also, of course, in terms of the permissive path that will be created and exists both during operation and then on restoration, which will link up the existing residential and other areas. Both of those benefits will be permanent, lasting beyond the temporary use of the site itself. And third says, as to the concern about congestion and the effect of additional traffic on the road network, the appellant has carried out modelling and testing that uses worst case assumptions in terms of HGV activity, which demonstrate the highway network can accommodate what's proposed without any unacceptable adverse impacts. But of course, where the National Planning Policy Framework only requires refusal where such impacts would be severe in any event. The modelling work by the appellant is extremely robust, where, for example, it models the original 144 HGVs proposed rather than the 126 now secured for years 3 to 7. And both the appellant and the Highway Authority agree that the addition of such HGV traffic can be accommodated and will not result in any such severe impact. In addition, as we've already mentioned, the appellant will deliver the funding for the Highway Authority's pedestrian and cycleway improvements to Hamble Lane. So delivering not just a benefit whilst the site is operational in terms of improved facilities of those kind, benefiting an existing problem, but securing those benefits for the future. And that's in addition to the permissive path and the maintained landscape area linking up the site itself. It is therefore unfortunate that so much vociferous opposition continues to be expressed about the proposal in terms of traffic impacts, with emotive commentary regarding the presence of the Hamble Primary School and Hamble School, where that opposition is not based on an objective analysis of what's proposed. Indeed, it's a particular virtue that the proposed development will enable the extraction of this important mineral from this site in a way which will not have any unacceptable impacts on highway safety or the road network, but will secure long-term benefits to the area. Turning to habitats regulations assessment and hydrology and recreational pressures. Now that the HPGG has withdrawn any objection regarding loss of veteran trees and doesn't put forward any other evidence to support other objections, the other two remaining areas relate to questions concerning the habitats regulation assessment, or indeed other assessments of the proposal in relation to hydrology and hydrogeology, I think their terms are used interchangeably, and recreational pressures in terms of alleged impacts on the national site network, SSIs, or other nature conservation areas, and I'll just refer to them for present purposes as protected sites. Insofar as it may be helpful, I will address the legal framework for HRA, Habitat Regulations Assessment, under the 2017 Conservation of Habitats and Species Regulations in due course, as it's clear that there's considerable misapplication of the requirements and concepts in the remaining points of objection. In relation to hydrology, for example, HPDG seem to ignore the basic principle that the appellant, Natural England, and the Hampshire County Council, the NWPA, were all legitimately satisfied that there are no likely significant effects to the protected sites at all, so no further appropriate assessment was required. And so that's entirely unsurprising, given that the protected sites are simply not dependent on flows of fresh water from the site, so no significant effects could arise to them in any event, even if there were changes in hydrology. But of course, the nature of the embedded mitigation means that no material change to such flows will arise anyway. And in relation to recreational impacts, HPDG seek to rely upon an inherently unreliable and self-serving survey, but where no such survey is required to assess the position in precisely the way the appellant, the NWPA, and Natural England have done, and of course where such surveys will clearly not be anticipated, even if this were a proposal for new housing, which it clearly is not. But in relation to both purported issues, the important initial context is that not only have Hampshire County Council as the competent authority, when they were determining the application, satisfied themselves through the HRA process they undertook that no such adverse effect on the integrity, or indeed any unacceptable adverse effects on sites like the SSIs, of any of the protected sites would occur with the embedded mitigation proposed. And that comprehensive HRA process has been endorsed by Natural England as the relevant statutory consultee. So you are now the competent authority on this appeal, but you will no doubt be aware that it's been established at the highest level of authority, namely the Supreme Court, that not only may you rely upon the views of Natural England, where it's satisfied itself that the proposed development will not have such an adverse effect, but you're entitled to presume no such adverse effects in relation to their assessment, and indeed you'll have to give cogent reasons for disagreeing with them. And I've given you a citation to a case, the case of Morge, involving Hampshire County Council, but that's just incidental, and 2 passages of the speeches to that effect. But indeed, Hampshire County Council's own judgment in its HRA, its own HRA, in reliance upon Natural England's assessment, could only have been challenged on Wednesbury grounds, that's rationality, Wednesbury reasonableness, which would have presented a very high threshold when Natural England had withdrawn its objections. So the reality is that there is simply no basis for suggesting that there will be any adverse effect on the integrity of any protected sites for the reasons given the appellant's shadow HRA, addendum SHRA, the Mineral Planning Authority's own HRA, and Natural England's full consideration of that HRA and its satisfaction as to the absence of such adverse effects with the mitigation proposed, and of course now confirmed in the evidence of Dr. Rachel Dewhurst and Danny LaHaye. In short, as set out above, there is no material change to the hydrology arrangement proposed in consequence of extraction or restoration, having regard to the drainage strategy and the nature of the operations. So there is no effect to the water environment of the protected sites anyway. But even if there were any change to that water environment, it's simply not capable of affecting the protected sites in terms of their designation and features, as they do not depend in any material way for the site and its fresh water. And secondly, so it's simply fanciful to suggest that there would be any material additional recreational pressure on the protected sites as a result of the proposed development taking place, let alone pressure which would adversely affect the integrity of the protected sites. One of the embedded mitigation measures is the creation of the permissive path through a dedicated landscape area through the site, protected from the site operations by bunds, which will be in place at all times during operation. And that will enable people to walk over a length of approximately 2.1 kilometres in a landscape area where dogs can continue to walk off the lead. And so that will not only be a new permissive path designed and managed as such, which doesn't depend upon the current unauthorised use, but it will link up with the extensive areas of existing recreational opportunities that prevail throughout the area. And so no doubt you'll see those on your site visit in due course. And that will then be supplemented by the new meadow area at the restoration stage. Indeed, we say any walk around the various trails available, with of course the Victoria Country Park, immediately demonstrates how absurd it is to suggest that any displacement of activity from the appeal site, even if such displacement were to occur with the permissive path in place, would lead to displacement that adversely affects the integrity of the protected sites, given the full extent of the opportunities available in the area. These remaining objections are therefore, we say, pursued in the face of the objective evidence and the proper application of the HRA principles and Natural England's complete satisfaction as to the absence of any such adverse effects. The attempt to suggest that Natural England's analysis in this respect was somehow affected by resources is as unsubstantiated as it is fanciful and disrespectful. Finally, in relation to other matters, clearly a whole host of other objections have been variously pursued by objectors at various stages, including matters relating to, for example, noise and air quality. Suffice it to say at this stage, so that all relevant matters have been comprehensively assessed in support of the application, demonstrating the absence of material adverse impacts of those kinds. For example, whether noise will be controlled by the use of bunds that form part of the proposal, and comprehensive noise assessments have been carried out demonstrating the acceptability of what's proposed. And these have been accepted by the MWPA and the statutory authorities. We'll refer you to that evidence insofar as it's necessary in due course. So it's simply not possible to touch on all that evidence in support of the proposal in this opening statement, but we will have no hesitation in due course in inviting you to allow this appeal for this much needed extraction to occur, with the consequential restoration of the site that will follow. It's vitally important that such mineral extraction, which ensures no unacceptable adverse impacts, is in fact allowed to take place to deliver the minerals needed for the sustainable growth of the country.
Thank you, Mr. Strawn. That I will record as inquiry document 3. Could I ask Mr. Lewis, please, to, well, first of all, give out a hard copy of
Thank you, sir.
submissions, which I will record as inquiry document 4.
Thank you, sir. Ms. Kirby-Hawkes is circulating some copies. You will see, sir, that the council's printer had some fun printing the document, in that if you go to the rear of the page, it is upside down, but actually it works perfectly well if we just read it in this way, as I do here. But apologies for that. For those that don't have a hard copy, we will of course ensure that this is put on the website. So this is an unusual appeal in that it is no longer resisted by the County Council as relevant planning authority. The County Council originally refused planning permission for the proposal for 3 main reasons, but it has since accepted that these reasons have been overcome by additional information provided by the appellant since it made its appeal. The appellant and the County Council are therefore agreed that planning permission should be granted for the appeal proposal on the basis that it complies with the extant development plan comprised of the County Council's Minerals and Waste Plan and Eastleigh Borough Council's Local Plan. The County Council acknowledges that the proposal is a controversial one. It remains the subject of a high number of objections from local people, including those represented by the Rule 6 party, who have raised concerns on a range of issues. One of the main functions of the public inquiry procedure is to enable local people to raise concerns about development proposals and have them considered seriously by an experienced planning inspector. To this end, the County Council welcomes the opportunities that it will have at this inquiry to explain how it arrived at its final planning judgments on the proposal and to answer any questions remaining. The County Council is answerable to local people for the planning judgments it makes as Minerals and Waste Planning Authority, and it accepts that those raising concerns do so out of genuine concern and a desire to act in the best interests of the community. However, this appeal proposal has not come out of the blue. The site is allocated for mineral extraction in the County Council's adopted Minerals and Waste Plan. It is also included as a proposed site allocation in the emerging partial update to that Minerals and Waste Plan, now at an advanced stage of preparation after examination hearings took place in February of this year. This means that in our plan-led planning system, the principle of developing the site for mineral extraction is long established and highly likely to be carried over into the County Council's updated Minerals and Waste Plan if formally adopted in due course. This does not mean that there is nothing further to scrutinise when a planning application is made, as in the present case, in reliance on the allocation. But it does mean that several years ago, the County Council made the considered planning judgment that a minerals extraction use on the site was realistic and deliverable, that it was likely that the impacts of such a use on the site could be made acceptable, and that these conclusions were endorsed by an independent planning inspector when they scrutinised the soundness of the plan in public examination hearings. In a plan-led system, this is the starting point for considering the current appeal proposal. This starting point also provides important context for the 3 reasons originally identified by the County Council's Regulatory Committee as grounds for refusing the planning application. None of the 3 reasons took issue with the principle of the land use proposed, rather all 3 reasons took issue with the adequacy of the information provided in the planning application on 3 material planning issues, specifically flood risk, impact on the highway network, and effects on air quality. All 3 reasons opened with the words, "on the basis of the information submitted with the planning application," suggesting that the provision of further information ought to enable those reasons to be overcome. The appellant has duly provided further information with its appeal. First, on the issue of flood risk, this reason for refusal was based on a holding objection from the lead local flood authority, or the LLFA, which was supported at the time by Southern Water. After the County Council refused planning permission, the appellant prepared a revised post-restoration drainage scheme and asked the LLFA to consider it. The LLFA was satisfied that this further information, supported by a technical note and relevant plans, was sufficient to address its concerns about the off-site flood risk post-restoration. The county ecologist also confirmed that the revised restoration plan was acceptable, with no unacceptable impacts on the ecology of the site expected due to the minor changes to that restoration plan. The County Council is further satisfied that the changes to restored levels are minimal, such that the revised scheme would not have any material bearing on the conclusions of the appellant's landscape and visual impact assessment. In view of both the LLFA and the Minerals and Waste Planning Authority being satisfied that the information provided overcomes the matters raised in the first reason for refusal, the Planning Authority promptly advised the parties and the Planning Inspectorate that it would not need to defend this reason for refusal at this inquiry. Second, on the issue of impact on the local highway network, the County Council, as Minerals and Waste Planning Authority, was not satisfied when determining the planning application that it had sufficient information about a financial contribution of some £500,000 offered by the appellant for a scheme to improve active travel measures in the vicinity of the site to assess its compliance with the statutory tests in Regulation 122 sub 2 of the Community Infrastructure Levy Regulations of 2010. Specifically, the Planning Authority considered that it needed, amongst other things, more detail on why the proposed financial contribution was required to mitigate the development, and how the costings for each element of the proposed scheme to improve walking and cycle access to Hamble Station had been calculated. The appellant, working in conjunction with the County Council as local highway authority, duly prepared additional information on the proposed mitigation package in response to this request that has enabled the County Council as planning authority to be satisfied that the tests in Regulation 122 sub 2 would be met by the financial contribution in question. The Planning Authority has already explained its rationale for that planning judgment in its proof of evidence, which it can expand upon at the inquiry in due course. Third, on the issue of impact on air quality, the genesis of this third reason for refusal was an unexpected late objection by Natural England to aspects of the Habitats Regulations assessment undertaken by the County Council as competent authority on the proposal. Natural England was concerned that increased air pollution from the proposal could have potential significant effect on sites designed for their designated for their ecological significance, specifically the Solent and Southampton Special Protection Area and Ramsar site, and the Solent and Dorset Coast Special Protection Area. Natural England, as the expert statutory consultee on matters that include Habitats Regulations assessments, advised that it needed further information to determine the significance of these impacts and the scope for mitigation. In the event, Natural England provided further representations on the proposal dated the 25th of September last year, in which it revised its previous opinion that the impacts of the proposal on air quality had not been sufficiently addressed within the HRA. In these subsequent representations, Natural England confirmed that the mitigation measures underpinning the County Council's standing appropriate assessment, dated the 7th of March of last year, if appropriately secured, would be sufficient to enable an adverse effect on the integrity of these sites to be ruled out. In view of Natural England withdrawing its objection to the proposal, the County Council as planning authority was satisfied that its third reason for refusal had also been overcome. The County Council as planning authority is therefore satisfied that there are no remaining planning grounds for dismissing the appeal. As it is agreed between the appellant and the council that the proposal complies with the development plan as a whole, including the allocation of the site for a minerals extraction use, this is not a case where the appellant needs to make a case based on other material considerations that the appeal should be allowed. In accordance with Section 38(6) of the Planning and Compulsory Purchase Act of 2004, read with Section 72 of the Town and Country Planning Act of 1990, the County Council accepts that planning permission should be granted because the proposal complies with the development plan. In view of this position, the County Council will not need to call any witness at the inquiry to defend reasons for refusal that are no longer maintained. However, the County Council has prepared a proof of evidence by Miss Lisa Kirby-Hawkes, the County Council's Head of Development Management and Flood and Water Management, to explain its position, including the history of how and why it reached its final planning judgments on the appeal proposal. The County Council shall be present throughout the inquiry to answer questions as you, sir, see fit, and will provide, of course, a final consolidation of our case in closing submissions at the end of the inquiry. Thank you.
Thank you, Mr. Lewis. And I will record that as inquiry document 4. Mr. Fulbrook, could I invite you to provide opening submissions on behalf of the Rule 6 party? Thank you very so much. Thank you.
Thank you, sir. These are the opening submissions on behalf of the Hampshire Peninsula Defence Group, which is the Rule 6 party in this inquiry. The HPDG is a partnership between Hamble Parish Council and the Hamble Peninsula Residents Group. Both of these organisations, representing a number of local residents, have expressed consistent opposition to the proposed development. They have combined to become a single Rule 6 party to this appeal. As separate entities, during the original application, they had worked together to ensure the communities of Hamble, Netley, Lowford and Bursledon were informed of the application. This led to over 5,000 objections being received by the planning authority. Together they provided 60 responses across a range of subject areas affected by the application. The two groups again worked together to present information to the Regulatory Committee meeting in May 2023. You'll no doubt appreciate, sir, that the enormous commitment that is required from communities to sustain such an effort over such a prolonged period of time, physical, emotional and financial. The application was first received in December 2021. Nearly 3.5 years later, throughout 2 Regulation 25 periods, the Regulatory Committee decision in May 22, and the Regulatory decision in May 2024, that commitment continues. Some background to the site. The site's history and its context help to explain why there is so much opposition to this appeal. The site itself is flat, open, unmanaged land on an elevated plateau. Aerial imagery and mapping shows that it is crisscrossed by a network of paths, which are a testament to its long-standing and extensive use by members of the public. Local residents say that this use commenced at some point in the 1980s, after the former airfield closed, and it has been a feature of the site since that time. A recent survey evidence produced for the HPDG submits that it is extensively used. 659 out of 690 respondents, that's 95%, used it, and of those, the vast majority, 94%, use it at least once a week, with 42% using it 3 times a week. Many use it most days. Respondents explained that they valued the site for its unspoiled, open character and its natural as opposed to manicured or artificial landscape. The HPDG is concerned that the appellant will attempt to portray the local residents who have engaged in this use as trespassers, vandals and even criminals. This would be an unfair and unbecoming characterisation in a context where such use, although admittedly unauthorised, is so long-standing and widespread. Indeed, many newer residents of the area would be totally unaware that this was not public land. Moreover, the Hampshire Minerals and Waste Plan not only acknowledges this use, but specifically lists the desire to maintain and manage existing informal recreational use as a development consideration in respect of this site's allocation. The site is therefore highly valued by residents, and that value is accepted and acknowledged in the development plan. Not only is the site itself valued, but its location also presents a number of challenges, which themselves help to explain the extent of opposition to the proposed development. This is well illustrated by figure 2.3 to Mr. Whittingham's proof of evidence, which I reproduce in the opening submissions. This shows that the site is sandwiched between 2 schools, a railway station, an early years centre and several bus stops serving the local community. It is also surrounded to the south and east and much of the west by residential development up to the boundary. There are business parks and marinas close to the site. Access to the site is provided from Hamble Lane, which is already formally acknowledged by the local planning authority in 2022 to be suffering from serious congestion, as a result of which the County Highway Authority considers that further development along it is inappropriate. It is of course important to acknowledge that the site is allocated for the extraction of sand and gravel in the HMWP, the plan. This must carry weight in the planning balance. However, it should go without saying that an allocation is not a guarantee of planning permission, and the allocation itself identifies a number of development considerations which mirror the concerns being raised by the HPDG and numerous others. Representations from interested parties. A consequence of the contextual matters set out above is that a significant number of interested persons intend to speak against the proposed development during the course of this inquiry. The interested persons do not speak on behalf of the HPDG, and many raise issues and concerns which stray beyond the HPDG's statement of case. This should not somehow be interpreted as undermining the weight that should be given to them. The HPDG does not have the resources to take every point, and nor would it be proportionate for it to do so. It is mindful of its responsibilities as a Rule 6 party and has sought to focus its case on areas which it considers would benefit most from the formal testing of evidence in this inquiry format, and in respect of which it has obtained expert evidence to support its position. The HPDG would wish to point out that its efforts to test the appellant's position have already elicited further and different information from that which was available to the Minerals and Waste Planning Authority at the time of its decision, including further traffic count surveys, an extensive shadow HRA addendum, and an acceptance, for what we say appears to be the first time, that the proposed development will result in changes to spring flow and behaviour. The details of these will all be matters for evidence in due course, but they raise a question as to the robustness of the assessments carried out by the appellant in relation to other matters. For this reason, and as explained in its statement of case, the HPDG would urge you, sir, to give careful consideration, as we're sure you will, to the representations you will hear from local residents and businesses who both know and care a great deal about the local area. Now to the case for the HPDG. The HPDG's case to this inquiry is set out below in the order in which the evidence is to be heard. The HPDG recognises that these matters did not form the basis of the Council's reasons for refusing this application, but this does not mean that they are incorrect. They arise out of the concerns of local parish councillors and residents who have carefully scrutinised the proposed development over a long period, and they are endorsed by professional experts. So the first is that there remains reasonable scientific doubt that the proposed development will have an adverse effect on the integrity of European sites. It's important to understand the legal context of this issue. A competent authority may not grant planning permission for any development which has been assessed as being likely to have an adverse effect on the integrity of a European site, unless there are imperative reasons of overarching public interest. The standard of proof which an applicant must satisfy in this regard is as strict as they come. It is equivalent to the criminal standard of proof. The courts have confirmed that planning permission may only be granted if the competent authority is certain that the development will not adversely affect the integrity of a European site. This means that there must be no reasonable scientific doubt about the absence of such effect. This conclusion must be reached following an appropriate assessment of the impact of the development. That assessment must be based on the best scientific knowledge in the field. That knowledge must be up to date and not merely an expert's bare assertion. It cannot have lacuna or gaps and must contain complete, precise and definitive findings and conclusions capable of removing all reasonable scientific doubt. This is no small task, and the burden of satisfying it rests with the appellant. It does not rest with the HPDG or any other party. The HPDG's experts, Dr. Clothier and Mr. Andrews, have raised scientific doubts about the absence of effects on the integrity of the nearby European sites. In respect of hydrogeology and hydrology, they note that the river terrace deposits on the site currently serve as an aquifer, feeding spring-fed streams that connect directly with the European sites. The removal of the deposits will affect the seasonal flow of these springs, which could adversely affect habitats and species which depend on them. The appellant has never measured the flows into these springs nor carried out any assessment of the habitats and species that they support. That is an obvious lacuna, and the appellant's total rejection of even the possibility of adverse effect is, we say, based on unevidenced assumptions. In respect of recreational displacement, it has been consistently acknowledged by both the appellant and the council that the proposed development will lead to the displacement of existing recreational use of the site, and that although this use is unauthorised, it will nevertheless amount to a likely significant effect of this development requiring assessment. However, there has never been any attempt by them to survey the current use or to establish where users might go. Rather, the HRA discounts this risk on the basis of an express assumption that people will prefer to use routes immediately available to the area rather than move to coastal areas in or close to the European sites, which are close to residences and which are at acknowledged risk of harm from recreational pressure. Survey evidence produced on behalf of the Parish Council and latterly on behalf of the HPDG demonstrates that this is not the case. In the end, the inspector might, sir, you may not agree that there will definitely be the effects that are alleged above. You might even think that those effects are unlikely, but that is not enough. The law is clear, sir, that if you have any reasonable doubts about either of those issues, you must refuse permission. Highways impacts. It is the HPDG's case, in reliance upon the evidence of Mr Whittingham, that the proposed development will have an unacceptable impact on highway safety. It will add a significant number of HGV movements to an already congested road, and the site access will require those HGVs to cross a shared cycle and pedestrian path which is frequently used by children travelling to and from school. Concerns raised about this in the road safety audit did not lead to any changes to the scheme, and the audit did not rule out a risk. The cumulative impact of the proposed development on the road network will be severe. Even on the basis of the appellant's own modelling, delays at key junction arms would be exacerbated to levels comparable with those deemed severe by the inspector in the GE aviation appeal. That modelling itself is based on 2022 traffic levels and is an underestimate of the current situation. The mitigation which is relied upon both by the County Highways Authority and the Minerals and Waste Planning Authority to address the highways impacts that both of these authorities accepted is not feasible and cannot be delivered by the financial contribution which has been secured. Nor in any event has any attempt been made to quantify the beneficial effect of delivering improvements to pedestrian and cycle routes on existing and future traffic levels. And third, just briefly on the Southern Water objection. You'll recall from our statement of case that the HPDG was concerned and remains concerned that although the lead local flood authority now appear satisfied with the proposed mitigations on flood and water runoff, the close proximity of houses to the east of the quarry site continues to present significant concerns to residents and businesses. The HPDG notes the concerns raised by Southern Water in their objection, namely that the design of drainage by the applicant should ensure that no groundwater or surface water flows are to enter a public or foul combined sewer, either through direct discharge or through overland runoff. Clearly, this concern directly affects residents and their houses, as before water enters the sewers, it will necessarily have passed through houses and gardens. The HPDG is concerned that no reference has been made to Southern Water, either by the appellants, their representatives, or by the lead local flood authority in reaching their current conclusions. The HPDG considers this to be a significant oversight. As explained in its statement of case, the HPDG does not intend to call any evidence of its own in relation to this issue. Rather, it wishes simply to highlight the matter to you, sir, so that you can ensure it is addressed to your satisfaction. In conclusion, so if you accept the HPDG's case in relation to ecology, then this appeal must be dismissed. There's no need for any planning balance in these circumstances. If the HPDG's case on ecology is not accepted, then you will have to conduct a planning balance exercise pursuant to section 38.6 of the Planning Compulsory Purchase Act 2004. This will need to balance the highway harms against the benefits of the proposed development and will require consideration of the weight to be given to the need for the minerals which it will provide. The extent of this need and the supply of fill material required to restore the site are matters of dispute between the parties. The HPDG's position, in reliance upon the evidence of Miss Catherine Else, is that the planning balance would clearly favour refusal in these circumstances. Therefore, for all of these reasons, the HPDG respectfully submits that this appeal should in due course be dismissed. Thank you, sir.
Thank you very much, Mr Fulbrook. That will be inquiry document 5 for inclusion on the website. Thank you. That concludes the opening submission on behalf of the parties this morning. At that point, we'll now take a break. We'll adjourn the inquiry. We'll reconvene at 1:25. That gives me 5 minutes before the 1:30 start to just go through the list and the order so people have an idea when they will be called. The thing that I said this morning is to just have a think about whether any speakers could possibly postpone speaking today to Friday. That would help us get through the number that's on our agenda today or this afternoon. You don't have to do if you can't possibly make it, but it would greatly assist timing if there are any people who know they're going to be here on Friday and therefore could speak on Friday. So that's all I think that we need to say this morning. That's the first part of the programme complete. We'll break now. It's now 12:10. I know it seems a long lunch, but we've already articulated on that programme a 1:30 start, and I'm aware that people are intending to arrive for 1:30 this afternoon. So I can't bring, really, to be reasonable to all people concerned, bring that programme any further forward than 1:25. So it's now 12:10. The inquiry is adjourned. We'll reconvene back in this room at 1:25. Thank you. I'm going to go through the list in a second. To be reasonable to everybody concerned, we're going to have to cut off at 5:30. So we'll need to see where we are at that particular time. I did ask for people just to have a think as to whether or not there's some people who could move speaking from today to Friday to make numbers manageable. I'm going to ask if there's anyone else, but we have a couple of people who will be doing that. Councillor Keith House has indicated that he can attend on Friday. Donna Jones, who's a crime commissioner, was going to speak this afternoon, but we've had a phone call over lunchtime to say that she can't make it until Friday. Brian Timbrell and Steve Fletcher have also indicated that they can now speak on Friday. Is there anyone else who thinks that they could move from this afternoon to Friday that I've not recorded there? Were you on the list from this morning? Did I remember? You should be on my list somewhere, but it's okay. Whoa, dearie me. See me after school. All right. Is anybody else? All right. As we move through this afternoon, there's just a reminder that when I invite people to the witness table, I will ask you. You're all right. I will ask you, are you in support or in objection? I don't think we've got any people in support, but nonetheless, I will ask that question. I'll also ask you for a copy of any speaking notes that you'd like to leave or could leave me. I have a speaking note provided on behalf of Councillor Crawford. So I'll record that as the inquiry document at the appropriate time. But if anybody does have any notes that can leave me, it just means that I've got a better record than I can possibly keep up with in terms of making my notes. And a reminder that at the end of all of that, I will ask also whether or not you're content for Mr. Strawn to ask any questions that he may have of you. All right, Mr. Strawn.
So could I just ask, if people are providing copies of speaking notes, could they, I'm sure the council can assist, but provide copies to the main parties?
That will ensure that they are on the, there will be recorded as inquiry documents. That's brilliant. Yep. That's brilliant. If we can do that over the next few days, and when we do housekeeping in the start of the morning, in the afternoon, I will say I've received these, and then I will give them inquiry document numbers, and the council will put them on the website. So thank you for that. I appreciate your efforts in all of that. Thank you. Right. So I'm going to read out the list so you know who we are. So the first person I will call is Paul Holmes, MP. Then Sir Stephen Holgate, Christine Walton. Jenny Austin will be speaking on behalf of Alex Riding. Nick Griffith. Then from the school, and I do apologise if I've not recorded names correctly here, but I will check those names when you come to the witness table. I have Max Breeny, Annalisa Kenny, Martha Hart, Olive Frody. That's a name that I couldn't read my writing, if I'm being quite honest with you. Isabel Bidwell. Then we have Councillor Wallace, Councillor Crawford, Dr. Thompson, Vicky Hillman, Christine Walton, Anna Craggs, Lindsay McClay, Lisa Roachford, Rob Hillman, Susie Thompson, Tony Peter, Fred Wales, Glenn Jewell, Angela Fowler, Steve Inton Lever, Kay Linders Kilby, Lou Clayton, Rebecca Stanforth, Kerry March Bank, Vix Mansfield, Nick O'Donnell, Bill Blaine, Jenny Austin, Kelly McGrath, Isa McGrath, Georgie Baker, Ted Hill, Valerie Archibald, Phil Riley, Andy Daniels, Caroline Trimble, and Hayley Bear me a second, I need to check that name. Is it Hayley Rickens, I think? We'll check the names as you come up. I think it's Hayley Rickens. All right, so the first person I'd like to invite up to the witness table is Paul Holmes, MP. I'll let you settle, Mr. Holmes. There's some fresh water there and a glass should you so wish.
Thank you.
Just let me know when you've got your stuff together now. You okay?
Yeah.
Okay, it'd be helpful if you can just state your name, who you represent, I know in this case who you represent, obviously, just to confirm your objection support, and can you just advise me whether you'd be content to answer any questions that Mr. Straw may ask?
Yes.
Thank you very much indeed. So in your own time when you're ready.
Well, good afternoon, Mr. Normington, and I'm grateful for the opportunity to speak here this afternoon. Today, can I just commend you firstly for the work that you're about to embark on? I know it's not easy and it's a hard role, but we do appreciate you being here, especially with the strength of feeling that we have in the community and hopefully what you'll see later on this afternoon. The Hamble community have come together over the last few years, and it is clear in the fact that in the response to the consultation held by Hampshire County Council, a total of 5,700 responses were submitted detailing their opposition. It is my belief and the belief of all elected politicians in the area, and forgive me, I didn't introduce myself, I'm Paul Holmes, HOLMES, the Member of Parliament of Hamble Valley. But it is my belief and the belief of all elected politicians in the area on a cross-party basis that if this is allowed to go ahead, it will literally destroy Hamble as a vibrant village. Looking at the details of the application, it is not difficult to see why it's faced this response. The Hamble Peninsula is a cluster of villages accessed by one narrow highway, Hamble Lane. This small road already struggles with traffic flow problems which will be further and greatly exacerbated by 126 lorries a day going in and out of this lane. Hamble is well-renowned internationally for its role in that it plays in inshore sailing, supporting many businesses associated with the boating industry, and it is also home to a wide range of international businesses, an oil terminal, and the Firearms and Gold Command Centre for Hampshire Police. For years, residential development has made traffic issues worse, and this is a key reason for why further residential developments were dismissed by appeal in recent years. So there is a clear precedent. Indeed, the official plan has recognised the acute congestion problems in the peninsula even prior to the additional pressures that this quarry would add. And this has been recognised, as I say, in previous inspectorate reports when residential development was rejected and rejections were upheld. I previously stated at the hearing held in May with the Regulatory Committee that there needed to be an additional refusal reason under highways impact which had not been adequately addressed and were based on outdated traffic assessments. I welcome the fact that based on the available information, the proposal was considered conflict with policy S11 open brackets transport infrastructure close brackets of the Eastleigh Local Plan 2022 and paragraph 114 of the MPPF. Because it does not promote walking, cycling or public transport, nor does it incorporate sustainable transport options in the development. And before we heard the capitulation this morning of Hampshire County Council, I still believe that those policies are not being met. The Hampshire Police and Crime Commissioner has objected on behalf of the police service in Hampshire. In the recommendations in the report, her specific concern about the ability of the police to respond to emergencies from their Gold Command Centre and to be able to pass two HGV lorries side by side in a traffic jam along many parts of Hamble Lane was not mentioned. This objection, I believe, places the proposals at odds with HMWP Policy 10 on impacted amenity and HMWP Policy 12 on managing traffic. There are also the views and commercial outlooks of 250 businesses with a combined turnover of £148 million and 1,800 employees. CEMEX has failed to undertake any face-to-face consultations or engagement with local businesses, and indeed under NPPF policies in paragraph 85, it clearly states that, quote, planning policies and decisions should help create the conditions in which businesses can invest, expand and adapt. That requirement is not met by this application. School services, businesses and residents would all be impacted by this development, and I want to reiterate that this application will see a quarry dug less than 110 metres from the secondary school and an early learning centre, less than 80 metres from 250 houses, and in some case within 50 metres, and less than 160 metres from a primary school. This appears to be in contravention of MPPF paragraph 193, which states that planning policies and decisions should ensure that new development can be integrated effectively with existing businesses and community facilities, and that existing businesses and facilities should not have unreasonable restrictions placed on them, and I also believe that this is contrary to HMWP Policy 10. Hampshire County Council had deemed that this was likely to cause unacceptable flooding, violating Part H of Policy 10, Protecting Health, Safety and Amenity, Policy 11, Flood Risk and Prevention of the HMWP, and Policy DM5, Managing Flood Risk of the Eastleigh Borough Local Plan 2022. Additionally, it does not align with Policy S11, Transport Infrastructure of the Eastleigh Borough Local Plan, or paragraph 114 of the NPPF. As a result, the proposal was not considered as sustainable minerals development by the Regulatory Committee, contrary to Policy 1, Sustainable Minerals and Waste Development of the HMWP 2013, and paragraph 11 of the NPPF 2023. And despite piecemeal agreements and an unfortunate capitulation of Hampshire County Council, I believe that these policies still act as decent and categorical reasons why you should uphold the refusal put forward by the Regulatory Committee in May. Residents have been supported in their valid reasons by Hampshire County Council. They were supported by Hampshire County Council, and can I put on the record that I believe this decision and negotiation should have gone before the Regulatory Committee of local elected politicians before officers decided to pull the rug from under residents' feet. But at every stage, this quarry has been rejected through official local democracy. Residents, Mr. Normington, need this to come to an end, and I hope that you will see from the excellent contributions that you will hear from my community this afternoon why this needs to be rejected for the good of the village, its residents and their well-being. As I've said, Mr. Normington, I believe that the policies are still in place for this to be a sound rejection, and I hope that after this process you will come to that conclusion in your role as planning inspector. Thank you.
Thank you, Mr. Holmes. Mr. Strong, do you have any questions for Mr. Holmes?
Are we going to have to press alternately? Well, that's going to be quite... Okay, I'll do my best. So, first of all, sir, just to make clear, because otherwise we'll be here even longer than we have you programmed, I'm not going to ask questions of everyone, and in large part I'm not going to ask questions of most people, and I hope that doesn't disappoint you too much, Mr. Holmes, because there are others coming to deal with evidence. But I am going to ask you just a question or two about your response. You wrote into the inspectorate on the 8th of January 2025, and you've raised transportation issues again a moment ago. And I'm assuming from what you said to the inspector, you would expect and hope this to be a decision based on objective evidence. Is that right? You would hope. Yes, good. And the reason I ask is because you in your representation to the inspector had, and I think you repeated this a moment ago, but without the adjectives or adverbs, traffic assessments and data relied upon by CMEX and Hampshire highways are woefully out of date and are from Hamble Lane at a time before mass local development took place, is what you asserted. And then you went on for good measure to say that Hampshire highways were showing willful negligence from a public authority in not relying on the facts. So quite a strong piece of criticism from one public servant to another set of public servants performing their public duties, isn't it, Mr. Holmes?
Yes, it is. And I'm fully willing to answer that because At the time that this proposal was coming forward, there were no physical traffic assessments since 2017. And since that time, I live in the area, so I know what's happened in the area. There have been numerous residential developments at the top of Hamble Lane that have been built, increasing traffic on Hamble Lane. The £50 million Windover roundabout works that were proposed to ease congestion on Hamble Lane have not gone ahead. There has been further residential development applications in Satchel Lane which have been rejected and upheld by a planning inspector. There is a question in my mind over the ability and the competency of Hampshire County Council in the way in which they formulated those traffic assessments, those initial traffic assessments. I have made that consistently clear to officers at the county. And if you look at when those assessments have been done, Hamble Lane is not a lane that has the traditional rush hour peak traffic flows. Residents and I have made that clear over many, many years. You can have a congestion on Hamble Lane at 12:30 in the afternoon. You can have congestion on Hamble Lane at 2:45 in the afternoon. You can have congestion on Hamble Lane at 9 p.m. in the evening, where you will be regularly stopped from accessing the Hamble village, which will be worse if this proposal goes forward. And it can take up to 45 to 60 minutes to get into the village. I see nothing in the arrangements that CEMEX has come to with Hampshire County Council that adequately mitigate the problem of increased traffic flows and traffic congestion that this proposal will cause.
I think we may need to adjust the system if we can to. All right. So, Mr. Holmes, I just want to tackle with your statement and see whether it's accurate. The assessments and data are woefully out of date. Right. Have you read the transport assessment and the addenda material yourself? Yeah. Do you know when the traffic data was collated by CEMEX?
There was one. Apologies, Mr. Strawn. Yes, they were done with the initial time when this proposal came forward. They were done around the time to which the application was submitted. So that was later than when I originally put my objection in. But what I'm saying to you, if I may ask a question of you, Mr. Strawn, is at what time were those assessments completed? How and what methodology was used in the way in which those traffic assessments were completed? Because I put it to you that there are a number of traffic assessments that were done and undertaken without anybody physically present. They were done by computer. There was modelling that was put forward on Hamble Lane that is not relevant to Hamble Lane. And I would ask you the times at which those traffic assessments by CEMEX were undertaken.
So Mr. Holmes, I hope this isn't going to go the way with some politicians. I asked you a question and you didn't answer it. I'm going to ask you it again. I can't make you answer my questions, but please have a go. I think you were suggesting you're aware of when the traffic data was collated for the purposes of, and I referred you to the transport statement addendum. If you know when it was done, just say, I know it was done, and it was in what year?
Thank you, Mr. Strawn. I'll bypass the fact some politicians don't answer the question. I assure you on behalf of my residents and knowing where they live, I do answer questions. The original objection that I put into the planning application was, I believe, in 2023. At that time, based on the traffic assessments that were completed, I took the view that there were no physical assessments undertaken and those assessments were wrong. That is my judgment. It is not a political answer. It is an answer to the best of my knowledge. On specifically answering your question so that I satisfy you, I would say to you that I do not know when the latest one that you refer to was completed, but at the time of my objection, I had read traffic assessments and come to the conclusion they did not meet what was needed for Hamble Lane.
Right. That was a long answer. I think you're saying you don't know when they were done.
Mr. Strawn, dare me say that barristers also like to ask long-winded questions. My answers are not long. I am saying to you, at the time when I submitted my response to the initial planning application that went forward, I based my answers on the traffic assessments that were undertaken. To answer your point, as I believe I answered in my last answer, I do not know when the latest or the addendum that you outline was undertaken.
I ask you that because your letter is written to the inspector on the 8th of January 2025. You're accusing the application as being supported by data that's woefully out of date. So I wanted to know whether you knew when the data was collected. I think I'm understanding that you don't know. Is that right?
No, because in my original answer that was in the original application, those assessments were undertaken in 2013. There were assessments undertaken in 2013 before planning applications were outlined. There were assessments done at a later date while this application was going in, or this application was going through its process. But as I say to you, nowhere does it undertake what time they were undertaken, and nowhere does it outline the methodology to which those assessments were undertaken. And at my last reading during the process of this application, there were desktop models attributed to this application that simply do not bear out the reality of local residents' wants and needs.
Right. So, Mr. Holmes, I think I've understood the position as to what you know or don't know about the data. You say it was before mass local development took place. Again, and you've also said there's no methodology. Have you actually read the transport assessment addendum yourself, or are you relying upon someone else who's told you these things?
I'm sure, like you, Mr. Strong, you have a big team that supports you. I have a very small team that supports me. But the evidence that I have put forward has gone forward after I have read traffic addendums and traffic assessments. The traffic assessments that are put forward by CEMEX indicate that there is a limited and restricted increase in traffic flows in the Hamble Peninsula after this application would be going ahead. I say to you in the strongest possible terms that knowing the area and knowing the traffic situations that happen on that peninsula, those traffic assumptions are not correct.
So, Mr. Holmes, I'll try again. I think the inspector did ask you.
Just please, as mentioned earlier, please don't say anything.
I think the inspector did ask if you could answer the question directly. It will save a lot of time. Otherwise, the question's put again.
We'll put it again.
So, yeah. Have you read the transport assessment addendum in order to make the statement that you have that it's woefully out of date and the data and done at a time before mass local development took place?
Yes.
Do you want to then turn up the transport addendum B82, CDB 82? You can probably reach it behind you.
I wasn't expecting the witness to be taken to the third party to take to court documents. Is there a different way we can deal with this, Mr. Strong?
Yeah. I'll try.
And I'm sure
take it from me, and I can get the document out for you if you want, Mr. But you told me you've read it. It makes clear, if you had read it, that in fact the transport data incorporates not just the development you're talking about in terms of housing, but it had already been constructed by the time that the data was collated in 2022. Are you aware of that?
Yes, Mr. Strawn, but as I say to you again, there have been developments that have gone on down there, and what you are not saying in your questioning is how those assessments were come to, or how that data was come to. What I am saying to you is that those assessments and the indications that show, I think that there was a 0 point something increase in traffic movements post or while this application was undertaken, or while this application was in operation, that there would be minimal increase in traffic movements and flows and congestion in Hamble Lane. I am saying to you once again, and I'm not sure how I can make it more clear, that the assessments that have been undertaken do not take the reality into account. You once again, Mr. Strawn, if your case was very strong, you would be telling us at what time period those assessments were undertaken on Hamble Lane, because those assessments and traffic on Hamble Lane goes from very, very harsh peak times and very high levels of congestion within a space of 15 minutes to suddenly being clear and then going back to being congested again. So you can ask me the question again. I am saying to you that the traffic assessments that have been undertaken by CEMEX are not a true and accurate account of what happens in Hamble Lane. And once again, the timescales at which those assessments were undertaken are not clear, and they do not portray an accurate reflection on the day-to-day movements of traffic up and down Hamble Lane.
Mr. Holmes, you can use this as a soapbox in that way. I'm asking you very simple questions. They don't require elaborate answers. You don't need to repeat your case. No, I didn't ask you. I asked you a new question. It was about the content of the transport assessment addendum. I can also get it out to, if we time allowed, to show you that it does provide all the methodology and detail you're referring to. So, but I don't need to do that. It's just really what I'm getting at, Mr. Holmes. Your statement to the inspector that the data is outdated and doesn't take account of housing, or as you put it, mass local development, doesn't take account of it, it's outdated, is simply wrong, isn't it?
Mr. Strawn, you may say I'm on a soapbox, but I would just remind you that I'm a democratically elected member of Parliament, elected by my constituents. I'm not on a soapbox. I'm talking about what I think.
Answer the
what
question.
I think. I will. I will.
Question.
What I think is best for my area and my constituency. To answer your question, well, I have been. I think you've won.
Hold it there. It's not helpful to have this kind of spat. I think we need to bear in mind that Mr. Holmes is not a highway expert. Clearly he represents the local community, and obviously the evidence regarding those surveys and data can be tested with relevant experts. So what I'm really saying is, first of all, just be mindful of that, and secondly, be mindful that this is not a political audience in that sense. So short questions, short answers, and we can move on.
May I answer the question?
Absolutely, yep.
Thank you, and I assure you, Mr. Normanton, I'm not trying to make this political at all. I'm just saying my opinion in my role. In terms of the traffic assessments being outdated, and in terms of the data that's being shown, I think I've demonstrated to you what my understanding of the data is, which is that CEMEX claim that there is a minor increase in traffic movements that are not noticeable enough to determine that this application should be rejected on highways grounds. If that were the case, I would just put it to Mr. Strawn and you, Mr. Normington, that there is a precedent, as I have said, in residential development in Satchel Lane and Hamble Lane being rejected, and the rejection being upheld by the planning inspector based on highways and traffic assessments and an indication that traffic increases from residential development, let alone this quarry, would increase and would not be at sustainable levels.
So, sir, just taking your point on board, my question is confined to a purely factual question as to the basis upon which Mr. Holmes has represented not just to you but to the local community, hence my concern about misrepresentation, that the data that's being used, for which he accuses the Highway Authority of willful negligence, is outdated and doesn't take account of committed development and also the development that's been built in the area. Now that's just simply wrong. I put it to Mr. Holmes, I can't do anything further than that, but I do. The reason why I pursued it is because, for the reasons I expressed in my opening, if this is, in our submission, an unhelpful example of an incorrect statement which has been put not just to you, but to the local community. It's not surprising people are concerned if that's the portrayal of our material. It just simply doesn't reflect reality, and it shouldn't be allowed to be said, let alone accuse a highway authority of willful negligence, which I think is not just unsubstantiated, but completely inappropriate. And that's why, in fairness, I put it. It's a very short factual question as to whether that I was exploring as to whether Mr. Holmes knew the data.
Okay, if it helps, I understand the point you're making. I equally understand the point you're making, Mr. Holmes, regarding the extent of the evidence which you've read and your interpretation of what conditions are like in a reality perspective. If it helps us move on, I understand the points respectively you're making.
Thank you. I would just like to briefly come back on that. The evidence that I've put forward in the objections, I do not believe are incorrect. I did accuse the Highways Authority of being willfully negligent if they come to the determination that there would be no adverse effects on the highway should this application go ahead. They have chosen to make that decision. I think that is a travesty to the local people in the village. But I would also say to you, Mr. Strawn, that it is my interpretation of reading the reports. You have a job to represent your client and get this application through. My job is to say to you that my interpretation of the data from the traffic assessments and the actions of Hampshire County Council will demonstrably make residents' lives worse in Hamble, will increase traffic movements and congestions on the Hamble Peninsula, and will see the adverse effects that they are already suffering from go even further. I think that's a perfectly reasonable answer to you, and I think that answers the questions that you have asked me in this session.
Well, I'm not going to get drawn into that. That's not the question I asked, and not, but I pursued. So you'll be able to.
I can make my own assessment of what's been said and asked, Mr. Strawn.
And just to be clear, sir, of course, I'm not going to ask everyone about all of the ways in which the evidence has been characterised. But I do think when it comes to a professional body like the local highway authority, that it's particularly unfortunate. They're not here, of course, but it's unfortunate that that sort of statement is made when it's just patently untrue.
I'm fully aware of what you said and the reasons behind that, Mr. Strawn, and equally I'm fully aware of what you said, Mr. Strawn, and the reason behind it. So I think at that point, that's probably best for me to make my own judgment about what's been said, what I've heard, and indeed what I've already read as well, if that's helpful. Do you have any further questions? Mr. Holmes, can I thank you for your attendance at this inquiry? It's been most helpful. Thank you. Could I invite Sir Stephen Aldgate?
Sir, the mics now should be working, so you should be able to have them the team of works on
All right.
so you should be able to have the mics on both sides.
Sir Stephen Aldgate, can you please make your way to the witness table, please? I'll let you settle a moment. Would you like a drink of water?
I've got a whole bottle to get through.
Do you want a glass with that, though?
Thank you.
We'll get you the clean glass. While we're getting your glass, Mr. Aldgate, could you please introduce yourself to the inquiry, just explain whether in support or objection, and can you confirm to me whether or not you'd be willing to answer questions that Mr. Strawn may ask?
Thank you. Thank you, Mr. Northington. Ladies and gentlemen, thank you for inviting me to come here this afternoon. I hope I can explain why I'm here in a moment. My name is Stephen Holgate. I'm a Medical Research Council clinical professor of medicine at the University of Southampton, and I've spent the last 40 years researching air pollution in relation to lung and other associated diseases. I was the founding chairman of the Committee of Medical Effects of Air Pollutants, which is the government's advisory body on air pollution, and currently UKRI Clean Air Champion, and I'm the advisor to the Royal College of Physicians on air quality. So I'm here to represent children and vulnerable people in the community. And what I'm going to say has nothing to do with my knowledge about the local infrastructure that you're talking about. But I believe that in the last decade, where there's been nearly 32,000 new publications attributing air pollution to adverse human health, the game has changed very dramatically indeed. So much so that in my original RCP report in 2016, called Every Breath We Take, which is all about air pollution and human health, the Royal College of Physicians asked me to revise the report, which will be coming out on June the 19th, where we'll be focusing very much on the vulnerable and on children's health and well-being. In addition, the Royal College of Paediatrics and Child Health issued in September a statement which I think summarises some of the main issues related to children and the way that air pollution can eat away at their health over the life course. So you may ask, what has changed? Well, I was born in Manchester, so I do remember in 1952 the great smogs that they had in London and the time we had terrible smogs here. But air pollution now is different. Out of sight, out of mind. You can't see it, you can't taste it, and only occasionally are you aware that it's present. And yet currently, most people living in the UK are breathing air that's 2.5 times more polluted than the World Health Organization current guidelines for air quality, both for nitrogen dioxide and particulate pollution, which are the main pollutants I think you're talking about in this inquiry. So why are we here talking about air pollution and health when obviously there's been a tremendous change in the way that air pollution is generated and emissions have been controlled? Well, certainly on a worldwide scale, air pollution now is the #1 environmental factor causing adverse human health and accounts for up to 700 different diseases in terms of contributing pathogenetic mechanisms. All of this was unknown 10 years ago, so this is new research. Secondly, children particularly, and pregnant women, as they're conceiving and bringing up their babies in the uterus, are especially vulnerable. The particulate air pollution is breathed into the lung, which is the surface area of a tennis court, and the particles pass into the circulation, and like Trojan's horse, carry something like 800 to 900 different chemicals into every single organ of the body, including the placenta, and into the fetal circulation. And it's now known that even in the UK, in settings where there is polluted air, we have babies born with smaller lungs. And babies born with smaller lungs exposed to air pollution obviously are at greater risk of subsequent respiratory and other problems. So the main issue I want to try and draw attention to is that children are the focus of the new report. And as I understand it, in this community you're talking about, young people and children form quite a high proportion of the community that are going to be exposed. Outdoor air pollution gets indoors because we all have to breathe air to live. So anything that you talk about outside will get inside the buildings, unless you have absolutely airtight buildings, which I think is very unusual in the current building environment. In addition to children being vulnerable to air pollution, there are particular diseases I want to draw attention to, in particular bronchial asthma and allergic diseases. And I gave the clinical evidence of a case of Ella Kissy Deborah, who died of asthma in 2013, in which the coroner overturned the first inquest and put air pollution into the cause of death, which at the time when the first inquest was issued was not realised, for the very reason I said at the start of my evidence, out of sight, out of mind. It only happened that in Ella's case there was DEFRA air pollution monitoring a mile from her home, and Lewisham County Council had air pollution monitoring all around the neighbourhood for a completely separate reason, and we were able to make the case. And just last year the government and the JLC in London made an apology to the mother of Ella, indicating that air pollution had materially contributed to the death of her child. First time air pollution has ever appeared on a death certificate, and that, I think, has made history. And the reason it's making history is that people just don't know because they can't see it and can't measure it. So when you then have a community where you are deliberately introducing increased air pollution, and there's bound to be increased air pollution, whatever one says about the movement of traffic, where you're going to mine dusts and have static machinery that's milling and removing those dusts, then air pollution is bound to increase. There is no argument about that. It is going to increase. So how can we, with the UK having the highest prevalence of asthma in the whole of Europe, with us having now up to 35 to 40% of winter excess hospital admissions for chronic obstructive pulmonary disease, asthma and pneumonia being accounted for by air pollution, how can we deliberately introduce something that you know is going to make things worse? And that really is my case. And I don't know whether the absolute measurement or the numbers make the case. All I'm saying is that this government, the United Kingdom government, is going to work hard, I hope, with the professionals to reduce the exposure of people to air pollution, no matter where it comes from, and as a consequence of that, hopefully protect the generation that's going to come before us, namely the children and the young people who are now being exposed, who are now being born and will be exposed in the future. So I just stand in front of you as a clinician who spent all his life treating asthma and respiratory illness, saying that I have to defend the public right for clean air. We have a public right for clean water. We need a public right for clean air. We do not have it yet, and we will fight for that particular need. But I will say to you all that I think we must put health up at the forefront of decision making in areas like this, even though the legal framework is yet to catch up with the scientific evidence. And I'm hopeful that in the year or two to come, that process will occur. Thank you very much.
Thank you very much. So before you leave, don't leave.
No,
I did ask you, and I don't think you answered whether or not you'd be prepared to answer questions.
Oh, of course, if anybody is willing to ask them.
I think you might get some questions.
No,
Mr. Strong.
I wasn't going to ask any questions. I was just going to, obviously, Professor Holgate was not referring to any of the numbers or assessments. I was just going to say that if he was interested, he'll find them all in the core documents. There's a number of documents, so you've probably seen them, but they range from the original ES and then various further assessments, B43, 44, 57, 90 and 92, in addition to the original CDA 35.
Yes,
I don't know whether that means
I'm not arguing. As I said at the start, I'm not partisan here. I'm representing human health.
Understand.
And human health is an important issue in the decision making that you're going to have to make.
And I wasn't asking a question. I was just giving the references that you, if you're interested, you can see.
Thank you very much.
In which case, there's no further questions, Stephen. Thank you for your contribution to this inquiry. Thank you. Could I ask for the... Could I invite Christine Walton, please? While you're settling down, Mr. Walton, the same questions I've asked everyone else. I assume you are in objection to the proposal.
Yes, I'm objecting.
And would you be adverse to Mr. Strawn asking any questions?
As long as they are reasonable and delivered in a polite manner, I would be happy to answer his questions.
Thank you very much indeed. I will ensure that is the case, and I'm sure Mr. Strawn will ensure that's the case as well.
Thank you, Mr. Norrington.
So when you're ready, if you could please commence your presentation to this inquiry.
That's on. Good afternoon, Mr. Norrington. My name is Christian Walton, and I'm the Vice Chair of Governors at the Hamble Primary School. I'm speaking here today on behalf of our 355 pupils, their families, and our 51 staff members. For the last 3 years, we have fought long and hard to be heard, yet our concerns about the impact on our school and our children has been largely ignored. I am here today to be the voice of our children, and you will hear from some of our children later. We strongly object to this quarry. Our concerns are not unfounded, as CEMEX will have you believe. This proposal as our MP said, sits just 160 metres from our primary school. That is from the main building where children are educated. And it's 50 years from an early years nursery and directly across the railway line from the Hamble school. Let me ask you plainly, would you ever consider building a school next to a working quarry? Then why would anyone approve a quarry next to 3 schools? Would Mr. Strawn be happy to send his children, if he has any, to such a school? I really doubt it. This proposal is not only inappropriate, it is dangerous, unjustified and deeply harmful to our children's health, safety and education. Our school is regularly oversubscribed. We are a thriving village primary school that is rated good by Ofsted, and we are on a journey to excellent. Such is our reputation that our current waiting list for school places stands at 25. These are children from outside of our Hamble catchment whose parents want them to come to us because of our caring, nurturing approach that provides the best possible start for our children. Do you want to jeopardise this by favouring this appeal? Let me put some numerical context around our concerns. The proposed site entrance lies just 375 metres from our school gate. One phase of the proposed workings is a mere 160 metres away from our building and 120 metres away from our key Stage 2 playground. 210 pupils aged 7 to 11 use the key Stage 2 playground daily. How would you like your child playing so close to a quarry while at school? It's not just on the other side of the road, it is just on the other side of the road from classrooms, playgrounds and paths used by our children. We are astounded that despite the proximity of the proposed site to our school, 120 metres, Hampshire County Council's own consultants, RSK, in their June 2024 technical review of air quality, haven't even included our school as a sensitive receptor. They've referenced that as P12, if you'd care to have a look, as they consider it too far away. They claim our school is 250 metres away, when our building is actually closer to 100 metres closer, and our playground closer still, literally just on the other side of the road from one of the working phases. Words like negligible, estimated and assumed appear often, and there is no evidence of actual measurements of air quality having been undertaken, either by Hampshire County Council or CEMEX. How can they be so blasé with our children's health? Public Health Hampshire County Council even noted in their statutory response to Hampshire planning, and I quote, "The site is in close proximity, open brackets, under 1 mile, close brackets, to Hamble Primary School," end quote. This paints quite a different picture than the reality of within 120 metres to our playground and 160 metres for our building. The secondary school, which as Mr. Holmes alluded is even closer, didn't even warrant a passing mention. How can the Planning Authority and Public Health Hampshire ignore this proximity? Why wasn't it properly considered? Please don't ignore this now. Across its currently proposed 15-year lifespan, the quarry will affect at least 995 children passing through our school, with 405 of them spending their entire primary school education under the influence of dust, noise and traffic. In all our time fighting this, our community has repeatedly asked for evidence via the Planning Authority from CEMEX that they have experience operating a quarry this close to so many sensitive receptors. They have repeatedly assured the County Planning Authority that they have experience, yet have offered no credible evidence. Why might this be? I can't answer as to why the county has accepted their assurances without evidence, but I can state why there is no evidence. It is because no other operational quarry anywhere in England is this close to 3 schools. We are an outdoor learning school, and our June 2023 Ofsted inspection noted, and I quote, "Outdoor learning is a real asset and gives all pupils many opportunities to build independence and broaden their experiences," unquote. 145 of our children receive structured outdoor lessons each week. All 355 pupils engage in at least 1 hour of outdoor PE weekly. This does not include the time the children spend outdoors during break and lunch times. If we add in the break times, this becomes significant. And Key Stage 1 have 20 minutes in the afternoon as well. Our 45-year-R children, the youngest and most vulnerable with developing lungs, as we heard from Professor Holgate, are taught in a free-flow classroom where they are free to go in and out of the building at will in order to develop their core skills, so their time outside is greatest. Again, Ofsted noted, and I quote, "Children receive an excellent start to their life in the early years," unquote. It is our strong belief that this quarry will jeopardise this. We have deep concerns about the impact of dust and particulate matter on the health of our children, and as you will no doubt hear from our doctors and as you've heard from Professor Holgate. If I'm not mistaken, PM10 particulates are 10 micrometers to 2.5 micrometers in diameter, and PM2.5 particulates are 2.5 micrometers and smaller. CEMEX's dust management plan, section 5.1.2, alludes to a daily dust inspection as a mitigating factor. I'm really curious, and perhaps you could explore this further with them, to understand how a suitably trained operator, as they describe in their plan, will be able to see these microscopic particles with a visual inspection. We would be grateful if you could get a sensible answer to this. 30 of our children already have asthma or chronic respiratory conditions. We're extremely concerned about the impact of air pollution on our children, and we ask you to challenge CEMEX's claims that our concerns are unfounded and there will be negligible impact on the health of our children. They are not medical experts, nor do they appear to have sought medical expertise. 50 of our children have special educational needs, and out of these, 27 of our SEND children are very susceptible to noise. Outside of our SEND children, our Year R children struggle with sudden noises. So successful are we as a school in nurturing children with SEN, on the 7th of March 2025, we received approval from Hampshire's Executive Member for Education to commence non-statutory consultation on the establishment of a resource provision for 12 pupils aged 4 to 11 with autism spectrum conditions, opening in phases from September 2026. By implication, the number of children at the school with SEN will only grow. The proximity of the quarry will likely impact their educational outcomes. This brings me on to our concerns around fear and intimidation. CEMEX's assessments have concluded that fear and intimidation is negligible. This is in relation to highways. However, the standards they have based this on and previously submitted show a base load of 12 to 1800 vehicles per hour statistically correlates with great levels of fear and intimidation. How then, with traffic previously reported by them at 1,370 vehicles per hour, which has only increased since, in the peak morning school rush, can this be logically concluded to be negligible? The proposed Quarry Junction crosses the only fully paved and pedestrian cycle route into and out of Hamble. 1/3 of our children and half of our staff travel into the village, that is, from north of Hamble Lane, on a daily basis. This means that they will pass the quarry entrance and interact with the inbound HGVs. Our swimming programme, a required national curriculum activity, requires our children to walk from our school to the swimming pool adjacent to the Hamble School. Every week during the summer term, 100 children crossings of the quarry entrance will occur during school hours. Over 15 years, that's over 1,000 children crossing the quarry entrance just to access essential swimming. If the route becomes unsafe, we may be forced to cancel this vital skill. Have any of you actually walked the shared path up and over the bridge and along Hamble Lane with peak time traffic rushing past? This is just not about desktop numbers that CEMEX will have you believe. It's about the reality of living in Hamble, living alongside Hamble Lane, and the confidence and well-being. Our children use these narrow shared pavements. Our fear is justified. Our children's fear is real. Hamble Lane is not a resilient traffic network. It's a fragile one, and our school children suffer. CEMEX's assertion that Hamble Lane can cope with up to 126 additional HGV movements is simply not credible. This compares to the original Minerals and Waste Plan, which envisaged 30 to 60 total movements per day. So this, by my maths, is doubling at least the number. We have collated evidence as school governors that we have previously submitted with our letters to the inspectorate that identified 17 significant traffic issues occurring over a relatively short period that gridlocked our community. It only takes one minor mishap to push things over the edge into chaos. One of these instances included a child getting hit by a vehicle on Hamble Lane not far from the proposed entrance. Just this weekend, an elderly lady was hit by a vehicle at the traffic light controlled pedestrian crossing near Tesco. The road is simply at capacity and dangerous for vulnerable users. These are not unfounded claims. We remain deeply disappointed in the overall lack of oversight provided by Hampshire Highways. Over the course of the last 3 years, our objection letters have laid out concern after concern identified in the design plans for the entrance, as well as others highways issues. At no time has Hampshire Highways challenged CEMEX's plans. Were it not for our objections, we strongly believe that CEMEX would have been permitted to have a junction design, which from their own safety consultant's report stated, and I quote, "The audit team have concerns that a large vehicle deviating from the path illustrated would encroach the proposed footway, which could lead to a vehicle to pedestrian stroke cyclist collision, strike the proposed curbing as well as guard railing, leading to a loss of control type collision, or encroach the opposing lanes into the path of oncoming vehicles, leading to side swipe type collisions," end quote. This was submitted along with their documents demonstrating the entrance, which shows that they took no account of this internal audit. Later, safety improvements include mentioning that HGVs would be driven by professional drivers. In my experience, you have to be a professional driver to drive an HGV. None of this has apparently ever been questioned by Highways, which supports the assertion that Mr. Holmes made on behalf of the community earlier. We have further concerns about the so-called mitigations. CEMEX and Hampshire Highways appear to have agreed these measures behind closed doors. A critical one for our school, banning HGVs from leaving the site during school start and finish times, is fundamentally flawed. There is no ban on vehicles arriving, simply because this would be too inconvenient for CEMEX. Should the safety of our children going to and from school be beholden to the convenience of CEMEX? Where is the logic? Where is the evidence that an unladen HGV entering the site is safer than a laden one leaving it? There is no such evidence. In fact, Hampshire Highways confirmed to our governors via a Freedom of Information request, and I can give you the reference should you need it, that, I quote, "This information is not held," unquote. Clearly, this implies that no risk assessment exists to support this mitigation, a mitigation that's being touted by CEMEX as key to allaying our concerns. This mitigation takes no account of our breakfast club, which is critical in ensuring children from well-off families are able to access a healthy breakfast. This runs from 7:30 each school morning and feeds an average of 15 children per day. It also takes no account of our after-school activities, including clubs and the Creative Kids programme, which sees 50 children on site until 6 p.m. The proposed measures would do absolutely nothing to protect them once they leave our school premises. The same Freedom of Information request that identified that there was no risk assessment also identified that the proposed £500,000 contribution to improve walking and cycling is barely no more than 200 metres of pavement that's been based on a 2019 feasibility study, which had its costs updated in 2023. This would create a path from our school to the railway station, where there is one train an hour on average in each direction. In correspondence with CEMEX dated February 2023, Ben Clifton, the Strategic Transport Manager for Hampshire, wrote to advise, and I quote, "Once the funding is in place, we would anticipate the scheme coming forward in approximately 2 years," unquote. So, mitigation scoped in 2019 and recosted in 2023 won't be in place until at least 2027. How does this help our children who come from the north of the railway bridge get safely to school? How does it help our community? Will inflation make this unaffordable for the county? Given the significant increase in building costs since COVID and the county's track record for hanging on to developer money, I suspect this money will sit and lose value in a bank account. Beyond safety and health, this quarry undermines our entire educational ethos. Additionally, noise from HGVs, processing plants and reversing alarms will further disrupt our children's education. Our 1950s era classrooms, which rely on open windows for ventilation, combined with the constantly changing coastal wind direction, will no doubt funnel dust and noise indoors, further harming concentration and learning. Finally, we have significant concerns about trespass and the safety of trespassing children on site. The site will remain accessible after school hours. During the summer, our local youth are known to explore open spaces. In terms of child trespassers, there's actually a greater duty of care on the landowner. The occupier is required to make premises secure and hide away any allurements as thoroughly as possible. The prospect of unattended machinery and water-filled pits is deeply worrying. Who will ultimately be responsible if an accident through trespass befalls a child? Cemex or Persimmon? Their fencing is merely a stock fence of undesignated height next to a mound of earth. This is not just a planning issue, this is a safeguarding issue. The quarry will impact an entire generation of Hamble primary school children, nearly 1,000 pupils over 15 years. 405 of them will spend their entire primary education under its shadow. Given Hampshire's track record on planning for quarries, it is highly likely that this 15-year timeframe will be extended. And there is no adequate mitigation, there is no comparable precedent, and there is no acceptable justification. In 15 years, the quarry may be gone, but its impact on our children's lungs, learning and lives will remain. Cemex are certainly not building a better future for them. The voice of the child, our most vulnerable member of the community, has been dismissed repeatedly by decision makers throughout this process. We believe that Hampshire County Council have failed in their duties. Under Section 149 of the Equality Act 2010, the Planning Authority has a duty to give due regard to the impact on individuals with protected characteristics. This proposal will disproportionately affect young children, their health and education for all of the reasons that I have set out today, and we can see no evidence that this has been properly assessed. After hearing the county roll over this morning, we feel absolutely let down that they are not taking care of our community and our school. The impact is not negligible and our concerns are not unfounded. We urge you to reject this appeal for our children, for our schools and for our community. Thank you.
Thank you, Ms. Alton. Could you just remain there, please? Mr. Strawn, do you have any questions?
No questions, just a reference for the dust management plan. Section 5.2.1 deals with automatic particulate monitoring, not visual inspection.
May I just ask where those monitors are planned? Because they, I'm not, because they.
Strawn can direct things. You can't ask questions.
Okay.
Strawn.
Okay. No. Okay.
Procedurally, you can't ask
But I'm happy to answer. It's in the dust quality plan. It's to be agreed. The precise location is to be agreed with the relevant stakeholders.
Because the primary school's not particularly mentioned, and you're very clear on your dust management plan, as I quoted verbatim from it.
Thank you, Mr. Walton. Thank you. Could I ask Jenny Austin, please, to speak on behalf of Alex Riding? Can just explain who you're speaking on behalf of, and can I? It's probably a little bit unfair because you're not Mr. Ryan, Alex Riding. So in that sense, I'm not going to ask Mr. Strawn to ask you questions on evidence that you've not prepared. You're just delivering a statement on behalf of Alex Riding, I think. So we'll pass on the questions, I think, in this particular case, Mrs. Strawn, for obvious reasons.
Alex was obviously hoping to be here today. And as you can see, I don't have a statement printed out. I just have an email sent because he's unable to attend because of work commitments. He says, unfortunately, I cannot be present at today's proceedings due to work commitments. However, I've requested this statement to be read out on behalf of Cooper Vision's facilities based in Hamble. Cooper Vision continue to stand by our previous concerns which were raised in December 23. These concerns centred around traffic and air pollution. Please allow me to summarise. The Hamble manufacturing shift patterns are 7 a.m. to 7 p.m. and 7 p.m. to 7 a.m. The expectation is employees hand over the role so that manufacturing can continue seamlessly. There is a risk of our employees being caught in a traffic or behind lorries waiting to arrive to the proposed depot. This may result in them being late, which will have a knock-on effect to those leaving. As you can imagine, many of the employees leaving at 7 a.m. hand over parental duties from and to from the other parent at home. The timing of our shift allows them to do the school drop-off and support their own family needs. We also operate a daytime shift, 8:30 in the morning till 4:30 p.m., affecting around 250 of the total employees. Again, the need to be home at a defined time is obviously key to many of our employees. As we are in manufacturing, working from home is not an option for most staff, as we need them on site to operate or maintain the equipment. I know in the plans, no lorry will arrive before the allotted time and no lorry shall go past the quarry entrance. But when one does, the only possible places for an aggregate lorry to turn around will be at the top of Ensign Way or at the fire station. Turning at the top of Ensign Way is tight and likely to block the road, preventing access to our facilities. Turning in the fire station yard could impact their ability to get to a shout, affecting us as well as the local community. My final concern is around the facility. We operate clean manufacturing areas to make the contact lenses. In the proposal, there is little evidence or data indicating the levels of dust generation, how it may be carried on the wind, or the effects that this may have on our air conditioning. Our concern is that an increased level of atmospheric particulate, this would propose a risk to our clean rooms, as well as increasing the need to manage and maintain and change filters, also increasing unnecessary costs to the facilities. Many thanks, Alex. And Alex Riding is EHS Director of Cooper Vision, responsible for EU and speciality business.
Thank you, Ms. Austin. Thank you for that. You can leave the witness table. I know you're going to be coming back later, but you can leave on that particular point. Can I ask Nick Griffiths, please, to come to the witness table? Well, you walk in there, Mr. Griffiths, you can explain who you are, you resident, yes. Assuming an objection, and just confirm to me whether or not you're prepared to answer any questions that Mr. Strong may have.
How do I do this?
Press the button on the right.
Yes, happy to answer questions, and I'm against the appeal.
When you're ready.
Thank you. First and foremost, thank you for the opportunity to speak. My name is Nick Griffith. I'm a long-established marine business leader with over 30 years of experience in the Hamble community. As Managing Director of Ancaster Group and Director of Hamble Yacht Services, I wish to address the significant business impact and employment concerns that the proposed quarry development will have on our thriving local marine industry. Having listened to the opening statements from both the appellant and the Hampshire Council, I'm concerned by the apparent lack of consideration given to the economic impact this development will have on our local businesses. This critical aspect must be thoroughly addressed before any informed decision can be really made. With regard to business impact and employment on the Hamble River industry, the Hamble River has been the centre of UK yachting for over 150 years, developing its reputation due to its proximity to London and the exceptional environment qualities of the area. This has fostered a specialised marine sector comprising numerous independent businesses that collectively form the backbone of the local economy. Our operations alone employ over 95 staff and approximately 50 subcontractors across our various sites. The broader Hamble marine industry employs thousands of people, both locally and from the surrounding areas. The marine industry represents the largest employer in the Hamble River area. Our business success depends on two critical factors that would be directly threatened by the proposed quarry: the pristine environment conditions, essential for attracting the yachting fraternity and maintaining a dust-free environment for yacht maintenance, preparation and finishing. In addition, reliable transport access, necessary for staff, clients and the movement of vessels. The existing traffic congestion along Hamble Lane already represents insurmountable challenges. Hamble Lane has failed to accommodate the increased traffic from residential development over the last 20 years and cannot possibly absorb additional HGVs and heavy equipment vehicles from quarry operations without further disruption. I'm sure that the data that is being collected in good faith. However, having employed 90 people that commute up and down the Hamble Lane every day for the last 25 years, I can assure those reading the data that the data, if it doesn't demonstrate that this two-lane road is overly subscribed, is wrong. The fragility of the current road network was starkly demonstrated within the last past six months when a single incident caused complete gridlock throughout the Hamble village. Some of my staff took 6 hours to get back through, to return to added 6 hours to their commute. And this wasn't an isolated incident. The proposed improvements by the appellant reveal a fundamental misunderstanding of local transport infrastructure or a deliberate attempt to mislead planning authorities. The suggestions of cycle paths and footpaths appear woefully inadequate. For perspective, our staff would face a 2.5 kilometre walk from the nearest train station to our facilities and other businesses much further. Public transport remains an impractical alternative for most employees and the travelling yachting fraternity. Then we move on to operation and economic implications. The current inadequate road infrastructure already adds unsustainable cost of projects that ultimately undermine our competitiveness in the international marine market. The additional pressure from quarry-related heavy traffic would further reduce our operational capacity, decrease employment opportunities due to businesses relocating to more accommodating environments not impacted by the quarry's dust, noise, and general heavy industry feel it would place on the surrounding areas, and would obviously diminish income for the local community, threatening thousands of local jobs. Wider community impact, the Hamble River ecosystem supports numerous marine businesses, including chandleries, sailing clubs, boatyards, yacht maintenance providers, yacht charterers, restaurants, marinas, and hospitality venues that collectively drive the local economy. As both a business leader and someone who enjoys water sports on the river, I can attest that this development threatens the recreational sailing industry through increased traffic disruption, environmental quality through dust pollution and noise, and the historic landscape that makes Hamble attractive to marine tourism and commerce. The absence of a credible economic impact study demonstrates a critical flaw in the application assessment process. Those responsible for evaluating this application appear unequipped to measure the true economic consequences. As a business leader who's lived and breathed this local industry for over 3 decades, I can state unequivocally that this proposal, if allowed to proceed, will jeopardise a thriving, sustainable local industry for a minimal short-term gain. The proposed quarry represents a temporary extraction activity with limited economic benefit to the community, a direct threat to established businesses and provide long-term employment, an irreversible risk to an environmentally sensitive area. Moving on to the future residential development that we assume will follow this quarry development, the longer-term plans to develop the airfield with additional residential housing and no meaningful investment in access infrastructure are fundamentally flawed. As already highlighted, current access infrastructure to the peninsula is woefully inadequate. By any metric, the traffic volume on the single road fails to meet acceptable standards. Before any consideration can be given to increased residential development, planners must address the access issue. To do otherwise would be irresponsible. Have planners commissioned a formal study on the true impact of increased volumes of traffic on Hamble Lane, and was required to bring access up to an acceptable level to accommodate current and future needs? In my capacity as a significant employer and marine industry stakeholder, I strongly urge you to uphold Hampshire County Council's rejection of this proposal. Obviously, this was written before Hampshire County Council announced their acceptance of it. To my knowledge, there exists no precedent for approving a quarry development with so many sensitive receptors in the immediate vicinity. Allowing this development would set a dangerous precedent and cause irreparable harm to the established marine industry in Hamble that has taken generations to build. Thank you.
Thank you, Mr. Griffith. Mr. Strawn, do you have any questions? In which case, can I thank you for your contribution today? Thank you, Mr. Griffith. I'm going to now move on to some of the school pupils. Can I start by asking Max Breeney to come forward, please? I realise this is a probably daunting experience, Max, so well done, first of all, for coming here and sitting there. I'm sure Mr. Strawn, if he has any questions, I'll be mindful of the reason you're here. If you don't want to answer them, that's fine. I don't think he would ask any questions anyway. I'm not going to ask you to represent, because I know that already. So just introduce yourself to the inquiry, and then you can commence and read out your statement. Thank you.
My name is Max Brealey. I am proud to be head boy at the Hamble School. I have lived in the local area for over 10 years, and I am here to defend our local community against the construction of an urban quarry. While I acknowledge that I will be leaving the school soon as a Year 11 student, my younger sister will still be a student here, and I will continue to live in the community after I leave. It deeply troubles me that she will not be able to experience the same school environment as me due to this proposal. The educational impact cannot be overlooked. I have recently completed my mock exams and will soon complete my final GCSEs in the sports hall, which is adjacent to the proposed quarry. Through my personal experience, I have learned that every single noise disrupts our concentration. Therefore, noise from a quarry will undoubtedly mean that we were disturbed. How can we expect students to perform well under those conditions? This will lead to lower outcomes and limit the life chances of students. The Hamble School has provided me with an excellent education, and I have had the privilege of learning from amazing teachers. However, if this quarry is built, I fear that the school will not be able to recruit or retain high-quality staff. Who would want to drive through constant traffic jams, sitting in noise and pollution just to get to work? Who would want to teach in a building that is disrupted by noise and dust, making it difficult to deliver lessons effectively? The consequences of students would be devastating. Every day would be disrupted by noise, dust, and dangerous traffic, making it almost impossible to focus in lessons. The air quality would suffer, leading to potential health problems from students and staff, many of whom already suffer from conditions like asthma. The proposed site is just 45 metres from our examination hall where students sit their important GCSEs. The health risks associated with dust and air pollution are also alarming. As we know, the airborne particulates can cause serious respiratory problems, particularly for children and for those with pre-existing conditions. In fact, many students have already voiced concerns about the quarry proposals in our student survey, where over 90% said the proposed quarry was a worry for them. To provide some context of how close the school is to the site of the proposed quarry, from the entrance to the Hamble School to the airfield, it takes just 90 seconds to walk there at an average pace. The proposed quarry is likely to prove to be a deciding factor in many parents and carers deciding not to send their children to our wonderful school community. This could even force our school to close its doors and end the excellent education it provides to the village and the surrounding area. Hamble cannot be considered for a quarry. You would not build a school next to a quarry, so why build a quarry next to a school? It is clear that the impact will be felt generation after generation. Thank you.
Thank you, Max. Well done. You can return to your seat. Thank you for that. Can I invite Annalisa Kenny? Thank you, Annalisa. Same things apply. Mrs. Strong won't be asking you questions. I'm not even going to ask you. But when you're ready, introduce yourself and commence your presentation, please. If you want a glass of water, by the way, as well, that's a clean glass. So please have a drink if you want one.
Good afternoon. My name is Annalisa Kenneth, and I am a Year 7 child at the Hamble School and a former child at Hamble Primary School. We pride ourselves on achieving excellence together. This is in all aspects of school life. My concern is the traffic. Hamble is already a place with limited accessibility, with only one road in and one road out. We are facing an issue that will seriously affect getting to school. Being on time and good punctuality is very important. If 127 HGVs are added to the roads every day, congestion will only worsen, making us late and impacting our learning. At the moment, school staff patrol the roads around school in the morning and the afternoon, as there are already safety concerns due to the traffic on the road. It will become even more dangerous and time-consuming to get to school. Many students walk or cycle to and around the village and to and from school. How can we continue to do so safely if there are large trucks driving by us every day? The safety of children, staff, and families is at risk. Many of us walk to school or cycle along Hamble Lane, a route already narrow and hazardous in places. Currently, when lorries pass us, it is nerve-wracking and I often fear for the safety of my friends and family. Imagine the risk when 127 heavy goods vehicles are using the same roads every day, especially during the hours we are going to school. The proposed quarry would lead to increased traffic congestion, putting the lives of students, staff, and local residents in danger. I cannot begin to describe the fear I have for the safety of my family and fellow students if this project goes ahead. It is deeply concerning that the proposal would place an industrial site so close to places where children learn and play. The noise, dust, and safety risks are simply too great, and they far outweigh any potential benefits of the quarry. As a student, I want to ensure that the next generation has the same opportunities for education that I have had. I want my peers to be able to learn in a safe, supportive environment where they can focus on their studies and not be distracted. The proposed quarry threatens that future, and we must stand up to protect the children of our community, as this will have an impact on generation after generation. Thank you.
Well done, Annalisa. Thank you for that contribution to the inquiry. Thank you. Can I now invite Martha Hart? Hi, Martha. If you can pull the microphone towards you a little bit, and if you press that right-hand button, the red light should come on. So when you're ready, you can just give us your presentation. So you start when you're ready.
Good afternoon. My name is Martha Hart and I'm in Year 6 at the Hamble Primary School. I'd just like to start by saying thank you for allowing me the opportunity to share my thoughts with you today. The reasons why I feel that the quarry should not go ahead is simple. My friends and I walk or cycle to school every day. Many of us have a road to cross, a road that is already very busy, and 126 lorries will only add to the amount of traffic that there already is at peak times. This will have a huge impact on pupils and teachers getting to school safely. Large lorries on the road are a risk to the safety of me and my friends when we are on our journey to school every day. I also worry about my parents and other people with their businesses that are based in Hamble. They already experience the businesses in the village going about their daily work. In my opinion, the increased traffic will make people think twice about travelling into Hamble for work. If I take school as an example, most of my teachers don't live in Hamble and already have to leave home early to avoid being late for work. This can make it very difficult for Mrs. Hewitt to continue to employ such good teachers that we have today, as people would simply choose to find work elsewhere. It would also impact upon activities that we all enjoy outside of the village. For example, on a Tuesday, I attend my brass band rehearsal at Hedge End. My rehearsal starts at 5 p.m. and we already have to leave at least 45 minutes before to make the start time. With all of these additional vehicles on the road, I'm not sure that it would be ideal for anyone to attend activities outside of the village at these busier times of the day. I am also worried about the impact upon our emergency services. Imagine if there were another incident in the village centre, similar to the terrible house fire that we had next to the village hall. How would the emergency services arrive in time to deal with the situation? Just going back to my friends and teachers at school, for those of you that know the primary school, you will know that it is a very open site. I'm concerned about the high levels of air pollution that will be caused by lorries travelling to and from the quarry, and also from the process of quarrying itself. At school, we are very lucky that we can spend lots of time outside during our PE lessons, forest school, and during break and lunch times. These are times that everyone enjoys at school, but this might have to change as our health will be at risk by these high levels of pollution. I am also very concerned about the issues caused by increased noise level from the quarry and the risks that this will put on people's mental health and stress levels in the local community and in our learning environment. Even though the number of lorries travelling to the quarry has been reduced, I don't feel that this will make a massive difference, as that means that the lorries will have to keep coming for even longer to finish the quarrying, so the health of my friends and family will be at risk for many years to come. I also feel that people will be put off visiting our beautiful village. Some of the businesses like cafes and pubs will be affected and may have to close as people go to other places. I feel very strongly that our local environment and wildlife will be impacted by the quarry. The airfield is a natural haven for wildlife, and all of this will disappear if the quarry is allowed to go ahead. I love taking my dogs to the airfield, listening to the bird songs and enjoying the fresh air. I am also very afraid of the risk of flooding to our village, the impact that the quarry will have on the local land and river, and how this will put our whole community at risk is a big concern for me. I hope you agree that there are so many reasons why the quarry should not be allowed to go ahead. To conclude, please can I remind you of my first point and the risk that the quarry will be to my friends and all of the school children, their families, our teachers and other members of the local community. By allowing this ridiculous proposal, you will be guilty of putting people's lives and livelihoods at risk for many years to come. Thank you very much.
Thank you, Martha. That was excellent. Thank you for your presentation to this inquiry. That's a daunting thing to do, so well done. You can return to your seat now. Thank you. Can I invite Olive Frodley? And if I've got that wrong, can you please correct my name when you come to your name when you come to the table, please? Please take a seat.
It's Oliver.
Oliver.
Actually.
Can you spell the second name?
Fradgley.
Fradgley.
Yes.
Thank you very much indeed. I assume, well, I'm not so sure who's going to be doing little bits here, so I'll leave it in your capable hands. Yes, press the. You've done it. You've got it.
Fantastic, thank you. Thanks so much for letting me and my son Oliver speak today. It has been a long day for him, so he won't be participating. But we had a chat this morning about what we wanted to say and why we were here. So I'll speak on Oliver's behalf. Oliver attends Hamble Early Years Centre, and he has done since he was 7 months old. Bit about me. So I have lived in the Hamble and Netley area for all of my 35 years. My parents moved to Hamble in 1982 from the city centre, and they were really drawn to the green spaces, the beautiful water, and the quietness of the area. So it's with no surprise that when I was able to leave home, I decided to stay within the area. It's not an easy thing for young people to do, but we clawed our way onto the housing market, and we're so happy. And when we decided to have our son Oliver, we knew that when we were settled in the area that it was absolutely the right time. So when me and Oliver chatted this morning after we made our poster, we chatted about what the quarry was, what we enjoyed doing in our local area, and what the quarry would mean to us. So to be very quick, because I'm going to have a grumpy 4-year-old on my hands in a minute, me and Oliver talked about how we love walking to the park, we love the Hamble Quay, we love crabbing in the summer. Oliver loves his garden at the Hamble Early Years Centre. He loves his trips onto the school field in the school holidays. He loves walking down to the train station and getting the bus into Netley to visit the library. So in a nutshell, he loves his wide open spaces, and he probably won't say this right now, but he did want to say that he doesn't like quarries, and that's his contribution. So thanks so much for having us.
Hi Isabel, just take a seat. I've got your name right, haven't I? Isabel Bidwell? Yeah. Thanks ever so much. There's a button on the right hand side, Isabel. If you press that, that red light will come on. When you're ready, you commence.
Hi, my name is Isabel Bidwell. I'm 11 years old and I live on Satchel Lane. I'm currently studying for my GCSEs and I walk across the airfield every single day to get to school, to come home and to walk our dogs. That place isn't just a field to me, it's a part of my everyday life. I've read parts of the CMEX application and what upsets me most is that CMEX has not fully captured the biodiversity within the site. I've seen owls hunting there at dusk. I've heard woodpeckers and watched butterflies and deer. I know there are bats, smooth newts, hedgehogs and slow worms too. They are treated like footnotes in the reports. CMEX hasn't taken biodiversity seriously at all. The quarry is likely to cause permanent loss of the biodiversity as we know it. And then there's school. I already find studying hard sometimes. If the quarry is approved, I'll have to study and revise my GCSEs with the noise outside all day. Dust in the air, lorries reversing. My school is just 110 metres away from the site, and my home is even closer. That means I'll be breathing in dust at school and again at home every single day. But it's not just dust and noise that worries me, it's also the water. Our gardens are often completely sodden, not because of rain, but because of the underground streams running beneath the old airfield. Even when it hasn't rained, the ground stays wet and unusable. If CMEX disturbs the land, removes the top layer, and changes how the water moves underground and across the surface, it's likely to get a lot worse. I really find scary that CMEX hasn't properly calculated what the change in land will do to our garden, our house, or the houses around us. Nobody knows exactly what the quarry will do to us, not just me, but all the children in Hamble. Nobody knows it might affect our health in 10 or 20 years. That makes me feel like we're being experimented on, like our future doesn't matter as much as sand and gravel. The decision doesn't change the land, it changes lives. All I ask that you listen to us, not just the grown-ups, but the children who will grow up with this. We are the ones who will live with the consequences long after the machines are gone. Thank you.
Before I invite Councillor Wallace to the witness table, can I thank all the children who've participated today? That's no mean feat to sit there in a witness table in formal proceedings with barristers all around you and say with such confidence as you did. So thank you for that. I really value your contribution. Thank you. I'm going to take 3 more and then we'll break. So I'm going to ask Councillor Wallace to come to the table. I'll then ask Councillor Crawford and Dr. Thompson, and then we'll take a break. So at that particular point, welcome Councillor Wallace. I'd like you to introduce yourself in a second. Can I ask if you're prepared to answer any questions that Mr. Strong may have? In which case, when you're ready, please commence presentation. The glass is clean as well, should you wish to have any water. Thank you.
So, good afternoon all. My name is Malcolm Wallace and I am the County Councillor for Meon Valley. I'm speaking here today as Meon Valley is a close neighbour to Hamble. You can see from the number of residents who've attended the meeting today and from the numbers who've been protesting outside the strength of feeling of local residents to this proposal. Frankly, anyone who knows the area will attest to the fact that locating a quarry in the Hamble Peninsula is nonsensical. The original application was rejected for 3 reasons. Flooding. The leading local flood authority raised an objection relating to the flood risk from the runoff of surface water, which is inherent to the hydrology of the proposed site. This formed the first of the planning officer's reasons for refusal. However, and in addition, the Habitats Regulation Assessment does not address the impact on the aquifers from the airfield, in particular diversion of groundwater flows. The direct and indirect impacts of planning permissions on our environment cannot continue to be ignored. Our rivers and waterways are suffering, and ignoring these issues again will only make the problems worse. Second reason was obviously the overcapacity on Hamble Lane. the adverse impact of development on the highway network would not be satisfactorily mitigated and the development would not promote sustainable transport modes. Any of us familiar with the area know the capacity issues on the road into the peninsula. And I put the emphasis on the road. It is just one single road, and this is what makes it quite different to a lot of other locations. There is one road that goes in and out of Hamble. I worked in Hamble 20 years ago, and I mean, you would, at the end of the day, you'd look out your window and see if the queue was there before you left work. Because if the queue was there was no point going anywhere. You'd sit there for 2 hours or so because there was an accident somewhere on the single road in and out of Hamble. That can't be modelled on road statistics. So since then, additional housing on the peninsula means that the traffic situation's only got worse. Third reason, of course, was the air quality. You've heard from residents and medical experts about the concerns. I sit on the air quality group at Winchester City Council, so I'm acutely aware of the risks of particulates to our residents. The science around particulates is developing rapidly. There seems to be more research coming out every day about the damage that particulates cause to our bodies. I'll leave it to the more qualified people than me to talk through the details, but suffice to say that locating a gravel pit right beside schools and in the centre of the village introduces a significant risk to the health of our residents that cannot and should not be ignored. But there's another number of other factors that should also be considered. Impact on businesses, you've heard already from a couple of the businesses. I know that the residents group carried out a survey of all the local businesses, and almost half said they would consider relocating should the application be approved. Imagine that, half of the businesses moving out of the area and the impact that would have on the local economy. There's also the impact on trees. We all know there's a need to protect trees from development and that there is regulation in place for this purpose. However, too often we are accepting of the exceptions and allow trees to be sacrificed in the name of development. In this instance, trees will be lost due to the need to provide an entrance to the quarry site. 2 of these are considered ancient or veteran trees, which should be protected under paragraph 180C of the MPPF, which states that development resulting in the loss or deterioration of irreplaceable habitat, such as ancient woodland and ancient or veteran trees, should be refused unless there are wholly exceptional reasons and a suitable compensation strategy exists. The note to the policy defines wholly exceptional circumstances very specifically as infrastructure projects where the public benefit would clearly outweigh the loss or deterioration of habitat. That is not clear in this case. Finally, there's also the supply and demand for sharp sand and gravel. Hampshire has already fulfilled its requirements for sharp sand and gravel, having secured enough supplies through to the mid-2030s, and based upon the Minerals and Waste Plan update, these supplies could be extended to at least 2044 without the need for the Hamble airfield site. In other words, Hampshire has already satisfied national planning policy and its own requirements. Extraction of excess sand and gravel over the targeted supply is not required. The fact that several of the existing sites are currently mothballed further illustrates the fact that the demand is currently below the supply that is available. As you may know, Hampshire declared a climate emergency in 2019, which aligns with the UK government climate targets and a legally binding target to become net zero by 2050. This requires a 50% reduction of carbon emissions by 2030, in only 5 years, and 90% by 2050. As part of achieving UK legal net zero requirements, measures are being taken to reduce both the aggregate and construction industry carbon emissions. These measures include reducing the need for sand and gravel in coming years. Taking these points together, it's clear that the proposed quarry at Hamble Airfield is unnecessary to meet Hampshire County Council's supply requirements and is contrary to meeting the challenges of climate change. In summary, the proposed quarry at Hamble Airfield does not align with national Hampshire policy, and therefore this appeal should be refused. Thank you.
Thank you, Councillor Wallace. Mr. Strong, do you have any questions for Councillor Wallace?
No, thank you, sir.
Thank you for your contribution, Councillor Wallace. Can I invite Councillor Crawford, please? Councillor Crawford, I have a copy of your speaking note that you kindly provided to him. forgot your name, to the council this lunchtime. So I'll record this speaking note as inquiry document 6, I think. Let me just check my notes. Inquiry document 6. Just before you introduce yourself, Mr. Strong may have some questions. Would you be prepared to answer those questions?
Yes.
In which case, please commence your presentation when you're ready.
Yeah. Thank you. Good afternoon, Inspector. My name is Alex Crawford. I represent Aldershot North on Hampshire County Council. I'm here to present my concerns regarding CMEX's appeal to have a quarry at Hamble in the south of the county. When we saw the extraordinary application to have a quarry right in the middle of this lovely Hampshire village, my wife and I were so concerned that we drove down to Hamble. We walked around the site, we visited nearby housing and schools, and we spoke to local residents and businesses. I have come here today to address the critical issue of sustainable development, which we know to be the core principle underpinning planning. At the heart of sustainable development is the simple yet profound idea of ensuring a better quality of life for everyone, both now and for the future generations. In this case, those most affected are the residents of Hamble and those who have their businesses there. CMEX has failed to engage with the local community. This lack of engagement is deeply concerning. It is also contrary to the claims made on their website. They state CMEX has a long-standing reputation of operating its sites safely and effectively across the UK. We have an excellent track record of playing an active role within local communities. Despite these claims, CMEX's actions tell a different story. Throughout the past 2 years, the Hamble community has expressed widespread opposition to their planning application for the quarry, fearing the adverse impact on their quality of life now and for many years to come. CMEX claims to recognise the intrinsic value of nature and the importance of conserving biodiversity, ecosystems, and ecosystem services to allow for the sustainable development of society. Yet, they are going ahead with this appeal despite the clear and vocal concerns of Hamble residents and businesses about these crucial factors. I would hope that you, Inspector, will hold CMEX accountable for their stated commitments, which would have meant genuinely engaging with the Hamble community, accepting their concerns and prioritising their quality of life, both now and the future, by withdrawing this appeal. In conclusion, I would respectfully ask you to highlight the principles of sustainable development and to listen to the voices of the people of Hamble and the businesses that thrive in the clean, fresh environment in and around this lovely Hampshire village. Thank you, Inspector.
Mr. Strawn, do you have any questions of Councillor Crawford?
No, thank you.
In which case, Councillor Crawford, thank you for your contribution to this inquiry. The last person before we take a break is Dr. Thompson. Same question, Dr. Thompson, if you can just remind us whether you're in support or opposition, and also tell me if you're prepared to accept, deal with any questions that Mr. Strawn may ask.
In opposition, and questions accepted.
Whenever you're ready.
I am Dr. Mark Thompson, Senior Partner at Blackthorn Health Centre. I represent a body of over 18,000 patients from the villages of Hamble, Netley and Burlesdon. I've been a GP at Blackthorn Health Centre for 34 years and have lived in the village for 32 years. I therefore feel I'm in a position to speak with some authority about the health of this village. I'm no Professor Holgate, but I am an experienced GP. I will mention some patients, but of course their names have been changed. As doctors, we know our community faces significant health challenges like all others. We are not exceptional in any way, but within our community we have 2,500 patients with respiratory conditions, 3,400 with heart disease, and 1,500 with mental health challenges. We're being asked to accept a 10 to 15 year operation that will raise levels of nitrogen oxides and particulate matter in the community. We already live in an area that has been identified as having poor air quality, the Clean Air South report. As mentioned already, the quarry will increase dangerous particulates, especially PM10 and PM2.5. These are tiny and invisible to the naked eye and small enough to enter the human system and lung alveoli. This is where oxygen exchange takes place. These particulates are proven to trigger asthma, COPD, and impair lung development in children. The World Health Organization state there is no safe level for these particulates, so surely increasing it is a worry for all concerned. Our main practice is on Satchel Lane, less than 500 metres from the edge of the potential quarry. We have a footfall of at least 200 people a day at this site. The Hamble School, the Hamble Early Years Centre are within 150 metres. The Hamble Primary School, which CMEX didn't identify as a centre receptor, is within 160 metres. It was clear to us previously that we as medical professionals should speak out against the development of this quarry, and so we have written on 4 separate occasions to object to this proposal. Yet our objections have been dismissed, with the impact being described as negligible by CMEX, the planning officer acting on behalf of HCC, and at the regulatory committee where health concerns were ignored. We simply do not understand how this conclusion has been reached. The failure to undertake air quality monitoring close to the quarry and at the most sensitive receptors, including the Hamble School and preschool, as well as the houses on all 4 sides, is incredibly alarming and undermines all other evidence relating to this site. Instead, they rely on data from the results of monitoring the air quality annual status reports undertaken by Eastleigh Borough Council, background pollutant concentration maps published by DEFRA. They rely on predominant wind direction, when we know Hamble is a peninsula and the wind can change regularly. Besides, predominant does not mean always. As the only local GP practice, we have not been specifically asked for our expertise on how this might impact our patients. Documentation provided by CMEX consistently suggests that the impact of their proposals will be negligible. However, as health professionals, we remain extremely concerned about the short and long-term implications upon our patients' health and the well-being of the wider community, and our concerns are not unfounded. Exposure to these particulates can cause inflammation and irritation in the alveoli, thickening of alveolar walls, reducing oxygen intake, impaired lung growth leading to permanently reduced lung function, greater risk of asthma, bronchitis and respiratory infection, toxic particles entering the bloodstream impacting heart and brain development. Children are particularly vulnerable to air pollution because their lungs and immune systems are still developing. They breathe more rapidly and spend more time outdoors. Their exposure per body weight is higher than adults. The damage can be long-lasting with effects that persist into adulthood. There is no safe level of exposure for children who are part of the group identified as sensitive receptors by CMEX. Timothy is a 13-year-old boy with severe and brittle asthma. This means he has a severe medical condition which can deteriorate rapidly. This could be caused by a viral illness or poor air quality. Timothy has several inhalers to help him manage his condition and lead as near a normal life as other teenagers. He uses his inhalers diligently and sensibly in order to manage his condition, and in addition, he has a nebulizer at home. Despite his careful and appropriate use of his prescribed medication and regular ongoing professional reviews, Timothy has had several previous admissions to hospital, which have required intravenous steroids and intensive treatment. Can CMEX please explain how they know that particulates from the quarry will have a negligible impact on Timothy's health and how he will not be adversely affected by this gravel quarry? From my understanding, I don't believe CMEX can evidence this, as they, despite making insurances to the planning authorities to the contrary, have no experience of managing a quarry this close to so many sensitive receptors anywhere in the country. Professor Holgate, a world-renowned respiratory specialist, has explained in no uncertain terms the world-leading research that he and others have undertaken on air pollution. This shows that no amount of increased air pollution is acceptable to the lungs, and it is simply not acceptable to ignore his groundbreaking research on this matter. Let me show another patient, Mildred, a 73-year-old lady with COPD. Like Timothy, Mildred also has inhalers to manage her condition. As her condition is severe, in addition to her inhalers, Mildred has a portable oxygen supply with her wherever she goes, and also an oxygen concentrator at home. To allow her to leave her home and engage in the community, Mildred uses a mobility scooter. In conjunction with her portable oxygen tank, this allows her to live her life to the fullest extent possible, enabling her to get out into the community, which is incredibly important for her physical and mental health. Again, can CEMEX please explain how they know that particulates from the quarry will have a negligible impact on Mildred's health and how she will not be adversely affected by these gravel pits? The adverse health impacts of these particulates extend further to include neurological and cognitive impairments, such as cognitive decline, dementia, anxiety, depression, ADHD, and schizophrenia, as well as negative outcomes for eye health, digestive health, liver function, and reproductive health. The loss of green space and increased noise from additional HGV traffic further compound these issues. In a community already suffering after the aftermath of SARS-CoV-2, worsening seasonal respiratory viruses, and a re-emergence of respiratory syncytial virus, any additional burden from a quarry is intolerable. My final patient is Fred. Fred is a 63-year-old ex-military veteran with post-traumatic stress disorder. As a result of his military service, Fred's PTSD means that he struggles with people in crowded places. As part of his strategy for managing his condition, Fred has recently got a dog to help him, and he regularly walks his dog on the former airfield, something that everyone in the community knows the landowner has turned a blind eye to over many years. These regular daily walks that Fred takes with his dog on the former airfield are amazingly therapeutic for him and a key part of his self-help to manage his PTSD. This, of course, will be taken away from him for the foreseeable future, should this appeal be granted, and sadly, no doubt his mental health will suffer. I've mentioned these three patients in particular, as they are the ones that immediately come to my mind. However, there are many, many more patients who will suffer as a result of this gravel pit, should you be minded to ignore the sensible objections of this community that are being set out to you. The impact of increased HGV traffic on the Hamble Road network is concerning, as ambulances already find it hard to get to the village. We question how an ambulance would get through if it encountered two gravel lorries side by side when the road is congestion. A scenario that is not hypothetical, as ambulances are called to the village almost daily. Hamble Lane is very narrow and a gravel lorry would struggle to negotiate the pavement, especially in the presence of children. This could result in delays that might prove fatal. Like the police and fire brigade, we are not scaremongering, we are providing a fair warning of this potentially catastrophic consequences of your decision. In conclusion, the cumulative evidence from patient demographics, clinical outcomes through the stringent, albeit interim DEFRA PM 2.5 planning targets, and the stark warning of the SRI Civic Clean Air Report to the expert testimony of Professor Sir Stephen Holgate leaves no doubt that the health risks associated with this proposal are too great. Shouldn't it be up to CEMEX to demonstrate beyond reasonable doubt that they will not harm the health of our community? We urge you to reject the CEMEX appeal. The future health of the Hamble Peninsula residents must be prioritised, and we cannot, in good conscience, stand by silently while a development that endangers the physical and mental well-being of our community is allowed to proceed. On behalf of Blackthorn Health Centre, our doctors, staff and patients, thank you for your attention.
Just remain there a moment, Dr. Thompson. Mr. Strong, do you have any questions, Dr. Thompson?
No, I'll just repeat the references I gave earlier to Professor Holgate if Dr. Thompson's interested in them.
Okay. In which case, can I thank you for your contribution, Dr. Thompson? Thank you for that. It's 21 minutes past 3 now. We're about a third of the way through, so I'm conscious that we need to speed up a little bit. I'm going to take a break in a moment. During that break, I know there's lots of people who want to speak and you want to say lots of things, but just think about what I said earlier this morning about not repeating things that we've already heard if possible, and just be mindful of where we are on time, because I will try to get through everyone today, but to be fair to everyone as well, we do need to think about a cut-off around about 5:30. So just have a little think about that during lunchtime, and then during the break time, and I'll continue to go through the list as we go through today. All right, so it's 15:22. If we can come back in this room for 15:35, that's just over 15 minutes, so you've got a chance to stretch your legs and have a drink if you wish. We'll adjourn at that point, 15:35. same things, Ms Hillman, if you can just state whether you support or objection and whether or not you're prepared to answer any questions that Mrs Strawn may have with you.
Please could I give you 2 diagrams because I had to refer to them in my speech.
Can you give them to, how many copies do you have?
As well. I've got 5 of each.
Is that something you could you stand these out, Amy, if you wouldn't mind? If you could just give one to the appellant, the council and the Rule 6 party, and then one for myself, if that's okay. Well, that's been done. Could you perhaps introduce yourself to save some time?
Yeah. So my name is Vicky Hillman. I live in Hamble with my 2 young children. I'm a biologist and I'm partway through a PhD in computational virology, just for a little context to the analysis that I've carried out myself. Shall I begin?
Yeah, just wait one moment. Do we have... I'm missing a copy. Can you pinch their copy? No, pinch that one. It's all right. Thanks so much. Thank you.
Thank you. Mr Normington, members of the inquiry, representatives of Hampshire County Council and CEMEX. I'm here today because CEMEX refuses to accept the legitimate rejection of its planning application for gravel extraction at Hamble Airfield. I'm deeply concerned about the health implications of this proposal, so today I will focus on air quality, a critical issue astonishingly overlooked by Hampshire County Council as a reason for refusal, despite compelling evidence. This included expert testimony, as we've heard today, and at the previous session, from Professor Sir Stephen Holgate, one of the UK's leading authorities on air pollution and its health effects. Ignoring this evidence undermines science, public health, and the trust of this community. So we ask with complete disbelief, how could air quality be excluded as a reason for refusal when the county has a duty to protect residents from harmful pollution? If this appeal is approved, it will set a dangerous precedent, one that sacrifices public health for industrial convenience. I understand the environmental impact has been reassessed. Has this been done on new information provided by the appellant, or have their previous submissions been taken at face value without question? Mr Normington, it's important you have a clear picture of the environmental challenges currently facing Hamble, as this is the backdrop to CEMEX's proposals. Hamble doesn't start from a clean slate. We're at the forefront of an air quality crisis. A 2024 report by Transport and Environment named Southampton as one of the UK's most polluted port cities. Emissions from cruise ships alone exceed those of all the city's cars combined. These pollutants, nitrogen oxides and particulate matter, they don't stay localised. They disperse into surrounding areas, including Hamble, which lies directly in their path. In January this year, the University of Southampton published their Clean Air South study, confirming dangerously high pollution levels in the central south. Hamble ranks among the worst areas for air quality in the region, aligning with concerns residents have repeatedly raised during the CEMEX inquiry. If you can just take a few seconds to look at the map that I provided. This is taken directly from the Clean Air South study, and you can see here that Hamble sits directly in the red. It is the worst area for pollution in the central south, along with central Portsmouth and the central part of the city of Southampton. The combined impact of shipping emissions, traffic congestion and industrial activity routinely pushes Southampton's PM 2.5 levels beyond safe limits. Both the environmental impact assessment and the air quality assessment commissioned by CEMEX completely ignores this broader context. They narrowly model emissions from the site and access roads without considering the cumulative pollution burden we already live under. This is a serious oversight. Adding quarry dust and HGV traffic to an already overburdened area isn't just careless, it's dangerous. While the Clean Air South report was only published this year, CEMEX cannot claim ignorance. My own inquiry submission included published DEFRA data comparing background pollution across their UK extraction sites. Hamble emerged as an alarming outlier with combined PM2.5 and nitrogen dioxide levels comparable to those near the M4 corridor in Heathrow, and the nitrogen dioxide levels were the highest of any site assessed. CEMEX claim experience managing similar sites, yet their UK portfolio lacks any sites with such severe existing background pollution. In fact, their Reg 25 response confirms they don't even monitor PM10 or PM2.5 at what they term comparable sites. If you can look at the second chart that I've provided, this formed part of my inquiry submission. I've now annotated it with the sites that CEMEX claim to be comparable. They are not comparable. Hamble sits in the top right quadrant, where both NO2 and PM2.5 exceed UK averages by some margin. Their comparable sites sit in the lower left quadrant, well under UK averages. The excessively polluted backdrop to this application amplifies the problem with CEMEX's results. Their baseline calculations downplay real risk by hiding behind percentages that make dangerous increases look statistically minor. This is modelling by convenience, not caution. How can they confidently claim their operations will have a negligible impact? Looking at CEMEX's dust modelling, they rely upon the IAQM 2016 guidance, an entirely qualitative approach that discourages dispersion modelling due to insufficient UK emissions data. But even the IAQM stresses the need for professional judgment and adaptation to site-specific conditions. CEMEX have made no adaptations, and Hampshire County Council accepted this at face value. A peer-reviewed 2021 paper by Dr. John Bruce of DustScan found that IAQM's risk-based methods often underpredict real-world dust impacts, especially in sensitive settings. Generic emission factors don't align with monitored data unless adjusted using local evidence for weather and source emissions. CEMEX have collected no site-specific emissions or meteorological data for Hamble Airfield. In fact, they have carried out no dispersion modelling of PM10 or PM2.5, no worst-case scenario testing, and no monitoring of re-entrained dust from dry surfaces. Their dust management plan relies on a single particulate monitor, location unknown, which will begin operation just before extraction starts. There is to be no directional or perimeter monitoring, and daily dust checks will be visual, carried out by the quarry manager, who of course has a vested interest in maintaining operations. I know, Mr. Strawn, you dismissed this after it was brought up by Mr. Walton earlier, but this is what it says in the dust management plan, section 5.1.2. And let's not forget, those most dangerous particles, PM2.5, are invisible. This is not precautionary. It's outdated and irresponsible. The forthcoming IAQM guidance reflects the need for more rigorous modelling and greater emphasis on PM2.5 and respirable crystalline silica. The IAQM acknowledges flaws in current guidance, yet CEMEX hasn't addressed them. Where is there evidence that experts assessed whether outdated models are safe for a site this close to 2 schools and a preschool? Waiting for new rules when the risk is already clear defies common sense. In October 2024, DEFRA issued new planning guidance requiring developers to reduce PM2.5 exposure at the planning stage and not just avoid legal thresholds. While this interim guidance isn't mandatory for older applications, the science behind it still matters. Ignoring it because of timing is a choice, one that prioritised process over prevention. Under this new framework, CEMEX's application fails in multiple areas. They didn't assess PM2.5 exposure in site selection. Hamble's 2 schools, just 160 metres from the site, weren't even considered. They proposed no enclosed routes, no advanced dust suppression, and no meaningful barriers. They ignored regional pollution from the port and traffic, dismissing the high background levels or worse, using it to their advantage to mask percentage increases. This is not forward-thinking planning, it's avoidance. The failure to assess health impacts on children is especially appalling. PM2.5, as we've already heard today, has no safe limit, especially for children with developing lungs, yet there's been no child-specific risk assessment, despite the site's proximity to 2 schools. In fact, Hamble Primary School wasn't included in the dust management plan because it lies outside the arbitrary modelling boundary. That's not a technical oversight, it's a moral failure. The UK Health Security Agency also raised these concerns. They were acknowledged by CEMEX and then offered no response. There is no other site in the UK where a quarry has approved this close to not 1 but 2 schools. Are we really prepared to make Hamble the first? Turning briefly to traffic emissions, CEMEX's transport assessment contains serious gaps and misrepresentations, particularly around HGV movements. They claim emissions from transport will be negligible. They estimate 126 HGV movements daily along Hamble Lane, a narrow residential B road already plagued by potholes, congestion and daily tailbacks. The northern stretch is already designated an air quality management area, and I see daily this capacity at breaking point. Yet, CEMEX's modelling assumes free-flowing traffic and completely ignores idling. I asked CEMEX's consultant Bob Thompson to clarify the approach regarding congestion modelling back in May last year, but I did not receive a response. It's well established that HGV emissions are significantly higher while idling, and that stop-start acceleration dramatically increases particulate emissions from tyres and brakes. This is not accounted for in their model, despite the issue being raised during the consultation. Using data from the Transport Research Laboratory, we can estimate that a single 20-tonne HGV emits more CO2 in 1 minute of idling than driving the full 5-kilometre stretch of Hamble Lane at 30 miles an hour. Multiply that by 126 movements daily, and these emissions become significant, not negligible. This means congestion and idling are not minor factors. They're central to understanding the air quality impact. Ignoring them is a major modelling failure. It underestimates real impacts and misleads decision makers. It's a critical failure in assessing the real impact on air quality. The final and perhaps overarching issue is uncertainty. CEMEX repeatedly conclude their operations will have a negligible impact on air quality, but that conclusion is based on models built on flawed data, incomplete assumptions, and a refusal to account for local realities. If the models are flawed, the conclusions are worthless. That is the basic premise of any model. This application is riddled with uncertainty and the evidence is overwhelming. Hamble already suffers from dangerously high air pollution levels. The cumulative effect of major regional pollution sources has been downplayed. Hamble Lane infamously congested, yet the effects of idling are ignored. Children's respiratory physiology has been ignored, even though two schools flank the site. New DEFRA guidance is ignored, and at a wider level, the UK Environment Act 2021 demands a proactive stance, yet this quarry does the opposite. This is not just a planning matter, nor, as Mr. Strawn suggested at the beginning of this session, is it the inability of a community to be objective. Instead, it is a public health crisis in the making. Mr. Normington, whilst this increasingly feels like a David versus Goliath situation, we're not asking for special treatment. We're asking for protection for our air, for our environment, and above all, for our children. We ask you to stand with the science, with precaution and the spirit of the law. Please reject this appeal.
Strawn, do you have any questions?
Sorry, just a really point of clarification, Ms. Hellman, you explain you're a biologist. I don't think you're on air quality.
I'm not an air quality specialist, no.
Oh, okay,
No.
thank you. And you referred to a number of times CEMEX's assessments, but I gave a list of references.
Mm-hmm.
I don't want to repeat them again unless unnecessary, but if you want me to, I can point you to them. I mean, they include, for example, one of the references you mentioned a moment ago, a response to the UKHSA, because I think you were saying there wasn't a response to it.
It was a very dismissive response, I should clarify.
Well, I'll let the inspector judge that, but it's, I think it's B, I've lost it now, B44 or 57, B57, CD B57. A dismissive response of 14 pages.
Yeah.
Thank you very much.
Thank you.
I'll record those documents in inquiry, so maps. So we'll those as inquiry document 8, inquiry document 9. Can I invite Christian Walton? Why have I got you on my list twice, Mr. Walton? That helps. Hannah Craggs. you okay to answer any questions that might be asked? In which case, introduce yourself to the inquiry, please.
I'm Hannah Craggs and I'm the Chair of Governors at the Hamble School. I have made a couple of adaptations to try not to be too repetitive, so apology if this doesn't run as smoothly as I had planned. So for context, I'm representing the schools and education providers in Hamble. This includes the Hamble School, Hamble Primary School and Hamble Early Years. The school catchment includes Hamble, Netley, Hound, Lowford, Bursledon and further afield. In the years the proposed quarry may be in operation, over 4,600 students will pass through the school, and we forecast that approximately 30% of these students will have special educational needs and disabilities. We do have significant concerns about the impact of the proposed quarry in relation to the traffic, air and noise pollution, as you've heard from other representatives today. The Hamble School has, in line with government policy, breakfast clubs from 7:30 a.m. and after-school extracurricular clubs often running until 4:30 p.m. Hamble Early Years Childcare is at the entrance to our site and is open from 7:30 a.m. until 6 p.m. There is also a very active sports centre which is used by the community, with over 1,100 people accessing the centre on a daily basis, many of whom are attending clubs such as swimming, gymnastics and outdoor sports on the adjacent pitches. There is no safe time for a large number of HGVs to be transporting material to or from a proposed quarry next to our school, and the CEMEX claims that the community concerns regarding the impact on Hamble Lane are unfounded is simply not true. We have lived experience of traffic issues getting to and from school. Students at both schools enjoy time outside, using the exceptional facilities during lesson time, at break time and lunchtime, and before and after school. We know that young lungs are more susceptible to respiratory issues. The increase in dust and decrease in air quality will cause long-term irreversible damage. We are directly downwind of the proposed site, and a significant number of our students and staff have pre-existing respiratory conditions such as asthma, which will impact their breathing. In a national retention and recruitment crisis, there are founded concerns regarding staffing within the school. The Hamble School is currently a highly successful and inclusive secondary school. If the quarry were to go ahead, the reality is that lessons will be disrupted because of noise and outcomes could decline, impacting on the life chances of a generation of young people. This will also have an impact on the working conditions of all staff, therefore, impact on their mental health and well-being. As we know, it will only be 50 metres away from one side of the school. It is for me unbelievable that this proposal is even being considered. Students' learning will be impacted by additional noise and the quality of teaching within lessons will be disrupted. The quarry site would be adjacent to the school examinations hall, the only facility that we have that we can use. It will of course be noisy and students will be distracted during examinations. The examinations take place all year round, but particularly in the summer during the main GCSE season. At this point, we won't be able to open the windows or the doors so that we reduce distractions for them, and we need to do that to support ventilation. This remains a fundamental concern for student outcomes and their future life chances. The changing context within schools means an increase in students who have special educational needs or disabilities. This plan is unacceptable for all children within the community, but where is the protection for the most vulnerable students? And this leads me on to my next point. Both the Hamble School and Primary School are currently establishing resourced provision for 15 students on our site with autism spectrum conditions, and this is aiming to open in September 2026. There are currently no autism spectrum conditions resource provisions of secondary age students in Eastleigh, and therefore this would support children who need that specialist provision. As Chair of Governors, I cannot see how the children will not be negatively impacted. We have tried to engage with CEMEX over the last year and have contacted them on several occasions as they claim to want to be good neighbours on their website. They have failed to respond on at least 3 occasions and only 2 weeks ago responded. We asked for a meeting with them so that our children and staff could ask them some questions, but unfortunately they replied yesterday saying they were too busy. To conclude, we believe that the viability of all 3 educational institutions plus community facilities are under threat from the unacceptable proposal to build a quarry right next to a school. As Oscar Hill, our former head student, said last year, you would not build a school next to a quarry, so why would you build a quarry next to a school? Our stance has not changed. Hamble is the wrong location for a quarry, and we must prioritise the well-being of our children, staff and community over industrial development. I would ask the Inspector and all those in attendance not to underestimate the knowledge, understanding and opinions of the children in our community and the importance of their voice. At the Hamble School and Hamble Primary School, we teach students about the importance of British values and the rights of the child. Therefore, today, I'm proud of the children from our community that have shared with you some of their concerns. It is clear that the proposed quarry threatens their future and will have a negative impact on generation after generation. Thank you.
No, thank you, sir.
In which case, can I thank you for your contribution? Can I invite Lindsay McClay? Can I just confirm it's McClay?
It is McClay.
Thank
McClay
you.
with a Y.
Were you prepared to answer my questions?
Yes.
Thank you. In which case, please commence when you're ready.
No worries. I am Lindsay McClay. I am the chairperson of British Marine South and the Isle of Wight. I'm speaking on behalf of the marine business community in Hamble, and we wish to express our strong opposition to the proposed development of the quarry at the former Hamble airfield site by CEMEX. The River Hamble is home to a high density of marine-related businesses, training providers, marinas and service yards, and an estimated 60 to 70% of businesses in Hamble are directly or indirectly connected to the marine industry, contributing significantly to both the regional and national economy. Hamble Point Marina alone accommodates over 50 marine-focused tenants, offering everything from specialist rigging and engineering to charter operations and professional services. The viability of this economic ecosystem is inextricably linked to a stable, functional and resilient coastal environment. This was brought to a sharp focus during the severe flood event at Hamble Point Marina in January 2024. Which caused serious disruption to operations, damage to infrastructure and financial loss across a range of businesses. While precise monetary figures have not been disclosed, MDL, who managed the site, confirmed that Hamble Point was the worst affected amongst their south coast locations. Electrical substations were submerged, power had to be shut down for safety and recovery took considerable time and resource. This event was not an anomaly, but a sign of an increasing risk factor facing our coastal infrastructure. The proposed quarry presents an unacceptable and avoidable risk to an already vulnerable area. This site sits immediately upstream of key marine infrastructure and introduces the prospect of increased surface water runoff, soil disruption, and changes to the natural drainage patterns. Hampshire's own lead local flood authority has previously raised objections to the adequacy of the applicant's revised drainage and restoration proposals. It is our position that any activity that could cause an increased risk of further flood incidents, in this particular instance industrial excavation, is too great a risk to be justified. Whilst we recognise the importance of sourcing construction materials, this must be balanced against the long-term protection of the established local economy and community. As what is the point of acquiring minerals to build new houses and infrastructure if you end up undermining the stability and existence of the current infrastructure along the way? The Hamble marine industry provides skilled employment, apprenticeships, exports, tourism, all of which are jeopardised by infrastructure risk and environmental instability. We respectfully urge the Planning Inspectorate to uphold the decision made by Hampshire County Council in May to refuse this application. The flood risks presented by this development are not speculative, they are evidenced by recent events. When large companies prioritise profits over the well-being of individuals, it is the people who ultimately bear the consequences. We thank you for considering the views of British Marine and the marine business community we represent.
No further questions. Thank you. Can I invite Lisa Rochford, please? Is the battery going? Same issues, if you can use yourself, and would you be prepared to answer any questions? In which case, when you're ready. It should work if you press the right hand button, it should come in red. There you go.
Thank you, sir, for giving me the opportunity to speak today. Today I represent the 3 Hamble maritime clubs, my own club, the Royal Southern Yacht Club, the Royal Airfield Club. I am a resident of a resilient maritime village, but today I must speak plainly. The proposed quarry does not simply threaten inconvenience, it poses an existential threat to our community and clubs. Our clubs, each with their own distinct character, are volunteer-led member clubs. They rely on access through Hamble Lane, on income from membership, regattas, racing moorings, events, accommodation and hospitality. Together, these elements form the fragile economic backbone of our clubs. We are at the centre of village life. Our clubs and members support other marine and general businesses. Insert a quarry, no matter how it is run, into the heart of this village, and that delicate balance is broken. The clubs already operate on the narrowest of margins. Many Solent yacht clubs are currently in financial distress, including Royal clubs. Even a single figure reduction in percentage of our income could mean that their clubs are fatally damaged. The Royal Southern Yacht Club alone employs 50 to 60 staff during the season. Our clubs are event-driven both onshore and offshore. Our guests arrive predominantly by road. If traffic becomes intolerable and less safe, if access is hindered, if dust begins to settle on vessels that require costly maintenance, people will go elsewhere. Over 80% of the Southern's members live outside SO31. Anyone who lives here knows what one minor breakdown or poorly timed light can do to Hamble Lane. The road surface barely holds together. Add quarry trucks to the equation and we are gridlocked literally and economically. The suggestion that Hamble Lane is already congested and that the extra heavy-duty traffic will not make any difference is, in our view, unsupportable and shows complete disregard for the quality of life for ordinary people. In the same words used in the appellant solicitor's opening statement, it is disrespectful. Membership income is critical to the clubs, and as a result of longer journey time, members may not renew their membership and recruitment becomes more difficult. Longer travel time means that engagement at our open events becomes more difficult for crew who wish to join yachts moored in Hamble marinas or bring their dinghies to compete in events. RYA training centres become less attractive in Hamble. Our suppliers find it harder to deliver, employees will have a longer commute. The proposed quarry will produce fine abrasives less than 150 metres from a marina, which, especially in a consistently windy environment, will pose serious problems. Boat owners on the Hamble generally will face increased maintenance costs. Boats may be moved to alternative locations. There are currently in excess of 3,000 boats on the river. Fine particles have the capacity to cause considerable damage to the electronics, mechanics and other technical systems of vessels. Little or no consideration appears to have been given to the impact of fine abrasives from a quarry on vessels, including gel coat damage. The dust management response, which has already been referred to, relies heavily on the bun. There is a lack of acceptance that PM10 and 2.5 particles travel further than 100 metres. There is a lack of current assessment of existing dust levels and lack of knowledge of prevailing wind conditions. Visual assessment, as you have already clearly heard, is not adequate as PM10 and 2.5 are not visible to the naked eye. My understanding is that the response states that for one-off blips, 350% higher than legal levels is acceptable. The low-lying yacht clubs, as you've already heard, are potentially vulnerable to flooding issues caused by the quarry. The village would experience additional safety concerns, re-access for emergency service and police, and specifically for casualties evacuated from the Solent. There are many potential sites for quarries, but there can be few, if any, with so many sensitive receptors surrounding the site. I leave the technicalities of the appeal grounds to others, but I would simply comment that it is surprising that CMEX, with its legal expertise and unlimited funds, were not able to identify and address the issues which led to the planning permission refusal. But now, with additional engagement and information, they assert that the grounds for refusal are no longer valid. To those of us who live and work in the village and commute from the village, the idea that putting 120 plus extra HGVs a day on Hamble Lane is not going to negatively impact an already congested road and its safety is, to be frank, almost unbelievable. When representations are made by experts or the applicant concerning these matters, I would say come and live in Hamble, come and see what happens when a minor incident occurs. And we are effectively trapped on or off the peninsula, sometimes for all of the day, and we all are having to revert to Facebook to see how we can get in or out of our village. For the applicants to suggest that the mitigation that they are offering is mitigation in the real world is not credible. The traffic increase will not be negligible, whatever the protocols relied upon. As major businesses in Hamble, we must assert our concerns about the risk to business. CMEX have pointed to a handful of jobs created. It is a question of whether Hamble really is a suitable location to source the materials. Currently, Hamble businesses all find that recruitment is a common and growing problem. Traffic congestion is commonly cited as the primary cause. The test for refusing a proposal, i.e. determining if an impact is severe based on the percentage increase in traffic, or HGVs, is wholly inadequate to reflect the local circumstances in Hamble and surrounding areas. As you have already heard, as traffic is regularly at capacity, small increases in traffic have significant impacts on travel time, making journeys long and unpredictable, and more idling traffic means more pollution. Any worsening congestion will make our businesses harder to operate, put off customers, members and visitors, and make it even harder for us to recruit. Do your surveys, tell us that you're compliant in your applications, but the sad truth is that the community doesn't really recognise the outcome of these presentations. Of particular concern to the yacht club members and all river users is the adverse impact upon the peaceful and visual enjoyment of the Hamble River and the degradation risk to the river and thousands of boats arising from the potential environmental hazard of washed aggregate runoff, flooding and subsequent bleaching of infill waste disposal, light, dust and noise pollution. As hospitality and leisure businesses, we are extremely vulnerable to any harm to both the accessibility and quality of our space. We have a unique location. It is said that the gravel extraction is temporary, but the impact on businesses could be quick and long-lasting, and the gravel extraction could be extended. The leisure and hospitality sectors are particularly vulnerable in the current environment. It is considered that the applicant has not demonstrated that the benefits in this case outweigh the harm. The clubs share many of the concerns of the community, including transport traffic, flooding risk, health concerns relating to both traffic and the proximity of the schools and the health centre. We too are extremely disappointed that neither HCC planning nor the regulatory committee saw fit to object based on concerns about health and air quality. This was particularly surprising given the expert testimony at the original hearing from the Blackthorn Health Centre, the school's representatives and Professor Stephen Holgate, who you've heard from today. If the quarry were to proceed, our children would grow up in its shadow. And I wouldn't put good money on many of us here today, including myself, outliving this quarry. CEMEX are known for extending the life of their quarries. We ask, if Hamble becomes even more inaccessible and loses its tranquility and character, will classes still want to use our facility for their regattas when 150 boats have to come down Hamble Lane? Would you choose to locate yourselves or your boat at our clubs? In Measure for Measure, Shakespeare wrote, "It is excellent to have a giant's strength, but it is tyrannous to use it like a giant." The power to approve this quarry may exist, but the moral responsibility lies in how that power is used. This is not just a policy issue, it is a moral issue, a question of right and wrong. To suggest that a quarry belongs in the heart of our village is to defy not just logic but natural justice. I would say respectfully that it insults our shared intelligence. Our community, which has mobilised with reason, evidence and civility, is told that we do not understand. But we understand more than enough. Hamble is not a generic postcode on a planning map. It is a living village with maritime heritage that draws sailors and dreamers from across the globe. People arrive and feel something that cannot be measured in permits or profit margins. Lose that and you lose more than boats. The yacht and sailing clubs are not a luxury. They are places where young people learn to sail, where para-athletes find freedom on the water, where we celebrate and support female sailors, where the community gathers in solidarity and sport, where charities are funded and run for youth and disabled sailing, where, just like during the past weekend, the very best under-17 sailors in the country gather to compete. The clubs make the nation's most prominent sailors honorary members, and they come in turn and talk to all sections of our clubs to inspire us. The tides have come in and out of our estuary for millennia. We too are grains of sand in the current of history. But some grains matter more when they stand together, and this is one of those moments. We ask that the appeal should be rejected, not only because of the documented environmental, community, logistical, health and economic harm, but because it is quite simply the right thing to do.
You ran off before we'd got a chance to ask, but never mind, you've run off again. It's all right, you can go. He didn't have any questions anyway, fortunately. So off you go again. All right, can I invite Rob Hillman, please? It's now, just remind it's 16:13, so that puzzle I mentioned about just thinking about brevity and where we are in time, we need to start thinking about that pretty seriously now if we're going to get through everybody else. So it's just a reminder to people who's yet to come. Mr. Hillman, if you could just explain who you are, who you represent, whether you're in objection support, and that you are willing or not willing to answer questions.
Yes.
Is the answer to all that yes?
Yes.
In which case, I'm not going to ask you to introduce yourself.
Fine.
You please carry on.
Thank you. Thank you, Mr. Normington, for the opportunity to speak. I would like to offer some thoughts from my perspective as a local resident. I've lived in Hamble for 14 years. My profession is statistical modelling. I have a PhD from the University of Southampton, where I specialised in chaos theory. Chaos theory is a branch of mathematics developed to explain phenomena such as the weather, stock markets, and traffic. I've recently carried out economic impact analysis for the UK government to help design the pandemic and energy shock support policies. I'm not a transport consultant, but I would like to bring my skills and experience to focus on traffic and provide a different and I believe more accurate story to the one being told by the appellant. CEMEX state residents and businesses have unfounded fears and perceptions. Earlier we heard some new terms, misconceptions and misunderstandings too. I think this couldn't be further from the truth. There were about 5,000 objections, many of which referred to Hamble Lane and its congestion. If each of those people has had experience of driving, walking or cycling on the peninsula for let's say an average of 5 years, then that's 25,000 years of lived experience. These people are not to be ignored. They are expressing genuine concerns, grounded in experience and local knowledge. What I would like to suggest to you, Mr. Normington, is that I think they're telling you something that CEMEX's assessments are somehow just not picking up. Now, CEMEX will tell you, as they already indeed have, that they provided reams of analysis and impact assessments and that the numbers don't lie. In fact, Ben Howard, the iTransport consultant, has written, "It is also the most extensive modelling that I have ever completed for a development generating around 30 vehicle movements in the peak hours. I conclude, and the CHA conclude, that the modelling that has been submitted is robust and sufficient to understand the impacts of the development on a worst case basis." So Ben Howard and iTransport have apparently done a lot of modelling. But is it robust and is it sufficient to understand the impacts of the development on a worst case basis? I would like to give you some examples to demonstrate why I do not believe it is. On October the 19th, 2024, there was an article in the Daily Echo. The headline was, "Southampton Roadworks, Carmageddon causes week of chaos." I'd like to just read a few lines from the article. "While everyone across the city has been feeling the effects of the traffic congestion, Ray Calloway from Hamble Hoovers felt it more than most. Ray travelled from Hamble to Portswood to pick up a part for his Hoover repair business, but it ended up taking him 4 hours to travel to Machine Mart and back." Portswood is about 4.5 miles away from Hamble. To continue, "I had customers calling me, asking me where I was. I felt absolutely powerless. Ray arrived back to the workshop at 6:30 p.m, missing an entire afternoon of business due to the roadworks. Councillor Eamon Keogh, Cabinet Member for Environment and Transport, said, over the past few days there has been a coincidence of different events, some planned and some unplanned incidents that have led to unusual levels of congestion, including the M27 Junction 7 slip road closure." Now I remember that week clearly. My 8-year-old daughter was late home from school several nights in a row. On the Wednesday, for example, she got back at 10 to 7 instead of 5:30, 80 minutes late. And she's 8 years old. That's not an unfounded fear or a misrepresentation. It is an inescapable fact. iTransport, bizarrely, used that particular week to do a survey of traffic. And they found that traffic counts were lower than on the 18th of October 2022, the single day to which they compared their numbers to. In the CEMEX Statement of Common Ground, they presented these lower counts, and they claimed it was evidence of a trend of traffic falling on the peninsula. So I looked more closely at their data, and they were right. They were right about the counts. Not only was traffic lower than on the 18th of October 2022, but in some places, especially those places more prone to congestion, the count was significantly lower. On Hamble Lane between Tesco and Windover, their survey showed a traffic count that was 27% lower than in 2022. That is a huge drop, and not one supported by the experience of road users. So I thought about it a bit. What happens when traffic is congested? When traffic is congested, it slows down. The number of cars that can drive past an ATC counter within an hour will fall. If in 1 hour 1,000 cars go past a counter at 10 miles an hour, and then speed slow to 5 miles an hour, in the next hour, only 500 cars will be counted. So in fact, what iTransport unwittingly demonstrated was an example of extreme congestion, precisely the problem that Hamble residents quite rightly care about, and it's precisely the problem that CEMEX and iTransport have failed to represent in their assessments. Now, iTransport carried on, seemingly blissfully unaware, and they didn't stop to think that a 27% drop over 2 years against a rising trend of background traffic post-pandemic, they didn't think that was anomalous. This is a classic example of how remote desktop analysis, in this case someone looking at an Excel spreadsheet in Basingstoke, I believe, can misinterpret the facts. It shows that despite Mr. Howard's protestations that he is, in quotes,
fully familiar with the appeal site and surrounding transport network, he is anything but. But it isn't just iTransport that jumped to this erroneous conclusion. So did Hampshire Highways. Now that really is odd, because during the week before the survey, Hampshire Highways, along with National Highways and the County Council, had been alerting people in Hamble and the surrounding area of the likelihood of congestion and disruption the following week. Everybody from Hamble, Netley, Bursledon, Hedge End knows that junction closures, accidents, roadworks and the sheer weight of traffic regularly cause journey times to deteriorate. And what I feel obliged to stress to you, Mr. Normington, is that these congestion periods, they're not anomalous. They're not atypical incidents. They are an integral part of the rich tapestry of Hamble traffic. Now, fortunately, traffic is not often, or perhaps better to say always, as bad as the Carmageddon week I described earlier. But very regularly, as you've heard today many times, there are big tailbacks and journey times that unpredictably go from 10 minutes to 20 minutes to 30 minutes and more. On the occasion I mentioned for my daughter, it was 80 minutes. An objective worst case impact assessment would apply the development traffic during times in which congestion is building or already established. Now, I admit this is hard to do. Traffic models can struggle to predict impacts accurately in networks close to capacity. This isn't a fault of the models. It's simply a fact of life. And iTransport know this. I know they know this because in one of their assessments that showed adverse results for them, a big increase in queue lengths, they played down the result, saying, when a junction reaches capacity, the model becomes very sensitive to small increases in flows, which can have an unrealistic impact on modelled queue lengths and delays. Blaming models selectively when it suits is bad practice. It is a well-known trick attempted to bias the assessment towards the client. The reality is that nearly all Hamble Lane and nearby junctions are at some point in the day, and many at several times of the day, in this same state of near or over capacity. And this is precisely when even small additions in traffic can cause large fluctuations in congestion. So the crux of the issue for me is that CEMEX has never established a sensible baseline from which to assess impacts. And let me just talk about that baseline briefly. It came up earlier in the discussions with Paul Holmes. iTransport have a 5-day traffic survey from April 2022. It took place in the week before the May bank holiday, the first May bank holiday, and it took place a week after the Easter holiday. It was a late Easter. That is, as I'm sure you know, Mr. Normington, against guidelines for obvious reasons. They then have a single day from October 2022, the 18th of October. They only did that survey, as I understand it, because they were asked to do it by the County Highways Authority, because they hadn't, at that point, done any proper junction analysis. And then they have their Carmageddon survey from October 2024, the week that Ray from Hamble lost half a day's business due to congestion. This is utterly woeful, given the critical importance of transport assessments in this proposal. They have one single clean day of data. Hamble residents and the tens of thousands of road users deserve better. Finally, but have CEMEX and iTransport and the County Highways Authority, have they followed the rules? Have they ticked all the boxes? Do they make it hard for you to be able to reject the appeal? I think the answer to that is an unmitigated no. Helpfully, Mr. Howard included, alongside his proof of evidence, he included a copy of the 2007 Department of Transport Guidance on Transport Assessment. I'd like to just read a few sentences. Paragraph 4.92. If the transport assessment confirms that a development will have material impact on the highway network, the level of impact at all critical locations on the network should be established. A particular example of material impact would be a worsening of congestion. In congested areas, the percentage traffic impact that is considered significant or detrimental to the network may be relatively low, possibly below the average daily variation in flow. For the avoidance of doubt, the 1994 guidance regarding the assessment thresholds of 10% and 5% levels of development traffic relative to background traffic is no longer deemed an acceptable mechanism, since it creates an incentive in favour of locating development where high levels of background traffic already exist, i.e. Hamble. But claiming negligible impacts based on modest percentage increases is precisely the methodology that iTransport and CEMEX are relying on. Where in the transport assessments are there required discussions about the appropriate thresholds for determining impacts where high levels of background traffic already exist? Where is the data that demonstrates the frequency and the magnitude of congestion? Where is data on journey times, which are the most direct and transparent way of measuring congestion? Nowhere. Nowhere in all of the evidence CEMEX has presented are journey times. And there is one table of speeds. In everything I've seen, and please correct me if I'm wrong, I've only found one table of the speeds. The speeds in the table of traffic: southbound 34 miles an hour, northbound 34 miles an hour. That is ludicrous. That is the baseline on which you are applying impacts of traffic. And it is crawling it is unpredictable and long journey times that cause stress. They cause people to be late for appointments, miss trains, and lose business. And it's also crawling stop-starting traffic, especially of HGVs, that has the most negative impact on air quality. This, Mr. Normington, is why there's such a gulf between what you're hearing, between the residents and the businesses and the CEMEX claims of negligibility. That's why there's so much passion and anger. CEMEX have not even got remotely close to measuring, in Ben Howard's words, the impacts of the development on a worst case basis. So I hope you will approach your inquiry with these concerns in mind and not be persuaded by assessments based on false precision, rosy assumptions and biased reporting. I would welcome any questions or cross-examination by any of the appellant's experts, and thank you very much again for letting me speak.
Well, I don't know if I'm disappointing you, but I'm not going to ask you questions because I've got an expert. Could we have some?
Okay.
I'm not. Sorry, there's a lot of background noise.
Can you please be quiet? I said earlier, this is not a public meeting. You do need to refrain from interventions, please. Otherwise, we're not going to deal with what we need to deal with. It's not part of the protocol. So please, if you can be quiet.
So, sorry to disappoint you. I'm not going to ask you questions because there is a expert evidence being heard on the topic from highway modelers. I suggest, because you're clearly interested in it, you may want to listen to that and ask your own questions.
Thank you. Yeah, sure. Thank you. Thank you.
Please. Again, just be mindful of time. With an hour left, we're rapidly running out of time, and that's not me being mean. We have a programme to follow, and a protocol doesn't allow me to just flex that, unfortunately. So please just be mindful. Yes.
Yeah.
Yes. Yeah. Introduce yourself and can I ask if you'd be prepared to answer any questions?
Yeah. Okay. Thank you for your attention to my objection. For context, I'm Dr. Susie Thompson. I'm a Chartered Environmentalist, a Fellow of the Institute for Environmental Management and Assessment. I have a PhD in Coastal Management, a Master's in Water and Environmental Management, and I'm also a resident of Hamble and have been for 25 years. My kids attended the primary school, I walk my dog and run on the airfield, as well as around Hamble Point and along Southampton Water, along the Solent European Marine Site. I see the existing pressure on the protected mudflats and the migrating birds from bait digging, recreation and erosion. I've been a sustainability consultant for over 35 years and I was a member of the River Hamble Harbour Board for 8 years as well. I work in sport and recreation and sustainability as well for over 30 years, so hopefully that sets the tone of this. There are two areas I'd like to bring your attention to where I'm not convinced or I haven't seen the evidence, maybe there, provided by CEMEX that they're able to mitigate the negative impacts of this proposal. These are the displaced recreational activity and the impact on the protected habitats, including the Solent Marine Site, Ramsar, SSIs, SACs, SPAs. We've heard all the abbreviations. And I'd also like to raise the changing demand, the need, based on our requirement to meet legally binding carbon targets over the next 10 years, and the need for local supply, and the actual definition of sustainable development. Let's start with my first point. Currently, there is a level of informal recreational activity on the airfield, regularly used by walkers, dog walkers, runners, kids and adults of all ages. The Shadow HRA LC ecological states it's currently used informally by public for recreation and dog walking. CEMEX's breeding and wintering bird surveys referred to the current high level of public recreation. So then I looked at the habitat regulation assessment carried out by Hampshire County Council, which recognises the site lies 320 metres from the Solent and Southampton Water, SPA and SAC and other protected areas, and recognises the potential increased damage for displaced recreational activity resulting in an appropriate assessment, which concludes that the permissive path to the east of the site and the open area to the north would provide sufficient mitigation to mitigate the impact of recreational activity on the activity being displaced, and therefore would not impact the protected coastal areas. Although I cannot find any methodology as to how it has been assessed that the human behaviour factor will turn people around and not take them onto the coastal sites. I showed the likely displacement impact in my objection on January the 23rd and was hoping that somebody would then do some research into it and provide the evidence. I refer to my local knowledge of the area as a dog owner, requiring a couple of 30 to 40-minute walks each day. I'm far more likely to head to the closest area, the coast, away from the airfield and quarry site. Note, likely less than 320 metres to reach these areas. The 320 metres between the airfield and the coast is the village. That's where people live, the residential area. They're far more likely to go the 320 minutes to the coastal areas than they are, well, I estimated 1.5 kilometres, but I heard this morning this was a 2-kilometre path along the side of the quarry, to the north side, the furthest away from the village. I haven't seen any evidence or stated methodology to scientifically evaluate the actual likely displacement and therefore enable the likely significant effect of the displacement of this current high level of recreation. I believe there are 3 displacement options. The least likely is that people walk along this perimeter of a gravel pit working to the proposed public access area to the north and east of the site, a 1.5 kilometre walk. It's possible people may get in their cars or they walk to the car park by the primary school, passing the entrance to the gravel pit and use the playing field and Netley Country Park. I believe you said something about it being absurd about the idea of displacement, the Netley Country Park being a suitable alternative. But let me just remind you, this is actually also adjacent to the coastal European marine site. The most likely is that people walk to the closest areas, the spaces in the village adjacent to the SAC, SPA, Ramsar and SSI. It should be noticed that one of the greatest disturbances to birds is dogs. That's RSPB research, not my own. And the displacement of the current activity on the airfield to these sites is about a quarter, perhaps at best a third of the size of the airfield, and not all of it is accessible. On this basis, I don't believe human nature heading to the closest area in geography has been assessed to identify the actual likely displacement and therefore the likely significant effect on these European sites and protected habitats. My second point is around the changing demand and the need to provide locally sourced material. As a sustainability consultant, I help clients assess their carbon emissions, establish carbon reduction plans and climate transition plans. The core premise is to meet the commitment of the 2015 Paris Convention and now legally binding carbon targets of the UK government set out in the Climate Change Act 2008, with updated targets up to 2021. This Climate Change Act enshrines in law that we must reduce greenhouse gas emissions by 100% compared to 1990 baseline and net zero by 2050. And in 2021 sets an interim target to reduce emissions by set an interim target to reduce emissions by 78% by 2035. That's just 10 years from now. According to the UK's Green Building Council, around 10% of the country's carbon dioxide emissions are directly associated with construction activities, and the number rises to 45% when we take into account the whole life of the built environment sector. We assume we need to deliver on the current government's build policy. Achieving this demand for construction in alignment with legally binding carbon commitments cannot be achieved by a business-as-usual approach, and will have to be a shift away from use of virgin materials, which, contrary to the opening statement, would not, in my profession, be regarded as sustainable, which is more around net zero and circular economy. CEMEX consultants, Stantec, have done some work to measure and identify some ways to mitigate the carbon emissions around the actual extraction. It doesn't account for downstream emissions, and whether they should or not is not part of my point. We know downstream emissions will exist, and we know we need to be reducing these emissions from the construction industry. The industry is actually making steps forward in sustainable construction and sustainable development. Skanska have, through recycling of existing road materials and recycled aggregates, developed low-carbon concrete with a 40% reduction in carbon emissions compared to traditional methods. Holcim, a leading cement producer, have developed EcoPack low-carbon concrete with a 90% lower emissions by using recycled materials and alternative binding agents. And Kennet in Australia catalogues building materials for future use. Can also be used here in the UK, creating a material bank to avoid the need for virgin materials. There will, over the next 10 years, be an amount of existing aggregate in the built environment that will come available and can be part of our existing surface aggregate bank. We know Hampshire already has permissions for subsurface minerals, and I was told this was 11 years based on today's need. I believe this is 4 years more than required. Now, that's information given to me from the Minerals Planning Authority, so at the time I had no reason to doubt it, although we heard today that apparently we have less than 7, but I assume those are working permissions as opposed to actual permissions given. There's also an active marine sand and gravel wharf run by CEMEX in Southampton, 5.5 miles from the proposed entrance of this site that produces sand and gravel. If we take the existing potential surface material, recycled aggregate land bank into consideration, the reduced demand through the use of recycled aggregate and meeting our legally binding carbon targets, all of that on top of the fact that existing quarries in the region are extending their original planning timelines, and there is just 5.5 miles away a marine wharf run by CEMEX landing the same type of sand and gravel deposits as found in the airfield, I find it difficult to see how Hamble airfield will be needed to meet local or national requirements. Hampshire already has sufficient in the short term, and in the longer term, less will be required. We cannot carry on with business as usual if we are to protect future generations from the impacts of climate change. In 10 years' time, we're at 2035. We should have reduced our carbon emissions by 78% from 1990 levels. We can't do that by extracting the use of subsurface virgin materials and carrying on with business as usual. New alternative materials and investment in the use of recycled aggregates will ensure that our demand for these virgin aggregates drops still further. I refer again to the policy one, it's been brought up, Hampshire Minerals and Waste Plan, emphasis on sustainable mineral development. I haven't seen that this proposal of this site can be sustainably developed. That is a balance of social, environment and economic factors. Sustainable development means meeting the needs of the present without compromising the needs of the future. We're already at a 2-degree warming on climate change. We cannot carry on with business as usual. So in summary, I urge you to consider the displacement of the heavy recreational use that will very likely impact the protected area of the Solent Marine site. And based on our requirement to meet legally binding targets within the Climate Change Act, demand will reduce, the current land bank of 11 years will extend, and there is marine sand and gravel supply just 5.5 miles away. I question the need for this poorly located site. It is simply not sustainable. Thank you.
Mr. Strachan, do you have any questions?
No, but I'll just point out that we're revisiting both those topics later on in the inquiry, both recreational displacement. We do indeed.
Good.
But I'm not, rather than ask you all the questions,
Nice
I've got other.
Thank you.
Thank you.
My name's Tony Peter. I'm a resident of Hamble, and I have grandchildren, step-grandchildren, so we have a commitment to the village. I'm a Hamble resident living on Satchel Lane, directly below the former airfield. We have never experienced any flooding or surface water runoff, and neither have the previous owners, who lived here from 1996. I've looked closely at the proposed drainage and various updates prepared by Stantec UK Limited on behalf of CEMEX, and the published correspondence with Hampshire's lead local flood authority, as well as many of the other application documents. At present, the site comprises 60 hectares with an underlying permeable aquifer. Once the site is restored within permeable infill, this infiltration area will be reduced to 19 hectares, a third of its existing capacity. The whole site is a raised plateau in the midst of hundreds of lower-lying residential properties and businesses, so any unforeseen changes in the flood risk potential of the site would have wide-reaching consequences. The inspector, Mr. Normington, I think you need to see the extent of the slope from the airfield down to the houses below to fully appreciate these risks and concerns. It is recognised that more extreme weather conditions are now experienced in the UK, almost certainly due to climate change. I note that Stantec has designed the drainage system using the Flood Estimation Handbook FEH 13 and its associated rainfall parameters. However, the UK Centre for Ecology and Hydrology website states the FEH 22 rainfall model is the FEH's latest UK-wide statistical model for rainfall depth, duration, frequency estimation. It supersedes the FEH 13 model and the legacy FEH 99 model. It also advises, by including significantly more events and recent data, confidence in the model outputs capturing any recent climate shifts is improved. Hence, FEH 22 serves as an improved baseline for flood risk assessment. Given the more intense rainfall events experienced in recent years, I'm wondering why the proposed drainage scheme has not used the most recent published information for modelling, and why the Flood Authority has not required this. I'm concerned that the scheme has underestimated the potential flood risk and that design could be incapable of absorbing a more frequent and extreme rainfall event. My understanding of the current position is that Stantec has made some adjustments to the drainage plan and that these minor changes ensure that the restoration phase exceeds its flow routes and destinations mirror those of the existing site, and that the Flood Authority has accepted this. However, from personal experience, in reality, there is no surface water feature or signs of a historic surface water pathway on the airfield behind our property to support these baseline assumptions. The proposed drainage restoration scheme will include a large attenuation basin and a smaller infiltration basin above our property. If these overflow, the proposed restoration gradient contours shown on the restoration map demonstrate that the flood pathway would now pass through either our own or our neighbours' gardens and houses, with potentially catastrophic consequences. The Hampshire Surface Water Checklist guidance on exceedance flows requires highlighting the overland flow routes post-development if the drainage system blocked to ensure that properties and key access egress points are kept clear. The Flood Authority themselves picked this up. Given the proximity of residential areas, pre-construction phase and post-construction, exceedance plans are required to demonstrate there will be no detriment to other areas. The proposed exceedance flow pathways do not keep clear of adjacent properties. The National Planning Policy Framework clearly states local plan authorities should ensure that flood risk is not increased elsewhere. The proposed drainage scheme does not appear to comply with these stipulations. Hampshire has drafted drainage-related conditions to be applied at each phase of the development and not just at the initial application approval stage. However, residents do not want to be faced with the problem after sand and gravel has been extracted, only to then find out that any viable drainage plan cannot meet this requirement. By then it will be too late. Hampshire requires maintenance schedules must be provided for each drainage feature regardless of ownership. Confirmation of maintenance responsibilities and adoption will be required. Stansted has specified a detailed maintenance schedule, much of this monthly. Hampshire requires an aftercare scheme shall be implemented as approved for each phase for a minimum period of 5 years. However, Stansted has specified for the restored site, the management and maintenance of the drainage system will be undertaken by the landowner in perpetuity. Does this agreement with the landowner exist? Without this guarantee and the necessary resources provided by the landowner, with full and proper enforcement, our properties will be at risk indefinitely. I note Southern Water also requires similar assurances for protecting the sewage system. The Flood Authority has also commented, it has been assumed that the general lack of groundwater with superficial deposits mean that obstruction of groundwater flows will not occur except for possibly in areas of high groundwater. Whilst it is technically outside our remit, we have concerns that if groundwater flow paths are restricted, it could trigger spring flows elsewhere. Residents do not want to be faced with the prospect of new springs emerging in our properties with the risk of flooding from groundwater sources as well. The National Planning Policy Framework requires taking into account all sources of flood risk and the current and future impacts of climate change so as to avoid, where possible, flood risk to people and property. So, in summary, why has superseded source data been used for modelling the drainage design when a new version is available with improved baseline for flood risk assessment? Why do the proposed exceedance flow pathways run through our properties? Where is the agreement with the landowner that the drainage system will be maintained in perpetuity? Where is the evidence that new springs will not be triggered in our properties and gardens? The site's elevated topography, the existing geology with its aquifer and moderating benefits, the close proximity of so many vulnerable properties below the site, and the uncertainties raised with the proposed drainage scheme suggest that the site is unsuitable for an industrial large-scale quarry. Even after restoration, the additional need for a new, essential and permanent monthly maintenance regime only adds to the risk. Thank you.
Strachan.
I haven't got any questions, but Mr. Peter may like to know we're dealing with hydrology tomorrow.
So good afternoon all, Fred Wales. I've come here for a short talk to talk about infrastructure and Hamble allotment gardens and how much it means to myself, my wife as a holder and all the other allotment holders. I'm also going to give you, just due to time, just some bullet points from different holders today. So to define what Hamble allotment means, and if we had to put it in a few words, those words would mean it means everything to Hamble community, to be part of that community. My wife and I have been allotment holders for almost 2 decades and have made significant investment in our plot. More recently, in the last 10 years, lottery funding and the community, including businesses, help provide fencing. And thanks to Lock Gate, there's been no significant recent damage or vandalism. We worked alongside different agencies at one point. Hamble Police, Hamble Parish Council, the Asset Committee, councillors at the time, ensuring that the holders and the wider Hamble community were involved in creating the allotment we have today. Yourself, Chairman, you're welcome to visit Hamble allotments to see what I am talking about today. The allotments have developed into a thriving community with greenhouses, sheds, and now the exciting prospect of beehives. We've recently welcomed a new holder and a beekeeper, which will bring the benefit of more pollinators to the fruit trees and plants. The allotment fosters a connection with nature and encourages healthy eating. It's a place where we can nurture both the land and ourselves, putting fresh homegrown food on the table and taking pride in what we've achieved. So with this in mind, any disruption, whether through boundary changes or increased public access, it wouldn't be welcome, particularly considering the safety of families, the ecosystem, and the introduction of our new pollinators. Nothing beats the sense of achievement that comes from growing something from seed and putting food on the table and to be able to say, I grew that. Now to some key phrases from some other allotment holders. Rick and family have said, the allotment's more than just fruits and veg. It's a community, it's a place of learning where we teach our children the value of hard work and where food really comes from. Any changes to infrastructure, whether fencing, paths, pathways, or anything else, would have a serious impact on the safe space we built for our families. Bev and John, just picking out a bullet point, it's where we come together, united by a shared enthusiasm for working the soil. The impact on CEMEX on this cherished space, in their words, goes beyond the physical. Possible changes to infrastructure affecting the allotment, whether through reductions in plot sizes, losses to space, or damage to fencing, can't be brushed aside. Carolina, in 2 bullet points, says, it means a lot to me. This is a space where I grow fruit and veg. I haven't got a garden. But it's more than that. It's my 4-year-old and 2-year-old daughters to play and learn about nature. We're lucky to have slow worms. It's my happy space, essential for my mental health. Spaces like this make our community. Taking them away can break it. Phil, 2A, in a couple of bullet points. He finds solace in being able to visit the allotment during the working week. A public path through the allotments, should it be talked about or proposed, doesn't add to the community infrastructure. There's already a path on the side of the road behind the allotments called the rail trail, which is enjoyed by the community. And a further path not required as there's a Danny King cycle path already established on the other side of the road. And finally, Colin and Gay Ferris, 3B, said, we wanted to say how much we've enjoyed working on our allotment over the last 2 years. Living in a retirement flat, we really missed the garden we had before where we grew fruit and veg. Being able to get out of the allotment just half a mile away where we live has been a godsend. If anything changes, if our plot's taken away or reduced, we will truly miss the pleasure and freedom it brings today. Hopefully that won't happen. I just asked the Inspectorate, the Chairman, if you would reject any changes to infrastructure affecting Hamble allotment gardens and reject the CEMEX appeal. That's all. Thank you.
Yes, no problem. So my name is Glenn Jewell. I'm one of the allotment holders as well. And like Fred, I got some comments from other allotment holders, but I'll keep them very brief because there's a bit of repetition. You do get a feeling, though, it's quite a trite subject to pick up, talking about our allotments and that when we talked about children's health and traffic and everything else. But I've been asked to talk, and so I'll say my piece. So in particular, this is about the opposition to the CEMEX proposals and the installation of a new footpath, which will replace the existing green path, which is fenced off from the public, providing a level of protection for those allotment holders who are elderly or with young children. So on my own part, this is our 4th season as allotment holders, and we remain acutely aware of how long many people wait for a plot. Ourselves has been over a year, and due to high demand. And when we took ours on, it was overgrown and neglected, but through hard work, we transformed it into a productive no-dig space. Apart from when we're abroad, we're on the allotment every week, and at the moment, we're on the allotment virtually every day. And so are many of the allotment holders as well. It is a community. It's not left as a ramshackle plot. When public access was previously allowed via the existing footpath, the green footpath, in front of the allotments, we experienced multiple incidents of vandalism, petty vandalism, theft and shed break-ins. But since public access was removed and the gates were locked, there has been no significant issues, proving that controlled access is essential for security. Controlled access, sorry. This has allowed plot holders to continue working their land without fear, and with an increasing number of young families joining, it's been reassuring for both parents and pensioners alike, so they can bring their children to help dig their spuds. Reinstating a public footpath through in front of the allotments would once again expose the site to vandalism and theft, and sheds contain sharp tools, and an open pathway would create unnecessary risk and temptation. Each summer, as we are all aware, Large crowds travel to Hamble by train to swim, and their numbers alone would be exceptionally intimidating for those tending their plots, because they would choose the route of the new footpath right in front of the allotments. This is not an exaggeration, and the volume of visitors is well documented. Beyond security concerns, we must also consider the wider impact. Now, we've lived in Hamble for 37 years, and we've lived alongside the railway bridge, the Hamble Railway Bridge, for the last 20 years. So I am a Hamble traffic expert, because I sit there and watch it most nights. Just 30 feet from the road, and we see firsthand the traffic congestion from Monday to Friday, particularly during the school times. But like our other experts have already testified, there's no such thing as a rush hour in Hamble. It's rush hours plus anything else what happens. It happens all day long. But particularly during Monday to Friday, when during school times, when crowds of children travel between the train station and the Hamble village, and northbound as well. Many children cycle on dangerously narrow footpaths rather than dismounting. It's a 2-foot footpath. And a new footpath along through the allotments or alongside the allotments would do nothing to mitigate this risk and alleviate these safety concerns. Crucially, there is already ample pedestrian access in the area. A well-used railway trail, as Fred's already mentioned, runs between the allotments and the primary school, providing a natural and safe route. If improved with better lighting, some bush clearance and wider surface, it would also serve the local community better, but it already exists. There's one already there. Additionally, on the opposite side of the road, as everyone knows, you have the Danny King footpath, which offers a secure connection for pedestrians running directly from Hamble Secondary School, whilst trucks don't cross it, that is. For many of us, our plots are more than just a place to grow food. They are vital for both physical and mental well-being. The crops we grow are simply byproducts, often shared with family, neighbours, and the local food bank. If this space were to be ruined by the thoughtless acts of vandalism, many would have no choice but to give up their plots altogether, and there is no need to fix something that isn't broken. The current setup works, and introducing a footpath through or alongside the allotments would cause more harm than good. Now, aware that I'm out of time, 1 or 2 statements from some other allotment holders, is that okay?
Only if it's adding something.
I think the emotive part is most important, really. Becky and Mike, plot 13B, know them well. They have a young daughter, and they said, with the original fencing around the allotment, my daughter is safe to visit family and friends, plots without worry of cars and strangers. She's a 3-year-old child, and know that she's locked securely within the allotment with no one walking by, then that gives them peace of mind to allow them to do their things. They also, and I'm paraphrasing over here, they talk about the well-being for the child and that she's exposed to nature and not TV screens and tablets and everything else, and the value that it brings to them. Then I have Andy and Angie on plot B, line B. Their greatest concern is the lorries turning in off the Cemex proposed site and sitting there with their engines idling, exposing them to more and more exhausts. But again, for them, it's the mental aspect, how it makes them feel better, it keeps them fit, and the byproduct is the growing of vegetables. And that's it, sir. Thank you.
Just while Angela Fowler's come to the table, Mr. Jules left a document there which I'll record as ID 9. Ms. Fowler, just the same questions. If you introduce yourself, can you just confirm whether or not you're prepared to answer questions?
Yes, that's fine.
In which case, please proceed.
Thank you. So my name is Angela Fowler. I'm a resident of Hamble. We moved to Hamble 5 years ago for a better quality of life and for my health. So we used to live on the A3095 in Bracknell, so I'm very well aware of just how much harm idling traffic can do to lungs and to bronchitis, which I have not had since I moved to Hamble. What I'd really like to talk about, though, is a couple of points, and it's really to do with access. We've talked very much about how Hamble Lane is just a nightmare from a traffic perspective and that the models don't seem to reflect what we experience. But a few things in particular. The proposed increase in heavy lorries will pass directly through the existing AQMA, the air quality management arena. Access for gravel extraction through an AQMA should not be allowed, as it will not improve, and there is no way to mitigate this given the one road in, one road out Peninsula Road. Aside from the increase in pollution that will be generated, it is access that remains a key concern. Hamble Lane, as we know, one road in, one road out, single carriageway in both directions. As soon as repairs need to be made on or near the road, a traffic flow constrained to one carriageway, the village access journey times go from an average of 15 to 20 minutes to over an hour. Many of us experienced that this morning just trying to get here because there were some traffic lights on Hamble Lane again. This isn't unfounded rhetoric, it's lived experience. We regularly experience this with planned repairs, but unplanned repairs and accidents have a devastating effect on access. Even this Saturday, the 29th of March, 2025, a very sad accident on Hamble Lane meant traffic at Tesco's and surrounding areas had wait times of over an hour. The increase in these heavy laden lorries will increase the damage to the road significantly, and that's something I would like looked at, and therefore also increase the number and frequency of repairs, resulting in more restrictions on traffic flow, congestion and access. There's a relationship which is well understood by highway planners between road wear and axle load of vehicles using the road. The fourth power relationship was delivered from experiments by the American Association of State Highway Officials in the 1950s. The approach is widely used to evaluate cumulative road wear caused by different vehicle types, highlighting the greater impact of heavier vehicles like buses, HGVs, compared to cars. Now, forgive me, I haven't been able to find any reference to I've found references to traffic modelling, but not to the actual damage to the road. If we look at, there are other models suggesting varying powers, but if we look at the fourth power rule, it means that the wear on the road increases exponentially to the fourth power as weight is increased. So a car weighing 2 metric tonnes, like my SUV, will create some wear on the road. It can be calculated from 1 tonne per axle. An 8x4 tipper truck laden with 20 tonnes will have a gross weight of 32 tonnes across 4 axles. That's 8 tonnes per axle. So the wear per axle is 8 to the power of 4 times the SUV. In other words, one lorry will cause the same wear as almost 8,000 SUVs. 126 trucks will cause the same wear as 1 million SUVs. The point here, regardless of the maths, is that the extra wear on the road will result in an increased frequency of repairs that will be extremely significant and does not appear to be considered in the traffic impact reports. This needs to be considered by you, the experts, please. So it really comes down to how often will the roadworks be required more often and who will bear that cost. I've got one other point I'd like to raise particularly, and it's also to do with, we're very concerned about the road over the railway bridge, which I hope will be part of your site visit, and whether this will be damaged by the frequency and weight of these fully laden lorries. There is also a concern that these 3-metre wide lorries will not be able to pass each other on that bridge. The bridge is just 6 metres wide. I've measured that, that's wall to wall, that's not necessarily usable road surface. So the opportunity for an accident is obvious. Cyclists are required to come off the cycleway and rejoin the carriageway to cross the bridge on the road. This is a bridge with a blind brow. The capacity for an accident on this bridge is terrifying. This is a route our village children take to school. These large lorries will be intimidating to pedestrians and cyclists, particularly those under 1 metre tall, i.e. children. And what happens with more conjunction if the trucks are queuing to access the site, which is also very close to that bridge. If the railway bridge is damaged or needs repairs at any time, then access to the village will be severely disrupted. As I've said, we moved to Hamble 5 years ago, but as a consequence, I've had many years of living both near gravel pits, both at Calshot, Hampshire, and also Burfield, Berkshire. I can't attest to whether they were Cemex or other operators. But mud and dirt on the road from the access to the proposed site will increase the risk of accidents, especially for those on 2 wheels, and resulting road restrictions. We have lived near the gravel sites at Calshot and Burfield, and have a first-hand experience of the dangers this represents and the workings, and these workings and access were not in the heart of a community as being proposed here. Undertakings that wheels will be washed and the lived reality of the mud on the road in these situations and the dangers experienced in real life are different. All of this close to the railway bridge. Should an accident occur, the village access will be cut off. The only alternative route into the village centre along Satchel Lane, access point by the Hamble School, is highly unsuitable for large vehicles. The railway bridge on this road is only 5 metres wide, not 6, and let's remember these are 3-metre wide lorries. The parts of the single carriageway measure just 2.2 metres. There's no pavement on either side, so we would seek assurances, should the hearing decide for the appellant, that in the event of an access failure on Hamble Lane, that aggregate lorries would not be allowed to access via Satchel Lane at any time. Some of the other neighbours have obviously talked about some of the road incidents and the Carmageddon, but actually there's one I'd like to raise. It is in the files, it has been written about by many of us residents, but there was an incident on the 30th of August 2023 when Southern Water needed to make an emergency repair. This was during the school holidays. No one literally could get in or out of the village without huge delays from early afternoon to late evening. The village was gridlocked. This was still in the school hours, holidays when the traffic was lighter. The chaos we all experienced was reported on TV that night, and you'll find reports in Echoes as well as reports in the files, as we all wrote following that. On that day, journey times were an average of 1.5 hours, but I heard of instances of 2.5 hours to get home. There was no turning back. It was blocked in both directions. When you see the map, you see that there's if you like, a circular route. It was totally blocked. The impact of being trapped. Doctors and hospital appointments were missed. I also worked for the doctor's surgery. Emergency vehicles could not get in or out of the villages. Not a single ambulance would have been able to get through. Our fire station could not have been able to assist in a fire or emergency, whether that be Hamble or Burston or the M27. The police could not get out of their training support HQ. Supermarkets deliveries did not happen, and we couldn't get to the supermarket. Hairdressing, physio, dental appointments all missed. Buses on the peninsula were stuck, and any incoming services were cancelled by the bus company. Shift changes at our local employers were disrupted. Staff couldn't get home or to work, etc., etc. It's important to note these are not just inconveniences, but have real economic impacts and risks to our health. And that's really probably where I'd like to leave it. But if you would take time to look at those things, that would be appreciated.
Right. Afternoon. Firstly, thank you for letting me speak. And I've got 3 statements from local business owners in Hamble who weren't able to make it, and I'll read out their words. Excuse me. The first one is a statement on behalf of Ian Southworth of Warndon Sales Limited. We run a business here in Hamble employing 14 people. Excuse me. Some of whom live locally, some commute in. Already our team faces commutes of over an hour to travel just 5 or 6 miles. The traffic on the B3397, one of the busiest roads in the country as far back as 2008, has only worsened as the village has grown. To ensure we remain open for business and meet delivery deadlines, we often rely on expensive same-day couriers, standard delivery drivers, frequently missed connections due to the current congestion. If this quarry goes ahead, bringing with it additional HGV traffic, we fear this situation will only deteriorate. Thank you. We cannot be at this hearing today because we have already had to adjust our own working hours to compensate for unreliable access. But we want to be clear, we're seriously considering relocating. Dust, noise and congestion will limit our ability to grow and to attract future talent. If local businesses like ours are pushed out, it won't just impact us, it will erode the economic stability and vibrancy of the whole community. Number one. The second one, Jenny's Cafe, and well worth a visit, by the way. Jenny is a local cafe business. We have 2 premises within Hamble Village, employing over 20 people, and have a social responsibility to our local residents. We are lucky to be located in such a fantastic village with its picturesque appearance, with the cobbled high street, quayside, fantastic walks, etc., and geographical location. Jenny's and other hospitality units nearby are reliant on not only trade from Hamble, but even more importantly from visitors and tourists. One of the concerns we all have is that the presence of the quarry and all that means the lorries, the dirt on the road, the sight of the works equipment, the noise, the dust, it will all impact on the attractiveness of what is such a lovely place. Who is going to visit a village with a gravel pit? I believe that the gravel pit would deter people from coming to Hamble, and therefore we would not be able to sustain the levels of trade required to stay open. I already have regular customers who decide whether to come or not based on the traffic. There is no way this situation would improve for us. Additional traffic or perceived additional traffic, especially lorries, will exacerbate this, reducing visitors and ultimately reducing the numbers through the doors. This will not be mitigated by any trade we may get from the site staff. In all honesty, that is likely to be minimal. We are on the other side of Hamble from the quarry entrance, even though everywhere in Hamble is close to the edge of the site. If we do lose trade, that will impact the viability of Jenny's. We are not large, we pride ourselves on our service, quality of our food and the attractiveness of the area to keep people coming. It is a delicate balance. Disrupting that balance will disrupt the business. I've seen that somebody writing for Cemex has stated the fears of traffic are unfounded. That is said by somebody who knows nothing about a cafe and who knows nothing about visitor and tourist reliant businesses. He may know some things about traffic numbers, maybe not as much as he thinks, because Hamble Lane is very sensitive to small changes in traffic, and he hasn't suggested traffic congestion will not increase. And any increase is of concern to me, added to other disruption to make the area less attractive, and the impact could be serious. I know my business and I can assure him, Cemex and the inspector, that my fears are not unfounded. At this time especially, anything that disrupts my business could dramatically impact on my ability to keep going. I know that others are in a similar position. Ultimately, this is not just me and the family that will be affected, it is the business, the staff, the team, and ultimately Hamble and the area itself. I strongly believe that the future of our business relies heavily on the plan to develop the airfield being rejected. Thank you. And finally, a lot shorter this one. Thank you for the opportunity to talk. I apologise for not being there in person, but my doctor has grounded me. I am the owner and director of Vital Spark, specialising in marine electronics, founded in 2010, and I employ 3 other staff members. The impact on the quarry on me and my small business will be significant. We are increasingly concerned about the continual challenges we faced, and here he lists Brexit. I guess that isn't Cemex's problem, I know. COVID, the Russian war, US and UK politics, and now the gravel pit. All of this is drastically affecting our industry. Now Cemex want to add a quarry nearby, which could be the final blow. This is unsustainable for an already vulnerable sector. Many businesses in the UK have been impacted, but none face the threat of a quarry next door. I've invested significant time and resources into training 2 apprentices with minimal government support. Losing them due to the challenges posed by the quarry would mean losing years of training and investment, undoing a decade of work. The increased dust, noise and traffic may lead customers to choose other ports. The annual cost of operating their boats will rise. Dust in ropes, sails, winches, blocks, etc. can reduce their lifespan, necessitating frequent replacements and resulting in higher maintenance costs. Increased noise might detract from enjoyment, while additional traffic could introduce stress. This situation may prompt them to relocate, as other ports may offer more favourable conditions. As a result, the marine industry might face challenges, potentially leaving only larger companies to thrive or survive. My company may not survive under these circumstances, and my family might have to relocate for continued livelihood. This scenario impacts many small businesses in the area. Establishing a quarry nearby could significantly affect our industry and undermine years of hard work. Regards, Craig Cosser. Thank you. Yeah.
Thank you very much. We're down to the last 15 minutes or so, so need to think about repetition very, very carefully if we're going to get through a few more people. Kay Linders Kilby.
My name's Kay Kilby. I'm 63. I live in Crowsport, Hamble, and I'm asthmatic. I'm terrified by the prospect of the airfield becoming a gravel pit because I know what the effect of air pollution will have on my ability to breathe. One of the most terrifying things about being an asthmatic is when you cannot gather enough breath to speak, to walk, to move. When your blood oxygen drops so low that you drift into a very calm sleep and are woken as all hell breaks loose out around you, as medical staff start pumping oxygen into you to bring you back and covering your body with stickers to monitor you. This is what 10 years or more of my life is probably going to look like if you dig up our airfield. If I'm lucky enough to survive, I'm led to believe that none of the pits in Hampshire have ever stuck to its original proposed timeline. Currently, my asthma is well controlled, and I have a good life expectancy of at least another 20 or 30 years. But if the air quality around my home decreases any further, with the addition of dust pollution from the gravel pit and increased traffic pollution from all of the additional lorries using Hamble Lane, then my chances of having an active, fulfilled old age are substantially diminished. I have the option to move away from Hamble, to live somewhere where the air is clean. But why should I have to do that? Why should I have to move from the home I've lived in for 20 years and the village I've been part of for 45 years? Why should I have to move away from the doctor's practice who take care of my particular medical needs and away from the catchment area of a university hospital which has an exemplary history in asthma care? Until you've been subjected to the effects of inhaling dust particles and had the terrifying experience of not being able to catch your next breath, please do not tell me this gravel pit project will not affect us in Hamble. The village surrounds the airfield. There is nowhere for us all to escape. It will be in our ears, eyes, lungs and houses 24/7 for at least the next 10 years. From the basic research I've done, as far as I can see, CEMEX have never embarked on gravel extraction in such a confined area before, so cannot say with any certainty that there will be no effect from dust. How many of us must have our lives foreshortened for the sake of a few thousand tons of gravel, which can be sourced from other sites, which have better access and are further away from the populated area? This project is a dangerous madness which threatens not only our lifestyle, our livelihoods, but also our lives.
Good afternoon, Mr. Normington. Thank you for having me to speak, and to the rest of the room. I will considerably shorten this speech and send it to you in the email, the full version, if that's okay. I am a specialist respiratory physiotherapist in the area of pulmonary rehabilitation and breathing pattern disorders, with 20 years in the NHS. I have several presentations that, if you're also interested, I can send you in breathing patterns and understanding your nervous system and how the impact of air quality can significantly impact. I became a Hamble resident through skippering boat 6 years ago, and I've chosen to stay due to the remarkable community, the access to the water and the nature that I found around me. I'm also an athlete. I've represented Team GB for offshore sailing last year, so I stand by the marine community. For clarity and direct relation, I have no family ties to the community, so it really does say something that I am wishing to stay. and also wishing to defend this community. I wanted to speak because I'm very concerned. I have the lived experience to predict with objective and professional confidence that this is an obvious disaster waiting to happen. A disaster for the health outcomes, quality of life and taxpaying costs to pick up the bill for the assessment and treatment required for decades to come unless you reject this decision. I know we've heard this statement a lot of times today in terms of we don't build quarry, we've never had a quarry built so close to a school and a community, but that does mean that there is no evidence around the health outcomes to make any comparison to. We do have the power to keep it that way, and that's why I'm here today. What I can give you is the evidence from patient mileage, the lived experience. I've worked in Sheffield, Nottingham, Portsmouth, Southampton, all significantly impacted by industry. In recent years, I was on the COVID wards, and then that led me to long COVID service, and then becoming a breathing pattern specialist. Those living in damp conditions with poor air quality and inability to ventilate their own homes suffered exponentially. I currently co-lead a team that run exercise classes and education for patients with COPD, like the patient we heard from Dr. Thompson earlier, Mildred. We run 6-week exercise classes and education, and we use specific evidenced nationalised exercise testing alongside questionnaires to help gain a baseline of their current fitness, and then we can compare it afterwards. We can't reverse changes, but we can help them manage their condition. And I really hope that I don't find myself in the years to come needing those skills to assess the health of our community. We also play a role in hospital prevention, and we've touched on that lots today, so I'm not going to go into that. But 1 in 8 admissions are due to respiratory cause. And I'm sure I don't need to state the obvious demands we have placing our acute hospitals with recent NHS England and our current NHS climate. Were it to go ahead, please recognise that there will be a significant social and economic impact for years to come. I predict a rise in, and I've given you a list of conditions, which I won't go in, I'll stop and leave it on my email. Working in long COVID really has brought home the impact of how pillars of health make such a vital impact on our lives. Air, noise and exercise access are key pillars of health, and they are the forefront of how we are changing healthcare going forwards. I believe that these will all be significantly impacted if this proposal is approved. I'm here today because I don't want our village to become a Netflix documentary like Toxic Town. So I place my hope in you, sir, to make the right decision for the sake of the community I represent. I agree the proposals are a safeguarding issue and on a mass scale. I ask that common sense prevails. The community's objections I represent are not unfounded or fanciful, which is quite frankly slightly insulting, but overwhelming evidence. And I shall leave that there and send you the full version.
We've got time. I'll allow time for 3 more people, and then we're going to have to call it a day. Those who can't speak, we still have Friday available. We have talked about if people want to record something, we can play it. I understand on Friday, but I can go through the list. But I understand there are some people who, and I'm looking at you, Ms. Oslin, that you really want to speak today. So I don't know how you've managed yourselves, but is there some people who you feel need to desperately speak? I think a audio recording is something that the council could manage, and I can live with that. But you mentioned earlier that there are some people you thought need to speak today. So it's me saying I can go through this list in the order that I've read out twice now, or are there any of the people that you think, and I'm looking at you, and forgive me as a community representative who seems to be leading some of those speaker lists, who you think needs to speak in the next quarter of an hour or so? Or do you want me to just carry on with the list? I know I did say, and I've said it repeatedly, that we need to, brevity is the key, and we can't sit here all night, I'm afraid. Yeah, sorry, I do apologise, sorry. Sorry. Yeah, your name is? Yep, thanks ever so much, Mr. Blaine, that's helpful. Thanks ever so much. That's not me being mean, it's just that we can't, it's not fair to everyone, health and safety wise, to sit here all night, and we did have a programme, so we are where we are. Ms Mansfield, thank you. Introduce yourself. Mr. Strong might have some questions. Are you prepared to answer them?
Yeah, that's fine.
Straight away, off you go.
Hello. Oh, sure. Good afternoon. My name is Vicky Mansfield, and as a lifelong resident of Hamble, I've witnessed firsthand the unique character and beauty of our village. Growing up sailing on the river, attending local schools, and now raising my own young family here with another on the way. My roots in this community run deep. This personal connection fuels my profound concern regarding the proposed gravel extraction at Hamble Airfield. I run a business dedicated to managing holiday properties in the Hamble, Warsash and Bersden areas. This year, my portfolio includes 18 holiday homes in the area, 15 of which are in Hamble, including a combined capacity of 130 beds per night. The summer season is already looking incredibly strong, with over 600 guests booked to visit in June and July alone, and the inquiries for future stays, including Christmas, are steadily increasing. This highlights the significant appeal of Hamble as a destination. The prospect of the proposed gravel extraction proceedings fills me with apprehension. The already strained infrastructure of Hamble Lane and the surrounding roads will undoubtedly become even more congested, transforming travel into Hamble a significant ordeal. This increased difficulty accessing the village will inevitably deter visitors, leading to a decline in tourism and negatively impacting the local economy, including the vitality of my business. Compounding my concerns is the proximity of my managed properties to the proposed extraction sites. All 15 houses are situated within a mere 150 to 200 metres of the airfield. These are significant multi-million pound investments that attract high net worth individuals, both as owners and rental guests. Many of these owners and guests choosing Hamble because of the sailing scene here. Their presence is invaluable to the local economy as they actively support the numerous restaurants, cafes, pubs, delis, and contribute to Hamble's vibrant character and substantial revenue to the area. My business also directly supports the local economy through employment. I rely on individuals and businesses based in the Hamble area for various aspects of property management. Additionally, specialists who maintain features like hot tubs and AV systems need to travel to the village. If the increased congestion on Hamble Lane makes accessing these properties difficult and time-consuming for them, I anticipate facing challenges in securing and retaining reliable local support with the same expertise. This adds strain on logistics and will inevitably impact my ability to ensure smooth and efficient operations for both guests and property owners. I firmly believe that proposed gravel extraction will deter many holidaymakers from visiting Hamble for a multitude of compelling reasons. The prospect of navigating congested roads into the village, coupled with the inevitable dust generated by the extraction and transportation process, and the understandable health concerns regarding airborne particulates, not to mention the anticipated noise pollution, will significantly diminish Hamble's appeal. Ultimately, clients paying substantial sums for holiday rentals will undoubtedly be reluctant to stay in close proximity to industrial operation, leading to a loss of significant revenue for the area. Hamble isn't just a place on a map. It is the undisputed heart of the South Coast yachting scene. We are a magnet for boat owners and international racing enthusiasts, and their presence fuels a significant portion of our local economy through the vital surfacing and maintenance of these often exquisite vessels. The prospect of a constant layer of dust generated by the proposed mineral extraction settling on these yachts is deeply concerning. Imagine the frustration and potential damage to these prized possessions. It is not unreasonable to believe that owners faced with this reality would seek cleaner harbours elsewhere in the UK or abroad. It wouldn't just be moving a boat. Yachts require extensive maintenance from the 7 or so yards situated along Hamble River. Removing these yachts may also trigger a domino effect, leading to the sale of properties and severing ties with the Hamble area, with devastating consequences for our economy. The fundamental question is stark. Why would anyone invest and maintain an expensive yacht or house here if they're constantly at risk from industrial outfall, incurring additional and unnecessary upkeep costs? Beyond the yachting community, Hamble attracts a significant number of visitors from across the country and abroad, seeking out short breaks, often to celebrate special occasions. These guests actively engage with our local businesses, hiring boats, paddleboards, and enjoying river cruises, further bolstering our community and economy. Additionally, we provide accommodation for visitors and staff of local businesses, highlighting the diverse appeal and economic contribution of tourism in Hamble. Returning to the issue of dust particulates, a significant number of the properties I manage feature hot tubs or swimming pools. The inevitable question arises, how will the dust and particulates in the atmosphere impact these amenities? It's highly likely that they will damage filters and negatively impact water quality for our guests. This will undoubtedly lead to increased costs for property owners in terms of maintenance and water bills. Furthermore, the environmental implications of constantly draining and refilling substantial volumes of water to maintain cleanliness cannot be ignored. This adds another layer of negative consequences to the proposed extraction. And let's not forget the inevitable intrusion of noise. The additional noise stemming directly from the mineral extraction process will undoubtedly shatter the peaceful ambience that draws visitors to Hamble. Picture this. Guests attempting to celebrate a special occasion, perhaps enjoying champagne in a hot tub with friends and family, only to have the tranquility ripped apart by the relentless sound of gravel extraction. People are drawn to Hamble precisely for its calm and tranquility, and I firmly believe that the noise pollution generated by this operation will fundamentally erode that very appeal. The intrusive sound of heavy machinery and industrial activity will create a stark and unwelcome contrast to the peaceful environment our visitors expect and deserve. The potential impact is already becoming a reality. One property owner whose house can accommodate up to 14 guests and has been a valuable asset to visiting crews for many years, a property I have managed for nearly a decade, has already decided to put their home on the market. It's a significant loss for the area, and worryingly, the sale is proving difficulty, with the proposed gravel extraction plans being a major deterrent for potential buyers. This demonstrates the immediate negative impact and mere prospect of the development is having on property values and investment in Hamble. In summation, I vehemently oppose the prospect of this appeal by Cemex. The potential ramifications I have outlined pose a significant and multifaceted threat to the economic vitality and the very character of Hamble. From the inevitable traffic chaos deterring tourists and impacting on local businesses like mine, to the environmental concerns and dust and noise pollution, affecting our valuable yachting industry and the quality of life for our residents and visitors alike. The negative consequences far outweigh any perceived benefits. The stark comparison between the long-term economic contribution for our existing industries, particularly yachting, and short-term gains of the mineral extraction is undeniable. Furthermore, the concerning local trend in local property values suggests that there is a mere prospect of this development is already having detrimental impact. For these reasons, I urge you to reject this appeal and safeguard the future of Hamble. Thank you.
Miss Austin, is Miss Austin about? I think she agreed on somebody to come next. Whoever it is, please come to the witness table. And then we'll do one more, and then we're going to have to call it a day, I'm afraid. Can I ask who you are? Sorry, it's Kelly McGrath. Oh, I've got you at the top. Yeah, thank you. All right, just go straight in for it. Right hand side.
Okay. Good afternoon. My name's Kerry Marchbank. I'm here as a resident, and while my concerns are far-reaching, I'm touching upon the noise aspects of the proposal. I live in Spitfire Way in Hamble, just around about 100 metres away from the proposed quarry site. I'm mother of 2 children, Harvey who's 13 and Emily who's 11. I moved to Hamble over 15 years ago, attracted to the charm and quality of life of the village. Like many young families, we stretched financially to buy a home here and have worked incredibly hard to stay, believing it would be a safe and peaceful place to raise our children. Yes, the traffic's always been a downside. With only one road in and one road out, delays can be frequent and unpredictable, but that's the one trade-off for everything else that Hamble gives us. Right now, we wake every morning to the sound of songbirds. We open the doors and windows to fresh air and the distant sounds of life on the river. I work from home, and that calm, natural environment is my daily backdrop. The quarry risks destroying all of that. Our quality of life will be replaced by the constant grind of heavy machinery and the dust from aggregate operations. I worry deeply for my children's health, growing up with polluted air, relentless noise, and no way to shut it out, not even in our home. No more windows open, no more enjoying the garden. The site would operate 6 days a week from 7 a.m. to 5 p.m. and until midday on Saturdays. That's persistent disruption. And multiply our experience by thousands of families every day for the next 15 years, a time frame that's been referred to often today as temporary. Well, it doesn't feel temporary to me. In all of this, have we been given proper reassurance that the noise will be effectively understood, assessed or controlled? In December, Eastleigh Borough Council noted that the applicant had not provided a robust assessment of the baseline noise conditions or demonstrated how noise would be minimised. You've already heard about the typography of the site today in its elevated position and ability for noise to travel long distances. But the routine daily operations will create a constant industrial background for 6 days a week, starting from 7 a.m. We'll hear evacuation machinery, heavy vehicle movements, loading operations, and reversing alarms. CMEX states that there will be temporary operations like bunk construction and soil stripping that could reach an average of 70 decibels. That's as loud as a vacuum cleaner running non-stop. According to national guidance, that's permitted only for 8 weeks per year per receptor. That's 8 weeks every year for 15 years. Can you imagine that in a school or home environment? On top of this, there's reversing alarms, which can reach over 100 decibels, with a high frequency tone that's particularly disruptive and can travel large distances. These alarms will sound repeatedly across 6 days a week every time a HGV moves or loads on site. We've been told that bunds will be used to help reduce the noise, but the council has already raised concerns that these may not be enough. Taller bunds will be needed, but they would be visually intrusive, so it's either a noise problem or a landscape problem, likely both. This is not minor, it's a failure to properly assess or mitigate real-world acoustic impact. This is one of the most sensitive, densely populated locations CMEX has proposed to operate, and yet all their assessment shows no meaningful engagement with local services or schools. In short, the measurements are theoretical and flawed, the mitigations seem incomplete, and the oversight mechanisms to ensure enforcement aren't in place. Then there's the emotional and financial toll. We all pay a premium to live in Hamble. Our mortgages reflect that. Our homes are where we've invested our savings, our security and our future. And this quarry risks turning a sought-after village into a place that people want to leave, not a place where people want to live. Who will be accountable for that? We're not just numbers on a planning document. We are families, neighbours, school children, key workers and pensioners. This village is our home. That this proposal has reached this stage, despite overwhelming concern from residents, schools, medical professionals and local authorities, is hard to understand. So I ask you, please look beyond the theory and the technical documents, listen to the people who live here and reject this proposal before it takes from Hamble what no restoration plan can ever give us back. Thank you.
I will be 6 minutes.
Timed it. Good. Off you go.
Yes, you can ask questions, and I am in opposition. My name is Georgie Baker, a regular visitor to Hamble since the mid-1990s and a proud permanent resident for the last 12 years. We've already heard about many of the important issues related to this quarry, but I thought I'd attempt to fully understand one issue only, and that is why the County Council have improved the mitigation in relation to improvements on Hamble Lane. I broke my investigations down into 4 components. The first should be simple. It was to understand the aim of the mitigation. Now, the aim of the mitigation is not to reduce the negative impacts of the quarry for the residents, but to help offset them. This is to be achieved by improving the walking and cycling facilities along Hamble Lane and easing access to public transport. This is intended to encourage a reduction in the level of use of vehicles whilst promoting sustainable transport modes. Now, I'm seriously not against sustainable goals here, and I'm a big public transport user. But where the proposals are to remove us as individuals from the road so as to allow the quarry trucks to fill those same roads, it seems an unfair apportionment of burden. However, we all know life is unfair, so I'll continue to my second point. Does the mitigation provide a practical solution to keep us off the roads? The majority of my journeys inside the village are on foot, or with some degree of disruption could be. Not the same for everyone, but that's for me. However, when I leave the village, I predominantly use my car, given public transport links are limited. As an example, I can't get to my doctor's or my regular supermarket in a reasonable time without driving. I've commuted to London daily for most of my working life and still do occasionally. Since moving to Hamble, I've always used my car for this and then Southampton Airport Parkway, as it provides me the quickest, most flexible and safest route. The train and bus would only have covered approximately 20% of my journeys outside the village in the last 3 months. I've asked a dozen or so friends, and many were lower than me and none above 40%. The train from Hamble only goes to Southampton and Portsmouth. There is only 1 per hour in each direction. If I'm going to London, I can't get to Waterloo before 9 a.m. And if returning in the evening, you'd have to leave Waterloo at 9 p.m. to make the last train connection. The bus, which is likely to be negatively affected by the quarry traffic, only goes to and from Southampton. It is a half-hourly service for most of the day until 7 p.m. and then far less regularly, with the last one leaving Southampton at 9 p.m. You can theoretically get to Waterloo in the morning earlier than the train at 8:20 a.m, but this may still not be early enough for many people travelling to work. You would have to leave Waterloo at 7:30 p.m. to get the last bus connection home. Journeys involving a train or bus from Hamble will therefore be far more complex, longer and less flexible, and I'd probably at times feel less safe. All evening events outside Hamble would become unavailable or at best severely curtailed. A daily commute to London would increase from approximately 4 to 6 hours, removing Hamble as a commuter location for those who want to retain any semblance of work-life balance. My question is, has there been any investigation as to whether the current public transport systems are suitable to keep us off the roads, and if so, can we see that analysis? My third goal was to understand the offered upgrades to Hamble Lane. In early 2024, in the Regulatory Committee reports, there was a table of costs covering the upgrade to 200 metres of pathway. In the agreed statement of common ground issued in November 2024, this had been increased to 4 areas, including through the allotments, totalling 741 metres of additional or improved pathways, plus other alterations, i.e. tree removal, new or improved crossings, etc. It referred to 4 diagrams stating that the proposed works were shown shaded in blue. My confusion arises here because the shaded blue areas are not in line with the description in words. There is no analysis of the practicalities of providing the solution or the time and disruption it will cause.
Could the inspector please help us understand how the County Council finds this offer acceptable without this clarity? Fourthly, I sought to understand whether the offer of £500,000 as mitigation would cover the costs. Now, £500,000 was initially quoted as providing 200 metres of pathway, but now covers 741, plus the alterations mentioned. When accepting the mitigations, the Mineral and Waste Planning team reproduced the original table of costs referencing 200 metres with no additional information about the increased scope, except to refer to evidence provided by the Highways team, giving costings of 4 other similar schemes. No scheme they identified matched this one, particularly in length, but I could see an average cost per metre of £2,242. Therefore, with 500,000, you could build 220 metres only, and with 740 metres, and the 740 metres we need would cost over 1.1 million. I cannot find any explanation as to how the same money could cover an approximately 3.7-fold increase in path length, plus the alterations, and I would request you, Mr. Normington, to help seek your support to understand these points. In summary, I failed to get clarity on any of the matters I investigated. There may be a simple explanation, but I haven't found it. As I mentioned, I'm not an expert, merely a concerned resident. But given that the County Council has reached the important conclusion to accept the mitigation, thereby withdrawing their final objection to the proposed quarry, I would ask you, Mr. Normington, to help us get clarity on these matters. Thank you in advance for your help.
All right, we've gone on farther than what I said. Actually, we've gone to 6 nearly now. I do apologise to those who haven't been able to speak today. We have a programme. We've gone way past that programme as well. There's not much more I can do. We can't go on all night. I'm afraid it's not fair to everyone, including people who's been here since 7 o'clock this morning. There is Friday for those who've not been able to speak today. I'm sure, Ms. Austin, you can have a chat with Amy about arrangements as to how an alternative means can be made for people who can't speak directly to the inquiry on Friday. I think that's as much as I can do other than to say leave it in your capable hands overnight and have a chat with Amy during the course of the next few days, whether that's by email or whatever means. And I will try to accommodate the people as much as we can on Friday. Then we are really in a pickle. We are in a pickle because we can't, as much as I want people to engage, we do have to be mindful that this is, and I've mentioned it, it's not a public meeting. Repetition is the key issue, and I've heard a lot this afternoon. I understand why you're saying it, but there has been a lot of repetition of similar issues cropping up. So what I said it earlier in my announcements, what I need to hear is the things that I've not heard or read before. So if you can just have a little think about that, and it really is ensuring that what I hear is punchy. It's not going over the things that I've heard time and time again over the last few hours. That's not criticising anyone. I understand fully why you're doing that. But if we can just have a think for Friday with a limited time, at best with probably an hour and a half. So please just have a little bit think about how we can edit things to ensure that we're not repeating things that we've already heard. The worst comes to the worst, you're going to have to direct me to the speaking note, provide me a speaking note as an inquiry document, and I can read it. And that's the worst. I'm sorry about that, but that's how the public inquiry runs, unfortunately. We are where we are. So please be mindful about Friday. Have a think about brevity. Have a chat with Amy about how best we can look at alternatives. Right, before you go, you're not going to just walk off, I'm afraid, until I've formally closed it. That concludes our business today. It's now 10 to 6. We resume tomorrow morning in this room at 9:30. The inquiry will take a completely different tone tomorrow because it will be technical witnesses sat there being cross-examined So there'll be no third party interaction other than questions of some witnesses on behalf of the appellant at an appropriate time. So tomorrow morning, it's just to confirm, without me getting, we're going to deal with Tony Clothier on behalf of the Rule 6 party in the morning. Then in the afternoon, it'll be Rachel Dewhurst and from the appellant. Then we'll move on to ecology matters, and it will be Richard Andrews on behalf of the Rule 6 party. So that's what we'll do tomorrow. So at some point, I will give an opportunity to ask any questions of Rachel Dewhurst to a limited extent, and I will control that. Just thinking about what I said earlier about those questions must be questions that are new, that's not been already asked by someone. With that in mind, I'm going to adjourn now, and we'll be back in this room tomorrow morning at 9:30. Thank you.